Welcome to this conference on Europe's digital agenda. Welcome to Bergen, especially for all of you who has traveled here. Welcome to our beautiful weather, which we've ordered especially for this conference, because this is quite exceptional for Bergen. This is a city where it rains 3 meters a year, and we've just had the wettest August in recorded history. So this is quite exceptional. Just enjoy it while you're here. We have a packed program, so I'm just going to give you some practical information on the streaming. We are streaming. Those of you who are presenting knows it, but for those of you who are in the audience, we are streaming and we're recording this conference. We are going to have 3 presentations in each sessions, and then we open for discussion and questions. You in the audience will get a microphone, so you could ask the questions. You who are attending online can write the questions in the chat, and then we will convey those to the panels if there is time. With that, I give the word to the Dean of our law school, Karl Søvig, who will open the conference.
Thanks for that, Torger, and welcome to Bergen and welcome to the Faculty of Law. I know that Torger and the others in the organizing committee has been working hard with the weather and dancing all these kind of strange dances in order to have this outcome that we have. I will say some words both about Bergen and the Faculty of Law. The law school was established in 1969. Now we have 2,500 students with a staff of around 120 of these 50 in permanent academic positions. You come from across Europe, and in Norway, the law degree is a 5 years integrated master's degree. And we also recently opened an LLM in EU and EEA law, but that's 20 students a year, and the kind of what we live off is the more than 2,000 master students from Norway, and we also have around 300 incoming law students from across Europe and the globe each year. We are among the top 3 institutions when it comes to applications for higher education. That's nationwide, and it regardless of discipline. And of course, I like to think that's because they have a very good dean here. But I realize that there are other driving factors. Law is an interesting subject, and the conference today indicates how interesting law is, because it's constantly developing. You have the old issues, and you have a lot of new issues, and you can do research on both. And it's important that law is not only looking backwards, and I think this conference is a good example of the law and its abilities to look ahead. So when it comes to the applications for higher education and for law schools in particular, I think it's partly, of course, due to the labor market and that it is possible to have a job when you have your degree, at least in Norway. When it comes to Bergen, the University of Bergen was established in 1946. And those coming from Europe would say that's a very young institution. So in order to improve our kind of historic credibility, we always add that the Bergen University of Bergen is building on the Bergen Museum, which was established in 1824. So we are celebrating next year our 200th anniversary. And that was an important institution at that time. If you have time, look at the museum's building, which was a really huge building. And that was important at that time to show by buildings how important science was. And we had prominent scholars like Fridtjof Nansen, who was a polar researcher and also known for other work when he received the Nobel Peace Prize. Moving to today's topic, I would just say, since we are in Bergen and it is this year, I would just like to mention we have this year the Jubilee of Magnus the lawmaker, which was making this national code of Norway in around for 750 years ago, 1274. So it is important Jubilee for Norway. And of course, I tried to find something about today's topic in this. There was nothing. But it was a kind of prominent work at that time because, well, it was not so common with this national legislation like this. And it was the second in the medieval time of Europe. And at that time, Bergen was also the capital of Bergen. The king had his castle here, and we can add that Bergen is still the capital of Norway, but now only in the kind of functional way. And this conference demonstrates that, because we are gathering here so many prominent scholars from Europe on a topic that is important, and I know that he didn't come to Bergen to listen to me, so I will say welcome once again to Bergen, and before leaving the floor, I would just say thank you to those organizing the conference, Torger, Lilia, and Bernt, and Thomas, because I know it is a lot of hard work, and I know you're also assisted by others sitting here with the red t-shirts. It takes a lot of work to organize a conference. So to all of you, thank you so much, and have a good day here in Bergen. Thank you.
We are going to discuss some complex issues regarding EU's digital regulations today, with 3 sessions on data, platform regulation, and artificial intelligence. To set the scene, so to speak, and to give us a more general overview, we have Martin Husovec. Martin is an associate professor at the London School of Economics and has written extensively on, among other things, the platform regulations in the CDSM, the DSA, and the DMA. With that, I give the floor to you, Martin.
Thank you so much. Good morning, everyone. So first of all, I'd like to thank the organizers for inviting me to the beautiful Bergen. I have to say, as I already joked, to appreciate this weather, we should have had at least a little bit of rain to begin with, so that we can really appreciate what we will have for the coming 3 days. And since I've heard that the beautiful weather is going to last until Sunday, it will be very difficult to really know what the real Bergen is. So hopefully next time I get a real pouring experience of Bergen. I'm incredibly delighted to be here today, and I think the task I was given is to introduce you to all these laws, which is probably not something easy if you look at the amount of stuff that the European Commission and the European legislature has produced over the last couple of years. I thought for a while if I zoom in on this slide, but I don't think there's any point really. I guess the main message is there's just a lot that has happened. And the title of the conference has a couple of different laws listed, but there, I think, few others that I would add to the list that are super important and were just adopted recently. So if you look at what is happening, and particularly at these laws that were adopted recently, that I think this conference is dedicated to, and maybe I would add a couple of others like the platform to business regulation. It's a curious selection of topics, right? And you could wonder why exactly these topics, why exactly this time. So one thing is clear, lawyers in Europe will be incredibly busy, are incredibly busy. From 2022, something has happened. I don't know, any guesses what has happened in 2022 that could have caused this? So one hypothesis I have is that Bernt Hugenholtz retired in 2021. So there could be several explanations for that. Not the retirement, but why they coincide. So there could be correlation or causation. Either could be that a Bernt retired because he has seen this coming. And I think that I think I could relate to. Or possibly Bernt was somehow always very important in holding off a lot of legislation, telling the EU legislature that they shouldn't legislate so much, which is not a possibility. Obviously, the third option would be that in 2019, we have installed a very passionate new commission that was very keen on legislating, and this coincided with the understanding that big tech, in particular, was for a very long time understood as a driving force for good, as something that brings a lot of opportunities, but at least from, I would say, probably migration crisis in Europe has also surfaced many problems, and those are experienced in different ways in different countries. They're experienced differently in Germany as they're experienced in my home country, Slovakia, because the size of the country makes a big difference if you're interacting with the providers. And I guess that's part of the story behind all of this legislation, I think, is that particularly for smaller countries, mid-sized countries, this is essentially the only way how to get the attention of the economic behemoths. So we end up with a flurry of new acts. I have no theory for why they're called acts. Maybe Bernt can help us there, but I have no idea why we switched to acts. Maybe it's supposed to be a little bit more grandiose than simply calling it a regulation. But clearly, this is a sea change for the European tech policy. Now, one of the problems I see going forward with so many different laws, and we'll look at maybe the rationale for these different laws, is the fact that inevitably this will create an effect of the Tower of Babel, and that is we will struggle understand each other. So I spent many years in IP. I think in IP, people already don't understand each other. Patent people with copyright people, that is a big divide. You know, talk to proportionality to patent people, you'll get really blank stares for most time. And I think you can easily imagine how this is going to make things even worse with respect to these new laws. So these laws are very often horizontal. They don't necessarily come from, particularly for lawyers, from specific domain. It's not private law, it's not public law, it's not one area of law. So there are different people looking at these different acts and seeing different things. And clearly within each of these acts, there's different logic. So I think we're definitely risking that, I don't know, people looking at a DSA will not appreciate the impact of the AI Act, or people looking at a Data Act will not appreciate what the DSA has to do there, et cetera, et cetera. So I think this is a big problem going forward. DMA already you can already see the clustering of scholars, where DMA, for instance, is something that attracts mostly competition scholars. Although there's no particular reason for that, I think commercial lawyers broadly should be interested. DSA is a special beast. It is attracting lawyers from different sides. So I think this will be a challenge. Now, I started thinking about these different laws, and I started thinking about how to organize them for my own purposes in terms of, and I came up with these two different axes. So one is how horizontal or specific the law is. By which I want to say to what extent the law is really setting out some foundation for maybe broader area of regulation. And I think in this respect, clearly, I think the DSA, AI Act, and the Data Act are probably the most horizontal. DSA in particular, because it essentially, although it regulates, I always say, only user-generated content services, those are the main services on the internet. Basically, most people are interested in talking to other people, which is why most of the services are UGC services, which is why most of the services that we regulate through DSA is basically, it's the whole internet. So DSA really has this potential to become integrating, and we can already see it. One of the driving forces, for instance, behind challenging DSA designations as very large online platforms is the fact that other laws started using the same term for its own purposes. for political advertising, for media freedom, and for all sorts of other things, where basically this designation has become a stamp of you are big enough for us to really regulate you. I think AI Act is probably in the same in the same range, and the Data Act as well. On the other hand of the spectrum, I think you would have laws like DSM, so the Copyright DSM Directive, and DMA, which are probably very specific. So DSM obviously deals with copyright issues, but I would say for most part, with some exceptions, basically deals with very sectorial issues. DMA is the same, although it's about gatekeepers. I think it's rather a sectorial approach. It's a specific set of services that we are trying to tackle. So it's not as future-proof as, say, DSA or AI Act likely are. As the ecosystem changes, I think DMA needs much more update than the DSA. Now, another way how you can look at these different laws is look at them on the axis of what are they doing with the harmonization? Why are they doing the harmonization? And I think here you could maybe sort of distinguish two rationales. One is we're harmonizing because it's a good idea, because we reduce the barriers to entry for the market entrants, and that in itself will increase hopefully competition, because it will be easier for the firms to enter the market. And I think clearly DSM at least arguably tried to do that. DSA, MP2B regulation, platform to business regulation are certainly trying to do that, essentially making the environment much more uniform, much more unified across the whole continent. On the other hand, then we have also laws that are arguably much more about supporting innovation. And this will be the additional big rationale, maybe the big rationale for the next commission, and that is how to incentivize more innovation, not necessarily through IP means, as IP lawyers tend to be biased for this sort of toolkit, but through other means. And in case of Data Act and Data Governance Act is by essentially opening up a resource for innovation. Now, whether things will really always work out this way, it's questionable. I would say, for instance, that a DSM directive, if you look at its implementation after years, has done actually the opposite of harmonizing and reducing the barriers to entry. Christina Angelopoulos has done a quite extensive study of implementation of just 2 articles, and what you basically find is an utter mess in the member states, where basically there's nothing that is uniform across the member states. So at that point, you can question whether it has really any harmonizing value, and if member states left to do their own devices wouldn't actually reach a better outcome in some cases. So it's not always guaranteed that with the goal of harmonizing, we actually end up with harmonization. I think DSM is a perfect example for some of its provisions. So let me tackle these 2 rationales, and then let me take a step back to look at what I think are some of the connecting threads for these different laws. So in terms of rationales, as I said, one of the rationales for many of these laws is reducing the barriers to entry for the different market participants, but also for individuals when they're trying to derive rights from different legal relationships in which they find themselves. So I think this is quite obvious with the DSA, Digital Services Act, which is essentially unifying how providers of digital services deal with their users, and how and those users could be as well as consumers as well as businesses. And we're doing it, and I think this is quite novel and not appreciated, particularly from looking from across the pond in the United States, is that we're actually doing it not just for companies that are based in Europe, but we're doing it for everyone. So pre-DSA, the story was EU does not regulate mostly these services, which means member states to some limited extent could regulate these services. And the only thing that you would really have is the country of origin principle to somehow allow you to pick some legislation that applies to these services, but it then only apply to the EU-based services. In other words, if you wanted to operate in the European market before, you were basically left to 27 plus national laws to operate in. And one of the focus very often on when you look at laws like DSA is, oh, this is regulation. But I don't think we're always appreciating that this is regulation that actually has replaced 27 different regulations, often regulations that could have been much more far-reaching, number one. And for non-Europeans in particular, so companies that don't have any establishment, we have literally unified the rules, which before you couldn't even benefit from the country of origin principle. So there's incredible lowering of the market barriers for the providers themselves that want to comply with the DSA. Not to mention, obviously, for the users of these services, who now can essentially enjoy the same rights, regardless of whether they're using a German marketplace or French marketplace or, I don't know, American marketplace that is targeting Europeans. So I think that's a huge difference. And clearly, it's one of the things that harmonization should be doing, right? So one thing I would say with this rationale of harmonizing to reduce the barriers to entry, we should always keep also in mind that we should be comparing it to the world that could be, and that the world that could be is essentially chaos with plenty of national legislation. The fact that we didn't regulate for 20 years could be explained through all sorts of, or 15 years, could be explained through all sorts of rationales, but that's not how the world had to look like. So we could have easily had many national rules in this space where the tech companies would be happy to have one set of rules because they would understand that now they're saving. So I think that's just an important sort of, the point where you start is always very important when you're trying to understand the added value. I think with a DSM, it's perhaps a little bit more different story, where with a DSM, copyright DSM directive, particularly, of course, DSM is about a number of issues. Some of them are really harmonized, but particularly for the two, they were really controversial. The press publishers, right, and the video sharing platforms. I mean, this is clearly a story where there wasn't even a national experimentation. Of course, press publishers is a little bit of a different example. And yet we decided to adopt European rules because we thought that a national solution was ineffective, wasn't really solving the problem. So for the press publishers, right, obviously the story was that Germans going on their own, Spaniards going on their own is not sufficient. So we need a European solution so that a big tech gets serious. Probably is true, probably has worked out because the companies are now paying and they cannot do the same thing. So that's probably true. And the same logic also underpins the DSA again. Smaller member states couldn't really enforce many things vis-a-vis the platforms because they wouldn't care. So I think that probably has a value. But I think it also introduces the problem that if you cannot agree properly on the shape of harmonization, you end up basically in a mess. And I think this is where we ended up with many provisions of the DSM. That's the big footnote here. The AI Act is a unique in that sense because it's kind of a marriage of AI hype with the genuine problem of regulating AI products when they're offered in the European market. And I guess with the AI Act, there are tons of things we could discuss, but I think as one of the big issues with the AI Act going ahead will be, and again, this is linked to the rationale of reducing barriers to entry, will be to what extent the reliance on the harmonization, technical harmonization is actually a good model in this area. Because technical harmonization has many issues of its own in terms of legitimacy, in terms of the actual outcomes of the harmonization. So we'll have to see. So in any case, DSA, DMA, and AI Act, I think, are much more about this. Now, when we look at the data-related acts, I think the rationale there is much more about actually supporting the innovation ecosystem. So it's quite visible with the Data Act, where the aim is to open up some data, particularly IoT-linked data, for the reuse by third party, whether businesses or individuals, or Data Governance Act, where it's about certain types of data sharing. So in both cases, I think the rationale clearly is, when we look at the digital agenda, is let's open up the data to unlock this hidden potential that could improve our productivity in many different domains. I think that's clearly the story. I think this is how the Commission is also now thinking about it. Of course, the big question mark with these laws is whether they will work. But I don't think they are so special in the sense that it's not a first time that we're certainly regulating for the sake of opening up some infrastructures for to spur innovation in a particular area. So DMA obviously is a kind of a mixed beast, Digital Markets Act, which is about regulating gatekeepers and regulating access to their services, including potentially data sharing, interoperability, and regulating certain practices. I think with a DMA also, clearly the story is that partly we want these services to be more contestable. Hence, in the long run, we want more competition. But to some extent, we realize we have to live with these gatekeepers. And if we have to live with them, perhaps at least we could have a fair ecosystem for how these businesses build their own businesses on top. So app stores, how you build your own business as a developer within app stores. What's the fair allocation of value? What are the fair practices? I think clearly there's a rationale that in the long run this can also support innovation, but I think in the focus is much more on contestability and fairness in terms of competitiveness. Now, if I try to think about a commonality, so those are kind of the rationales, but now then I wanted to accept the challenge of finding some commonalities in these different laws, and which is one of the subtitles of the conference. And obviously, two commonalities immediately came to mind, probably not the ones that you were looking for. One is that these laws are very often quite difficult to read side by side because they were just written by different teams. And what is even more striking, they were written by different teams of people who never talked to each other. And this is not something I made up. This is real thing. So if you talk to people from the commission, I don't know, people who work on DSA, they amount of contact with the people doing DMA is limited, but their contact with people who are doing Data Act, is even more limited. They maybe haven't even talked. So these laws do not always speak the same language. They are really written sometimes not necessarily taking account of each other. I mean, the only reason why you find cross references is because whenever there's, I don't know, a reference to something that a DSA does, the DSA team will have to opine on that issue, so they will eventually have to come to certain synchronization. But that is a very different thing from thinking about the problems of your neighbor from the get-go, right? From the very beginning. That's a very different situation. So inevitably we'll have this problem, and we partly already have this problem if you think about this. A lot of data legislation about innovation is preconditioned on this idea that you can unlock data because you're not restrained by data protection law. So GDPR is the big, sword of Damocles, sort of hanging over this legislation. But if you look at a GDPR and how GDPR is evolving, the notion of personal data is basically creeping into everything. So that really makes you question to what extent this legislation that is sometimes preconditioned on either entirely working with the concept of non-personal data, which likely will be emptied by the data protection law in the long run, or is preconditioned on the idea that they can find harmony with the GDPR, is actually something that is running into a serious problem in the long run. And there's no interest in opening up because GDPR is a world of its own. So speaking of Tower of Babel, we already have that. So I remember when the Data Act was proposed, and I still try to care about Data Act. Obviously, then I was completely sidelined by the DSA, but and we made a couple of proposals with a colleague, and one proposal was that we should limit the use of data portability rule in the GDPR. So in GDPR, there's a possibility to port your data, personal data, as an individual, and we wanted to limit it in case the one who wants to port the data is the gatekeeper, so someone with a significant market power. And to my biggest surprise, we were attacked by data protection people for trying to weaken the GDPR. I was like, but I'm trying to limit the use by big tech so they don't multiply the data and don't take advantage. Still, I was trying to tinker with GDPR. So I think we're seriously running into this problem, and I'm not sure how to resolve this, but I think we already have it with data protection law, I'm afraid. Second example is, second commonality technical is incredible inflation of recitals and the way that EU legislation is written. I mean, this is just, I don't know, I still cannot accept this, that sometimes recitals are longer than the law itself, and that every single article needs a recital, and that every single political agreement that doesn't make it into the legal text tries to make it to the recitals. And then there's these endless debates about what that means, what that really means in practice. I'm really doubting that recitals are actually helping us if they are adopted in this way. in the long run, because so much confusion is introduced by recitals. So many failed ambitions of the legislature are buried in the recitals. Not sure what to do about that, but I'm just observing here. Okay, so let's try to find some commonalities in terms of the real stuff. What is this legislation predicated on? Can we say there's something common about this? And I think there is something common about these different pieces of legislation. And I would summarize it as these two issues, which I'll then try to explain in turn. So first, I think one big idea behind a lot of this legislation is that the legislation is adopted to empower the state, businesses, or individuals at the expense of usually big business. I don't want to just call it big tech because it's not always big tech only, but trying to empower the state, businesses, and individuals at the expense of big tech by providing them with certain legal tools and mechanisms. I'll explain that. Second one that I think is a connecting issue here is that a lot of this legislation actually tries to enhance trust of individuals by creating either optional or mandatory institutions around certain interactions that individuals engage in. Usually this is by giving them something that allows them to take more control of their environment. So this sounds even more esoteric. I try to explain it. So let me take the first one, empowerment. And this is something I've spent a lot of time thinking about. I mean, one way how to think about empowerment is to taking the control back, which is, you know, a little bit tainted slogan by this big political campaign to take back control in the UK, which ended up with taking back control and not much else. But it's really about that. If you think about what the legislation is really trying to do, I think it's really about that. So the way I'm trying to think about the DSA, for instance, and I think it can really apply to other laws as well, as I tried to show you, is the following. So we live in a world where basically in the last 15 years, the private power, by which I mean mostly big business, accumulated a lot of power over the individuals, and sometimes over the individuals, and in addition, sometimes accumulated that power also at the expense of the state. So in a way, weakened the state. Why? Because partly these economic actors became incredibly wealthy, so much that their market capitalization would dwarf GDPs of some countries, but also because they gain certain control sort of tools through technology that allows them to control the individuals or maybe enforce certain rules against individuals in settings where the state wasn't even present before, right? Because we didn't have a state in our pockets, so to say, right? But if you have the market player who is very powerful in your pocket, then they can control many of your interactions more than the state. So I would say the story is that the gravitational pull of technology, so the fact that we use more and more technology, allows the market players to control more. And in addition to that, if that is coupled with the market power, that allows them to essentially be sometimes stronger or equals even to the state in some settings. I always say YouTube can still not put your kids into jail, so it's still not comparable. But they are incredibly powerful. So how you can think about the regulation like DSA, you can think about it as redistribution of the power. And you could imagine legislation that would be purely about the transfer of power from the private entities to the state, which would be literally, you're doing this, now we want to be doing this, right? So if, I don't know, the government passed legislation saying we decide about everything that should be prohibited on your services, this would be typically distributing the power to the state. I don't think that the legislation we have adopted in EU is that. And I'm thankful for that, because essentially redistributing the power from the private actors to the state essentially only creates a new concentration problem. And this time around, it's a problem of concentrating power with the state. So I think the way I'm looking at a DSA is essentially redistributing the power by trying to bring the part of the control back to the state, but also trying to bring more power to the individual. And this is what I mean when I say empowerment. So essentially introducing legislation to empower the individual to be able to enforce certain things against, well, state or the private power, which they weren't able to do before because the only thing they were relying on are some voluntary arrangements. So this is how I think about a DSA. If DSA gives you procedural rights to content moderation, it's something that constrains private power, but also constrains state to a certain extent through transparency and other means. Of course, it's also trying to empower the state. Unfortunately, there's no way around it. If you want to introduce regulation, you'll end up with empowering the state. And sometimes we need to empower the state because it's very difficult to enforce rules if the state is powerless. And again, it's enough to look at a situation of smaller or even mid-sized member state in the last 15 years. They weren't basically able to enforce much on many of these services. If you look at other legislation like DMA, I think the same story can be illustrated here. So again, you have private actors accumulate a lot of power, aka gatekeepers, like app stores and similar players. They accumulate a lot of power. Of course, that allows them to behave as hegemons, and that allows them to kick apps if they don't like them, to regulate what types of apps they like, how much they want to charge, and all of this. And because they're living in an oligopoly market, they have a lot of sway over the whole ecosystem. And again, there comes regulation of DMA that weakens their power by basically telling them, okay, you need to have competitors because we need to allow sideloading of apps. So you won't be the only marketplace out there, even if you own the ecosystem. Or you need to be fair when you deal with your app developers, because this is how you can behave and this is how you cannot behave. So again, I think this is something that is not only done to empower the state in this case, again, although the state is gaining some power, but it's done to empower the business users, in particular in this case, the developers of apps. And developers of apps are now able to basically use all kinds of claims and have expectations of fairness vis-a-vis these players, which before didn't essentially exist for most part, because competition law was quite limited in what it could give to them. And you can also run the same story with the Data Act and Data Governance Act. Well, sometimes where the state is getting access to the private data, but also usually the main situation here being we're opening up some data silos for potential reuse by individuals or business users. So other market entrants, competitors, or individuals themselves are able to take advantage of this data and hopefully will use them in ways that either are helpful for competition or innovation. So I think you can clearly tell the story, particularly against the trends like the end of ownership that some people have been writing about. This idea that through everything being a service, we're losing a control, and giving users back the control over data is a way how you basically make them to control the thing that they're buying eventually more. So I think this story can be quite convincingly told about all of these things. Sometimes you can hear that this allegedly brings some paradoxes. So one of my favorite is that is one that detractors of both DSA and DMA particularly of DMA tend to use. They say, isn't it strange that Europe is trying to weaken Apple when it comes to app stores, yet Apple is crucial in assuring safety on App Store, and safety is what Europe is asking for in the DSA. So how can you ask for more safety, yet weaken the one who is the guarantor of safety? Isn't that actually a nonsense? Isn't that contradictory? And I think actually it isn't contradictory at all. It just means that you didn't understand what the EU is trying to do. Because what the EU is trying to do, and you can clearly nicely explain it if you take the thinking of order liberalists in a post-war Germany, who are basically always worried about not only the state power but also the private power. And the basic idea was that yes, the market is disciplined well through competition and other competitors, but sometimes that fails. And when that fails, the only way you can protect against that potential abuse is through regulation. So what the story of App Store really is that you have a oligopolist who is incredibly strong. So, and instead of relying on its benevolence when it comes to protecting safety of the users or app developers, we basically try to weaken that oligopolist, but at the same time install minimum governmental rules for that safety and the expectations of safety that we have. So essentially we weaken, but at the same time introduce minimum requirements for everyone that is in this market. So to me, that's completely consistent. I don't see any consistency there. It makes a lot of sense. And I think it just shows that there's essentially a belief that the market mechanism wasn't sufficient to discipline this particular type of private power. And yes, there were some good byproduct, but it doesn't mean that we couldn't reach safety through other means. And I think this is then what the regulation tries to do. And you find it in recitals like recital 5 of DMA, where basically there's a reference to that. So the laws like DSA are then just that, our response to a failure of the market mechanism to develop certain safeguards. And we are reintroducing them by regulation, while at the same time we're trying to weaken the actors who are potentially subject to these tools. So I would just say to those who often think about the regulation and EU regulation and just think of it as another red tape, is to actually sometimes challenge and think whether what they're looking at isn't actually more, and isn't sometimes, actually very often with these laws, in particular, some kind of a new control toolkit for individuals. So essentially new rights for businesses and individuals that they didn't have before. So regulation, that's from the side of the companies, but that regulation from the side of the individuals is actually something much more aspirational and empowering. So I don't want to go too deep into this since I'm running out of time, but I mentioned this because there's this bigger debate, and new commissions clearly will be involved in this. And this is a debate about whether the regulation that we have isn't holding us back. And we have the keen big tech that is trying to not introduce certain new services in the EU because the thinking is that the regulation is basically slowing down the rollout, although in reality, they always rolled out the services in the US and the UK first and then went to other countries, although there's some legitimate worries there. I think it's important to distinguish regulation and regulation. I think clearly, as Anna Bradford tries to say, it's a false dichotomy to think about regulation as a kind of anti-innovation. In fact, all the innovation scholars will tell you innovation, it's also about direction of innovation. And arguably what the EU is trying to do is trying to influence the direction of innovation and the allocation of the value when the innovation occurs. And particularly there's a keen interest in obviously emulating the US, because the US has been so successful with its consumer tech. Where I'm always keen on reminding Mariana Mazzucato's work. Mariana Mazzucato has written this beautiful book trying to look at the rise of the US tech industry. And she essentially makes the point that the state was incredibly important in the process by giving all kinds of money, loans, and everything to the companies. And she has this beautiful line where she says, look, if you want to emulate the US model, you need to do as the US does, not as the US citizens say it does. Because the ideology of how the US got where it is very different, or the public opinion is very different from what it actually has done in terms of supporting innovation ecosystem, meaning there's much more public investment, public hand, than you would think from the sort of glorification of the private actors that is the main theme when you look at the ecosystem. So that's just a kind of a side note. I think Europe is very likely to go in this direction. Already the previous commission has done quite a lot of work on innovation and trying to also push some money, and we are clearly heading into the direction of industrial policy. Okay. 1 minute. So my last point. I think the second connecting tissue here is trust. And I think the one of the problems that the EU is clearly trying to bridge and address is the problem of distrust. So if you look at these different instruments, you can clearly see how content moderation practices might be plagued by distrust, because you're not trusting why certain things are happening, who is causing them, what's the basis. Same with the gatekeepers. Why am I suspended? Why I'm not able to monetize? Why am I prohibited from advertising certain things? Sharing of data. Why I'm not able to port certain things? Employing AI tools. I mean, I don't even have to give you examples. So there's clearly a problem that I think the legislation is trying to address, and that is to increase the trust of citizens or business users in the different things that they encounter, whether that's content moderation or business practices. So I think, again, I can illustrate it best on DSA, where I spend the most time, where I think you can clearly say that DSA's ambition is essentially turn the opacity and arbitrariness of the system that decides about the content moderation into something that is much more transparent and fair. It's not going to be 100% 100% good. Nothing is, including our judicial systems. But hopefully it's going to be more predictable, transparent, and fair, and that hence more legitimate. Similarly, you could say that the current problem with the amount of decision making that is done on the content by the providers themselves centrally, as opposed to perhaps individually by users, is also breeding certain mistrust. Why should I accept opinions of Facebook on certain issues where I would like to have my own opinions about what I want to see or not see? Obviously, if we're talking about lawful content, not illegal content. So I think we have a similar story with the DMA, where there's a problem of trust between the big tech and the app developers and other business users. So clearly, this is something that we can see in also other legislation. Data legislation is also trying to create institutions to increase this trust, so the users eventually use certain tools. I just want to end with a word of caution at the end, and that is that all of this, I think, is super important, and I'm certainly behind the goal. I think empowering individual and business users is a way forward. The problem is that on the way, we're also empowering the state, and we need to be cautious about this, because empowering the state means obviously that we can run into all kinds of problems. I don't have time to go into examples, but these two men, in very different ways, and let me make that clear, represent that potential of abuse of some of these tools. And I think the only way out is to design this legislation. And I think some of the legislation is designed this way. Other legislation could basically hopefully be improved in the future, is by essentially having as a main check a contestation of these three different powers that I use in my triangle. So the state, private actors, and the individuals. And some of the tools do it better. I think the DSA does it quite well, although some tools are missing, but only through the contestation of each other, essentially, as in this Spider-Man meme, where essentially it wasn't me who abused the power, it was my neighbor. That's the only way you can keep everything in check, is where basically when everyone can blame everyone for everything, and then courts have to somehow deal with that. That's the only way to negotiate this triangle. And we should think about it, I think, going forward. Thank you for your attention.
Thank you, Martin, for this really nice introduction to the topic. Unfortunately, we have a quite full program, so we'll take questions to Martin and engage with Martin also during our panel discussions, which will be after each session. My name is Lilia Opresk. I'm associate professor here at the Faculty of Law, researching mostly IP and IT law. And before we start our first panel, I was tasked with some practical details. For you, basically, the restrooms are here to the right, so for those who are attending physically. And before we start, I would just like to remind you that online audience can ask questions in the chat. We have over 50 participants online, and those physically, you will get a microphone when we have the panel discussion. But now we will have 3 speakers. We will have a coffee break after the second speaker, and then we will continue with the panel afterwards. And the name of the panel is Fostering the European Data Economy. There have been a lot of initiatives and a lot of instruments basically introduced in the EU. So we'll have an introduction from our speakers, and then during the panel discussion, we will try to find some common themes, see how they can work together or maybe not work together, as Martin already been basically talking about it a little bit. And our first speaker is Heather Broomfield. Heather is the Senior Policy Advisor at the Norwegian Digitalization Agency, but she combines her work with a PhD fellowship research in responsible data-driven government at the University of Oslo. Heather has worked extensively on both sharing and the use of data, with a particular focus on AI, and has been a member of Norway's Law Commission for Data Sharing, the Council of Europe ad hoc committees, and other committees under the OECD, for instance. So welcome, Heather.
Thank you. Thank you. It's really lovely to be here today. And in case you're doubting this weather, I cannot remember in the last month or two where I haven't left the house with my coat. And this is the very first day. So you're all very, very lucky to be here. Okay, so I'm talking to you particularly about public sector data sharing. And as Lilia was mentioned, I'm I'm not just coming at this from a legal perspective, but coming also from a policy and a practitioner perspective, because I've worked with this area on the ground for many, many years now. And so I'm tracing kind of how far we've come, and also taking a look back about where we started with all of this. So, you know, Martin's done a very good job on showing you all about how central this is to European policy. But like, this is just to trace it back. And this, you know, the new commission was so into data and artificial intelligence. Back in 2019, von der Leyen was very, very clear on that. And we see there is no dying down, if probably particularly a ramping up of this with the new commission, where they want this data revolution. Now, they're still saying we need a data revolution. We're still not there yet, despite this being policy for quite some time. And of course, now they're also talking about a European data union strategy. And this, as Martin has been talking about, this is all about innovation. This is about the economy. This is about, you know, the European data economy. And of course, we are constantly told about all of these figures of what we're actually aiming towards. Now, I just want to bring you back to kind of the development or the evolution of these laws and where we're at in Europe, and also put it into the policy context. So it was actually, this all started actually back in the 70s, that public sector needed to share data, needed to share information. And this was all about this level playing field between the public and the private sector. And that's a very important point, because part of the history of this was that the public sector, in a way, competed with the private sector. They used their own data, their own information, built services and sold them on the market. So it was about stopping that, but it was also about this level playing field in the economy within the private sector as well, that the small guys, we should stimulate innovation, we should stimulate startups. And the way to do that was part of the way to do that was, of course, sharing the vast amounts of information and data that the public sector holds. And this level playing field. But it took, so that the first guidelines we actually ever got on that was 1989. It took nearly 10 years before we got the green paper on PSI, before there was any more intervention. 2002, then we got the EU-Europe 2002, which is about creating the framework and public sector information, or PSI as it's known in Europe, and I'm going to come back to that as well, started to become a little bit higher on the agenda. And we got the first directive in 2003, a weak directive, but certainly it's a start. Now, part of this, and I really want to emphasize the importance of the open data movement. The open data movement was actually initiated by open data activists or openness activists in 2010 as a reaction to the economic crash, the international economic crash. Why? Because of openness and transparency, because of the lack of trust, or the failure in trust in governments. So a group of open data activists started this movement. It was championed by Barack Obama, it was championed by David Cameron, and it was championed by Gordon Brown and many, many others, of the importance for getting data out. This, though, open data is rooted in openness and transparency. That is the main goal of open data, right? So the EU, there's a tension here, because the EU's goal is fundamentally economic. The open data movement was about openness and transparency. But this impetus for open data created the impetus also behind public sector information and getting data shared. And really boosted public sector information, or PSI, in Europe as well, and getting that higher on the policy domain in Europe. So in 2014, then we started to see this data-driven economy. We need this data-driven economy. 2017, we got another data economy communication. Then in 2019, and Martin's already been in on this as well, is we got the Open Data Directive. Now notice the difference here. We've gone from PSI to open data, okay? But we're still grounded in the single market. But it's been renamed Open Data because the movement has really popularized open data. 2020, on the same day, we get the AI white paper and the EU data strategy, as Martin has been in on, written by different DGs, launched on the same day. And then we got the Data Governance Act and the HVD Implementing Act then in 2002, 2003, respectively. And we're not to forget, along with all of this, we have the common data spaces, which of course the DGA is giving the horizontal or the main regulation for, but there is also further regulation in under each of those data spaces. We've Horizon Europe and Digital Europe programme, as already been said, trying to stimulate innovation. This is not just about the law. We need other incentives to get this innovation. So more has happened in the past 4 years in this area than the previous 4 decades. You know, this is big stuff here in Europe. So just to contextualize it a little bit, to give the Norwegian context of all this, of how important this actually is at government level. Norway has a vast amounts of data on the population, and actually Nordic countries in general have vast amounts of data. This is seen as so important by the Norwegian government that it's supposed to match the oil income and take over from the oil income in Norway by 2030. That is, you know, that is fundamentally the goal. Data sharing in line with the EU has now become very mainstreamed in the Norwegian digitalization strategies, and seen as, of course, huge for artificial intelligence as well. Torger and I were lucky enough, or honoured enough, I must say, to be on a law commission which just delivered now before summer, on particularly this issue, how Norway can legislate and regulate for, and of course transpose both the Open Data Directive and the Data Governance Act from a holistic perspective, from the Norwegian perspective, to try to also work to stimulate this innovation. Now, possibly everybody in the room knows the ODD and the DGA, so I was a bit reluctant, shall I give a little bit of an overview or not? But I said I will, because just in case. Now, the most important thing with the Open Data Directive is to know what it's actually regulating. What it is regulating is data, which government data. So open data is not necessarily just government data either, and that has to be remembered too. Open data can be also from the private sector. So this is data that's generally understood to denote data in open formats that can be freely used, reused, and shared by anyone. Okay, so under open licenses, etc. Very, very different to the type of data that's to be shared under Pillar 1 in Data Governance Act, and I'll come back to that. So the point is that it's an open format. There's practical arrangements for it. So every country in the member states has an open data portal, for example, that encourages open by design and open by default, meaning that when data is created, it should be created with the theory behind it that it should be ready to be opened up for others to use. Public undertakings and publicly funded research are now in scope. And dynamic data, when it is made available, there is no obviously obligation to share dynamic data, but when it is made available, needs to be done in real time and via APIs. There's a prevention of exclusive arrangements. This is nothing new. This also came in the PSI directive, but there's a strengthening of that within the ODD. And licensing shall not be subject to conditions, and they should ensure use of standard licenses. What are these standard licenses? Generally, this is Creative Commons. Our NOU, or our reports from the Law Commission, we recommend Creative Commons, obviously, and we also recommend Creative Commons zero where possible. And that will replace the Norwegian law on that, or license. Now, free reuse is a principle. So that data must be opened free of charge is a principle of the Open Data Directive, and it always has been right from the start. And this goes back to the level playing field for the private sector, because charges are deemed to be an entry barrier for both startups and SMEs. So your big companies are well able to pay for this data and are quite happy to pay for this data. But this means that, of course, the innovators can't access this data because they simply can't afford it. So this is trying to balance this out. Now, there are exceptions to this called marginal costs, and there are other exceptions as well, because there's basically exceptions to very much in the Open Data Directive. Now, I want to go back just a little bit to what I pointed out about the open data movement and this confusion between open data and public sector information. There has always been a confusion in the Public Sector Information Directive around freedom of information or access to information and public sector information as an economic instrument. And that is deemed to come from the definition of reuse, which includes both commercial and non-commercial use. Okay, so this confusion has always been there. It's been there in the member states, and was actually, when Janssen first wrote about this, she said it was actually an advantage in a way that freedom of information was included, because many member states argued for more data sharing for openness and transparency. But there was a confusion in member states because many didn't particularly understand that this was purely an economic instrument, and is only obviously the EU does not have competence around openness and transparency or freedom of information. So I've written a paper on this where I'm saying basically that the renaming of this to the Open Data Directive and increasing references to open data are unlikely to mitigate this confusion. Thanks. And references to citizen participation and openness and transparency are really likely to be window dressing in this, and member states need to take this into consideration when transposing and working with both the ODD and the DGA. And one of the things I'm probably most proud of that we managed to make in our law commission is I think we've managed to strike that balance in Norway between that freedom of information and making sure that the economic interests don't dominate the sharing of information, that we try to get a balance here between openness and transparency and the sharing of data for the data economy. So the Data Governance Act, just very, very quickly, because I'm sure you're all very au fait with this. It's only really the reuse, the pillar 1 that I'm talking about here. And of course, the European Data Innovation Board is also very important part of this as well. And Martin showed the Kaizener, you showed the Kaizener's overview of the data. And there's also another slide on that where he shows all the different boards and agencies that need to be set up as well. So take a look at that too. And the European Data Innovation Board is, of course, yet another one. So the Data Governance Act, public bodies, there's no requirement to share data in the Data Governance Act. It's completely voluntary. It must, but when, of course, when public organizations share, it has to be shared on the same basis with everybody else. There needs to be very clear conditions for reuse. Obligations can be set, such as using secure processing environments or attending the physical premises to get access to the data. And all data needs to be registered on single information points. There are also, again, new bodies. We see new bodies, new agencies, new boards in all of these laws, and the competent bodies for the Data Governance Act is about supporting, legally and technically supporting public bodies in the sharing of public sector data. One which kind of goes under the radar a little bit, but is actually a very important step from the EU, is the High Value Data Sets Implementing Act. It stems from the Open Data Directive, but this is actually the first time that Europe orders or that all member states must share specific data. It's no longer just open up what you can, et cetera, et cetera. These are specific data sets. It also makes the mark that we've moved from this situation where, oh, just get the data out there, all data is similarly valuable, it doesn't really matter, to actually admitting and realizing as the data economy matures, some data is more valuable than others, right? So these are the specific categories, and these are all to be made available under certain conditions, such as free of charge and machine readable, etc. So it does go under the radar, but it is an important step, and this will be built upon over time, seemingly. Okay, so just to conclude, kind of to try and reflect, well, are we there yet? I would say everything is relative, and when we put this into the historical perspective of data sharing in Europe, it's certainly come a long way. Now, I've quoted myself here, but the fact is that the reuse of regulation, reuse of PSI was a hugely nerdy domain, and I'm a card-carrying public sector data sharing nerd. I can assure you it was a very, very small domain on the outskirts of everything that was happening in Europe. Certainly wasn't mainstream, certainly wasn't up there in the top, and some specialist domain. But now it is really taking a central position in policy discourse. It is a very important arsenal in the weapons for the data-driven economy. And needs more. We need to paying more attention to this. There's minimal research on public sector data sharing, so we need more. But it certainly has come a long way. What's been learned? Some data is more valuable than others. it's not, no, you know, we would do need to prioritize, and that is something as well that we recognized in the Law Commission report that we did. I would question whether there is a level playing field, whether we have a level playing field yet within the private sector on this. And I think it's a lot more than just giving out free data. There needs to be a lot more incentives. And the question is, who is actually benefiting from this free data? Is it the startups and the entrepreneurs, or is it still big tech and the large organizations? How open data can be misused deserves proper deliberation. And Martin, you were kind of in on this a little bit as well, and because open data can be misused with tech, with AI. When we put together vast amounts of data sets, this can be misused. And this kind of, before we were very kind of, oh, just get it out there. This is all safe. This is all fine. Whereas now we actually need to have proper deliberation on this, both at member state level and at European level, that we probably haven't had. Now, this isn't to say that this should give an excuse to every public sector body that they can just say, oh no, we're just so worried this is going to be put together with other data sets and it's going to be misused. That's not good enough. We need proper consideration of actually what the risks are here. I think there needs to be big questions asked, possibly mostly at the member state level, whether PSI is overshadowing freedom of information. And if we think about the criteria that was used for high value data sets, for example, that was very much economic criteria rather than societal criteria or openness and transparency. Data sharing is expensive. Data sharing is hard work. Data sharing is on the side of the main core functions of public sector organizations. If we're going to do this and going to do this properly, we must invest and have proper policies around this. And it's not enough just with laws to tell us to do this. There needs to be other supports around this. So thank you very much.
Thank you, Heather. And now moving on from public sector information to the private sector information. Our next speaker is Lucie Antoine. Lucie is currently a postdoc at Ludwig Maximilian University in Munich. Her research focuses on classic IP and IT law, as well as data law and data protection. And she has worked intensively and extensively on the Data Act. Among others, she prepared a study with Matthias Leisner for the European Parliament's committee during the proposal phase for the Data Act. And also she worked with the Commission's Directorate General responsible for the Data Act in the preparation of the trialogue negotiations. So welcome, Lucie.
Thank you so much. Happy to be here, and yeah, happy to speak on the Data Act. As Martin said before, the Data Act is about innovation. It fosters, or it tries to enable fair access to data and to open up new possibilities for data-driven innovation. The question that I want to pose here is whether these objectives can be fulfilled. So to summarize the European data strategy, sharing data is seen as the objective to benefit us all. So we saw the public sector perspective, so getting access to data held by the public sector, whereas the Data Act is focusing on data held by the private sector. So in a nutshell, it's about data sharing as caring for all. So as we have seen also, the European data strategy builds upon 3 pillars. So we heard about the Data Governance Act, which contains a part on access to public sector data, complementing the Open Data Directive. But at the same time, it also tries to foster the development of data intermediaries as a tool to facilitate data sharing between private actors. And in addition, we have those common data spaces, which are indeed, as also Heather said already, are often overlooked. Because on the one hand, we have those regulated data spaces for sensitive sectors, as the European Health Data Space. But we also see the idea that somehow market-driven data spaces developed by respective stakeholders should develop at the market. And then there is the Data Act. And the Data Act comes into play as a tool to implement a fair EU data economy. That's at least, so to say, the objective summarized, and that also went even into the official title of the Data Act, the regulation on harmonized rules on fair access to and use of data. So in the presentation, I would like to go on in 3 steps and take a closer look at the context and again, the underlying rationale of the Data Act, then take a closer look at the access and sharing rights, because they really illustrate this principle of data sharing, of opening up data treasures, and then come again back to my initial question, whether the Data Act can contribute to fair access to data and open up new possibilities for data-driven innovation. So what is important also, the Data Act already entered into force, and it will be directly applicable from next September on. So there is only 1 year left to implement in particular those access and sharing mechanism for the relevant players. So the Data Act, as it is kind of a mixture between very different provisions, also it pursues very different objectives. So as I said before, first of all, it's facilitating access to data for connected products. So most importantly, IoT products. But at the same time, it also aims at safeguarding contractual fairness between the involved players. At the same time, we see the other side of the coin. We see a B2G data sharing mechanism, allowing the public sector to access data held by the private sector in situations of exceptional need. That is basically the COVID-19 outcome. At the same time, we see provisions that are mandatory for cloud service providers, which are obliged to offer their customers switching mechanism, so to port their data from one cloud service provider to another. And there are some provisions on interoperability and technical standards in order to make data flows work from a technical perspective. And those different objectives are become apparent in the different chapters of the Data Act. So as I said before, I would like to focus on those chapters 2 and 3, which contain the B2C and B2B rights of users to access and share data generated by connected products. In order to guarantee this fairness between involved actors, the Data Act also contains a B2B fairness test for contract clauses concerning data sharing, which is also quite important because for the first time we see a mandatory B2B fairness test on a European level. The rest I would like to leave apart for the presentation, but maybe we have time to dig a little bit deeper during the discussion. And then there is also one important provision from an IP law perspective, the former as in the proposal, Article 35, now in the official version is Article 43, which mandates that databases containing machine-generated data cannot qualify for database protection under the Database Directive, which is important when looking at the interplay between those access and sharing rights with possible IP protection. So these provisions contained in Chapter 2 and 3 of the Data Act contain, so to say, a sector-specific right to access data generated by connected products or related services. So what at a first glance sounds very far-reaching, it's quite limited in scope. We are talking about connected products. That is nearly everything nowadays, because nearly every tangible product is able to generate, to collect certain data. But the Data Act is not, for instance, about data generated when I use services which are not connected to the product as such. Possibly because the Digital Markets Act already contains certain provisions on those other services, but those provisions solely apply vis-a-vis gatekeepers. So we see a major difference in this regard, that we have portability and access rights vis-a-vis gatekeepers, and we see this mandatory horizontal rules applying to all users, B2B and B2C, to access data by the products they use. So the underlying rationale of these access mechanism has been that manufacturers of smart products have de facto control over data that is generated during the use by a user. So in order to enable, and we see here somehow the aspect of user empowerment that also Martin already brought up, the user should be enabled to benefit from this data he helps to generate. That is, so to say, the basic idea that underlies the access rights. And at the same time, this is meant as a driver for downstream innovation, so that data-based aftermarket services, repair, complementary services, get the opportunity to access such data in order to provide innovative business models. Again, it applies to all users, B2B, B2C, whether it's about you and your smart fridge, or being a big company having smart machinery for fabricating the goods. So when the proposal of the Data Act came out, this rationale has heavily been contested. The question arises, obviously, can this mechanism work, and is it justified to have such far-reaching access rights in all relationships? However, we have the Data Act now, so we have to look more or less how can we use those opportunities, and how can the relevant stakeholders implement those mandatory obligations the provisions of the Data Act poses on them. So those rights to access are structured as follows. We see a design obligation for manufacturers, mainly, to design their products in a way that by design the users can access the data. This is bolstered by certain pre-contractual information obligations towards the user, so the user should be informed about what data is generated and what data can be accessed afterwards. And then we see the core, so to say, of the access rights articles 4 and 5, containing on the one hand the right of the user to directly get access to the data generated by an IoT product, and also in Article 5, the right of the user to directly share this data with third parties. In Article 6 and 8 and the following, we see further conditions for making the data available to third parties. So that actually relates to the relationship between the data holder and the data recipient. So to repeat, we see those two basic constellations. The user, for instance, of a smart fridge can request the data holder to make respective data generated and transferred to the data holder available. The exception or Article 7 contains an exception for micro and small enterprises as data holders. That seems quite simple. However, if we have services like car sharing, we see a chain of actors leasing a leasing provider, a car sharing provider, and then the user of the sharing service. It's not so easy to determine who's the user. And basically, the Data Act insinuates that we can have many users. But what's then about, for instance, data protection law? Not so easy to answer. And in addition, we see this constellation where the user can request the data holder to directly make data available to a third party of his choice. The only exception, and that is, so to say, a perpetuation of the DMA, are gatekeepers who are not, who cannot be respective data recipients under this Article 5. So I will not go into detail here. I just prepared some more detailed slides for you for your afterward studying. So the data a user and also the third party can get has a very limited scope, because it solely covers volunteered and observed data. So basically, the raw and only pre-processed data a product transmits. But if I want to create an innovative business model, it might be necessary to get the derived, the standardized, the aggregated data. But this is not entailed by the Data Act's scope. In addition, and again, we see the GDPR as elephant in the room, because the access rights apply to both personal and non-personal data. However, as regards personal data, the GDPR fully applies. And what is more, for even this very basic mechanism of making personal data available, the Data Act does not constitute a legal basis in the sense of the GDPR. So more or less, as a data holder, I would have to comply with the mandatory access right of my user. And if I'm hesitant because I might violate data protection provisions, I can choose whether I will comply with the Data Act or with the GDPR. The next important interplay is access rights with IP in the broadest sense. The data sets that have to be made available to the user or to third parties might contain trade secrets. And here the Data Act takes a rather novel approach, because data access has to be granted even though the data contains trade secret. As a mitigating mechanism, the Data Act initially only foresaw a mechanism for maintaining the confidentiality of the data. At the end, as the final version of the Data Act shows, 2 exceptions have been introduced, but they are rather narrow. As regards the interplay with a possible database protection stemming from Article 7 of the Database Directive, as I said before, Article 43 comes into play, which at least on principle solves this problem. And what is quite important, that the roles of the persons and actors involved differ widely. We see the user who can get the data under this Article 4 constellation, and the user is basically allowed to use the data for all lawful purposes. The data holder, mostly the manufacturer of a product, however, cannot use the data he conceptually receives from a product. He needs a contractual agreement with the user allowing him to use non-personal data. And obviously, in addition, he needs certain consent or another legal basis for the use of personal data. When trade secrets are involved, they should even come to an agreement on the measures to maintain the confidentiality of the data. So in the situations where the user decides to share with a third party, the data holder and the third party receiving the data should not only agree on measures to maintain confidentiality of potential trade secrets, they shall also find an agreement on the conditions for making the data available. And these conditions should be fair, reasonable, and non-discriminatory, and they should also find an agreement on a reasonable compensation for getting the data. And also the third party is not free to do whatever it wants with the data, but only can use the data based on an agreement with the user. So we see this very complex mechanism, which is heavily based on contracts. And the Data Act does not say anything about those contracts. That's left to national contract law. However, implementing this puzzle at the different levels, contract law, the GDPR, the interplay in particular with trade secrets, is a very challenging question. And here the devil lies in the details. So to sum up just 1 minute, we see the Data Act as I said before, a measure to contribute to innovation, and it reflects this approach of openness and access to data instead of having exclusive rights. So the Data Act follows the discussion that there should be no exclusive right in data, no data property. However, at the same time, there is a certain misfit because the user is the central person. And the user is the only actor who can put in place, so to say, the sharing mechanism. But are there sufficient incentives for users to make use of these rights? And then, in a second step, open up the data treasures for innovative businesses? The Data Act thereby really tries to shape markets. He tries to open up the treasures for downstream innovation. And this is taking up two of Martin's point, a kind of mission-based law that we see a lot in the recent years. However, in particular, as regards the Data Act, the big question is, will the markets follow? For instance, taking also the DGA into account, will data intermediaries fly? Will, as regards the Data Act, the users contribute to this idea? That is an open question. But looking on a bigger picture, EU's data strategy is still remarkable because on an international level, it differs quite heavily from other approaches. As we heard before, the US follows this strong no market intervention approach, at least as regards data. When we look to China, they basically go to the opposite direction. They are looking again at a sui generis right, and they are already implementing some kind of registers for data sets. So indeed, the EU's approach is a particular one. And it also fits into this idea that, at least from the Commission's perspective, regulation might be a tool to sell, so to say, European values and a harmonized legal framework as a unique selling point. Whether this will work on a global level, we will see and we can discuss basically, but we might find the answer possibly only some decades later. Thank you, and looking forward to the discussion.
Our next speaker probably needs very little introduction. He's one of the organizers of this conference and also the driving force behind it. Bernt Hugenholtz, Professor Emeritus of Intellectual Property Law at the University of Amsterdam, and also until last year here at the University of Bergen. He's the former director of the Institute for Information Law in Amsterdam and has acted as consultant for various organizations, including WIPO, OECD, EU Presidency, European Commission, European Parliament, and so on. So welcome, Bernt.
Morning. Thank you, Lilia. Great to be back in Bergen. Weather was never like this when I was here for a very long time, 17 years, 15 years, yeah. I'll be talking about a topic not familiar to many of you, but it is increasing in importance: text and data mining. In the run-up to the Digital Single Market Directive, which was adopted in 2019, text and data mining was no more than a footnote, sort of a boring side issue for the nerds. I was one of those nerds, but there were very, very few. Most of the political energy, most of the attention, most of the publicity was, of course, on the platform rules in the DSM, the content filtering obligation, and there was some discussion, also quite fanatical on the press publication right, but no one was talking about text and data mining, but it was there in the directive. And if you're wondering, text and data mining, what's he talking about? There's actually a definition in the directive. This is, I believe, the first time in legal history that the concept of text and data mining has been elevated to a legal concept. It is the automated analytical technique aimed at analyzing text and data in digital form in order to generate information which includes, but is not limited to, patterns, trends, and correlations. In other words, big data analysis. That's what text and data mining is. And as I said, nerdy topic, footnote, but it has exploded into importance in recent years. And that's where I'm getting at in the course of this presentation. When this was discussed in the directive, in the run-up to the directive in the years preceding 2019, what we were thinking of was the use of text and data mining, of big data analysis in various fields, scientific and commercial, mostly in science, linguistics, for example. We can use big data analysis on large volumes of language available on the web to analyze the evolution of the Norwegian language, for example. Maybe I should say languages. You have 2 official languages. I'd love to tell that. During my talks about my Norwegian experiences to my friends in the Netherlands, did you know there's 2 official languages in this country? No one knows this. In healthcare, for example, tracking the way an epidemic progresses through regions or over the entire world. In pharmaceutical research to discover new drugs by analyzing big data, for example, by analyzing patents or analyzing pharmaceutical literature. And this is a way, a very rapid way towards drug discovery. In media studies, analyzing hate speech. In journalism, text and data mining is more and more used to dig through enormous amounts of documents and then discover that Putin actually owns houses in the Caribbean. The Panama Papers. Search engines are built on big data analysis. The indexes that drive a search engine are based on text and data mining of the entire internet. In all these cases, text and data mining usually starts with large-scale scraping of content of raw data from the web, from the internet. And that involves, obviously, reproducing tons and tons, gigabytes of petabytes of copyright protected stuff. And that's where the DSM and the text and data mining exception enters. There is an obvious conflict, at least technically speaking, between scraping the internet and using it for data analysis and the rights that right holders enjoy under copyright and neighboring rights legislation. The origin, I've been looking for the true origin, the roots of the text and data mining rules in the DSM directive, and I found it in one of many papers, policy papers, published by the European Commission on opening up data to build the famous data economy. There are at least 5 of these big papers and maybe even 10, all repeating the same message. Data is the new gold, the oil of our future economy, and we need to open that up for reuse, for competition, for innovation. And one of the first of those is a paper that was published 10 years ago, Towards a Thriving Data-Driven Economy. It has all the same grandiose language that you see in later papers. All of these papers basically conveying the same message and leading up to, and that's why we're in this joint panel, to instruments like the Open Data Directive, the Data Governance Act, and the Data Act. All of these are manifestations of that same ambition. And so are the text and data mining exceptions under the DSM directive. This is from the 2014 policy paper. The Commission is investigating ways in which data-driven innovation based on data mining, including text mining, might be enhanced, including in relation to the relevant copyright aspects. I'm almost certain that this is the first time this problem is mentioned at the EU level. This led rather quickly already to a text and data mining exception included in the original proposal for the DSM Directive in 2016. And no one really noticed this. In fact, in the course of the parliamentary discussions on the proposal, the text and data mining exception was expanded by another exception, a much broader exception in scope for allowing general purpose text and data mining, not only for scientific research, but for all other purposes as well, including commercial purposes. That was added during the, as always, complicated legislative process. People at the Dutch Ministry of Justice proudly tell me that they actually proposed this in the council. So this could actually be a Dutch addition to the, I'm not sure that's true, by the way, but they told me that. At the same time, the European Parliament also advocated broadening this exception to allow commercial text and data mining as well. Finally, we have two, not just one, text and data mining exception in the DSM Directive. Both of them mandatory, that means all the member states have to include them in their national law. One for nonprofit research, the other clearly more important one in practice for all purposes, with one proviso, and that's different from Article 3. Article 4, the general purpose text and data mining exception, allows right holders to opt out from the exception. This is quite a new rule, a new type of rule that we haven't seen much in copyright, where right holders can escape from an exception by opting out, expressly opting out. How do they opt out? The Article 4.3 tells us that for content made available online, that's basically all of the content being text and data mined in practice. Most of it is scraped from the web. Right holders have to use machine-readable means. So just stating on a website, I don't want to be text and data mined, or this website cannot be text and data mined, is not enough. There has to be a clear machine-readable instruction similar to the robot text format protocol that we already know for, and which is already widely in use for many years, which instructs crawlers such as those by search engines not to crawl a website. These exceptions apply not only in the field of copyright, but also in neighboring rights and database right. And no remuneration is included in this structure. So authors and right holders do not get compensated for these uses. As I said, these rules were far from controversial when they were introduced, and even when they were adopted in 2019. Right holders basically didn't care about them. There was hardly any lobbying. Scholars looked at it and were somewhat more interested, but basically said, well, is this really necessary? Mining in our conception of copyright already is permitted. Why need an exception in the first place? The reproduction right, said several scholars, does not extend to extractions of data from the expressive layers that copyright normally protects. It's always been allowed to extract data from a copyright protected work. That's how journalists work. They read other people's news and then rephrase that use the data in their own stories. This is how scientists work. This is normal. So this is how we learn. There's actually a doctrine in copyright developed in the United States, but it applies in Europe as well, the idea-expression dichotomy, which tells us that copyright scope protection layer is limited to the expression. Underlying ideas and facts are not protected. So why need an exception allowing text and data mining? There was even some fear in the initial years of the DSM that the exception would be too limited, that it would actually restrict the freedom to mine compared to the old situation where we had no exception. I'm actually on record saying one may wonder if innovation in Europe would not have been better served without any of these exceptions. Martin already referred to my innate suspicion of new rules at the European level. And I think that reflects what many thought in those days. Nothing controversial. And then the world changed, and that was 2 years ago. Even less. You had some AI already in the summer of 2022, but the big change, of course, came with the launch of ChatGPT in November 30, 2022, not even 2 years ago. And suddenly, this rather unseen provision or set of provisions became extremely relevant. As we all know, large language models, the generative AI technology that is changing our world or has already changed our world is driven by mining large volumes of data, including trillions of copyright works that are used as training input for large language models. What you see on this slide is an illustration of that. This is the so-called model card that European AI developer Aleph Alpha, it's probably the biggest player in Europe, it's a German company, makes available online. So there's already some transparency here as to its training data input. And what you see here is web crawls constitute 71% of the input in terms of training data to its large language models. There's also some books, interestingly. AI also reads books, and 5% of other sources, including lots of stuff provided by the EU. The EU produces a lot of data, so there you have open data as well. Wikipedia is 2%, by the way. Anyway, interesting figures, but what you see, most of this comes from scraping the net. So there is a lot of text and data mining leading to these models. And that has ignited the rage of the copyright industries, but not only those, also those of actual authors, actual creators. You've all heard of the Hollywood anti-AI strike. It wasn't only about AI, but AI was certainly a driver there. There has been anxiety all over the world in authorial circles and amongst right holders about the use of their content as input to technology that they perceive as a threat, or at least that they would like a piece of in terms of revenue. And that forces us to take a much closer look at this text and data mining rules that were dormant until then. In fact, the AI Act, which was adopted this year in June, contains some early responses to these concerns in that it regulates that providers of GPAI models, general purpose AI models, must comply with those rules of the DSM Directive, particularly Article 4.3 on text and data mining and its opt-out provision. Even if the training occurs outside the EU, models offered on the European market must take these rules into account. So there is a compliance obligation, or at least the obligation to develop a policy that complies with EU copyright rules. Otherwise, you may not offer your product on the market here. On top of that, there is another obligation in the AI to be transparent about training data, a bit similar to the model card that I already showed you previously. So the AI Act actually builds on the DSM provisions on text and data mining. So how did right holders deal with that until now in Europe? The initial position, as we could have guessed, was that those TDM exceptions were never meant for AI. Text and data mining is about other things, linguistic analysis, small fries, things that right holders don't care about. This is a completely different ballgame. The lawmaker never considered AI when these rules were made. That position, although understandable, is now, I believe, completely untenable, specifically because the AI Act builds on these rules in the context of AI. So it's quite clear that, according to the European lawmaker, that is a settled issue. There is no discussion that the TDM exceptions also apply in respect of AI training. Another notable response is the lack of litigation in Europe. There is almost no litigation pending in Europe concerning this question, which is, I believe, an illustration of the fact that it is a settled issue that the TDM exceptions apply. Compare that to the United States, where there are at least 20 fair use cases currently pending in courts. The US do not have this specific rule. They have this overarching fair use doctrine, which is being invoked by the AI tech companies against claims by the New York Times and many other large right holders concerning possible infringement of copyright. None of these cases, as far as I know, has come to even close to an end. So there's a lot of legal insecurity there in the United States. There's also some insecurity still in Europe. Not all is settled here. Many right holders, in fact, have opted out, but the way they have opted out is subject to debate. What we see a lot is public declarations by large collective rights management organizations, by large right holders, that they opt out from the exception. But these are very questionable in light of the rather precise obligation under the Article 4.3 of the DSM Directive concerning the use of machine-readable means. A declaration by SACEM on its website is not machine-readable, so I would argue not valid. There are problems flagged by many right holders that doing this in a machine-readable way for each object is problematic. Some objects, some digital objects of their works are available on the internet in thousands of copies. Do they need to add machine-readable means, opt-outs to each of those? That is one of the questions. There's also a rise of content training deals, which is emerging, particularly in the United States, but also in Europe. OpenAI is leading here. The leading company in the field of generative AI is also leading in doing content deals, exclusive deals in many cases with large content providers such as Axel Springer, such as Le Monde, such as Prisa Media. Those are all European companies, also various international companies, illustrating the need of the generative AI tech companies to have quality content available for training. Where are the authors in all this? Well, they are, as usually, sidelined in most of these debates, hand-wringing, worried about their future, and as a fallback position, asking for at least some remuneration in the form of a statutory remuneration right. The story's not over here, although it is over in a sense that the text and data mining exceptions are here to stay and will apply also in the future for AI. But as is clear from some leaked documents that have been circulating in Brussels and that you can easily find on the web, by the way, this is not the end of the story. There is a strong push towards at least revisiting some of these rules under a future commission. Under the current Hungarian presidency, a questionnaire has been distributed amongst the member states' delegations. That's this document. It's confidential, secret, shouldn't have been showing it, except that it's all over the internet, so I feel free to do it anyway. Interestingly, the questionnaire, which asks questions to the national delegates from the member states, asks pertinent questions about several AI and copyright related issues, although it starts by observing that the relationship between AI and copyright is already covered by EU legislation, and that includes the text and data mining exception. So that's an illustration, again, of the fact that that is a de facto, that's a given also for the future. However, some aspects, for example, and that's underlined here, potential remuneration for the use of protected works in the context of AI-generated creation could justify perhaps some intervention. That is an indication that there might be something added to the current acquis in this field. This is highly speculative, but, and this is my last slide, it's not unthinkable that at least something will happen to be tagged on the current rules of Article 4. A complete revision and retraction I do not see happening. At another level, a lot of legislation or self-regulation is going to occur in the context of the AI Act, which will be the subject of a separate session. The AI Act requires all sorts of self-regulatory codes of conduct, including rules on the exact template of summaries of training data, possibly also technical standards for opt-outs. There's a bewildering variety in practice now on the ways opt-outs can be realized by technical means. There's an obvious need here for some unification. So that will happen as well in the years to come. When doing all this, I think it is important to remember where we come from with text and data mining. The original concept is very much worth preserving. The freedom to mine, to open up data from copyright protected silos remains important for science, particularly, but also in various commercial realms, including AI, but including many other areas as well. Thank you very much for your attention.
Yeah, thank you, Bernt. I would like to invite all the participants of this panel on the stage for our panel discussion. Just a small note, we have a problem with asking questions online. We will fix it in the lunch break. So we will have more time to discuss questions from the live audience. Now, And there will be a microphone passed on, so you can already start raising your hands and you will receive a microphone for the question. But while you're preparing your questions, I would like to start with some opening questions to our speakers. And I would like to start with Heather, with kind of a unique position to also, you know, reflect on how governments are trying to comply with the regulations in the field of maybe misleading open data policies in public sector, as we've heard. But what would be your reflection? Has it been successful, or do you have any success stories to share?
I think if the measure of success is that there's a lot of data shared, then I think the answer, at least on the national level, and this is kind of every country throughout Europe, I think the answer would be there aren't any major success stories on the national level. I think that's quite, you know, as I say, if the success, the factor is the amount of data shared, because no country has managed to achieve what it set out to do. Huge ambitions for open data and huge ideas. Oh, we'll just set policies for open data and everyone would share their data and the world would be a better place. But what I do think is that the maturity that has happened here is understanding that this is very complex, that opening and sharing data from the public sector needs serious thoughts, needs serious expertise, it needs serious finances and investment, and that some data is more valuable than others. That just has to be taken into consideration. Now, in saying that and saying that there aren't national success stories, there are some organizational success stories. So here in Norway, for example, the Meteorological Institute has shared its data for, it's well over 10 years now at this stage. They were well out before Europe even came with a major open data policy. And they've had major success. They are attracting serious, very high level staff because of their reputation for openness and sharing. And their data is a much better quality because they're getting so much input back on their quality of data. So there are absolutely success stories, examples of organizational level, but I think at the national level, you know, we've learned a lot to improve our policies and to make them more targeted going forward. Yeah.
And I had just one follow-up question, because you mentioned there is no obligation placed on governments, right? Why do you think is that the case? Is there like any differences like in capabilities of countries to meet
it's the capabilities, but it's also the fact that it's a huge thing to ask, because this is not the core function of the public sector to share data. Their core job is to deliver their public services, and the data is a byproduct of those services. So to ask all, and we discussed that at length actually in the Law Commission when we did it, and said it's just such a huge thing to do to make it mandatory that all organizations must share data, particularly as some data, of course, is more valuable than others. So what we suggested in the Law Commission is that we need to prioritize. So we've suggested that on the national level here in Norway, that there would be a national prioritization committee, and other countries have done that. To make it mandatory to share some data at the national level. Yeah. So.
And I just received the news that online participants can ask questions now in the chat. It should be working. So yeah, please send us our way. And I would like to continue with Lucie. Of course, everybody on the panel should be free to participate. Do you think, Lucie, that something has been learned from this public sector experience in terms of placing an obligation? Because in Data Act, yeah.
As regards the obligation, I think it's a completely different approach, because it applies to a completely different relation, right? But maybe what we see or can interpret as a certain kind of lesson from access to public sector data, and that is reflected in the Data Act, is maybe the key importance of mechanism to make data flows work in practice, because that is actually also what in the open data community and in the national institutions is what we see, right? And therefore the Data Act tried, at least in a limited way, to introduce those provisions on standardization, on interoperability. But for instance, talking about personal data and technical means for anonymization, there could have been a little bit more actually. And also this mechanism of negotiating the conditions for making data available between the data holder and the data recipient might show certain parallels. However, as I said before, it is a very different relation because it's between private actors and not between the public sector and access by the private sector.
Thank you. And a following up question to Bernt, because rather predictably, all of those instruments have this very classical without prejudice to to copyright and intellectual property rights. Of course, you already hinted it in your presentation. How do you think whether it goes well together? This with EU copyright law, for instance, or intellectual property in general, or should there be more concrete links between the instruments? You already talked about the AI Act, and it actually relies on the TDM exception. But when taking more broad perspective on sharing public data or data access to the data sharing under the Data Act, do you think more regulation is needed in terms of linking it all together, or you would prefer, to just keep it apart?
No, I think the answer already implies the question already implies the answer. I think there could be more coordination between, on the one hand, this very laudable ambition of reuse, promoting the reuse of data in government, but also in private sector, in science, and also in commerce more generally. And the rules of intellectual property. Very often this very complex tension is dealt with almost as an afterthought, like in the Data Act, and they throw in this sui generis right provision, which is not very well crafted and raises a lot of questions. In the field of the Open Data Directive, the PSI directive previously, there was a huge debate for years of concerning whether or not government entities could invoke intellectual property rights to basically frustrate the whole application of the obligation to allow reuses. That also has led to amendments in the ODD, but that problem is still not over. No. It is still simmering there. In the Netherlands and elsewhere, there is still litigation about government agencies invoking database rights to basically keep in control of markets that they should not be in control. So this should be, I believe, much better regulated, and I think a more holistic approach would be important. How that would look like, I don't know. I do have one bit of advice. I think it would help already a bit if we would start considering subject matter exclusions to be harmonized at the in Europe in copyright and database, right? We haven't done that yet. There's a big difference in the way different member states deal with copyright ownership of government information. Some countries, it's almost 100%. In other countries, like Ireland, in other countries, it's sort of mitigated. It's half free. In the United States, at the federal level, the government works completely without copyright. I think the time is for some harmonization there, and preferably a rather radical one. I would be very much in favor of following the US rule. No copyright protection for government works, no database rights for government information.
Just taking up this point that it might also be qualified nearly as a common feature, right? How to treat the database sui generis, right? By means of the Open Data Directive, by the Data Governance Act, by the Data Act, instead of just reforming the Database Directive as originally announced, right? And there are so many issues, ownership, also as you said, Article 43 does not solve all problems regarding databases containing those machine-generated data. So there is still need, or would be the need, to reform the database directive as such in order to solve all these problems, right?
And yeah, and if I just build, I completely agree with the idea that, you know, in following the federal level in the US, I mean, the federal level in the US doesn't need this law. They don't need an open data direct. Well, they have an open data law now, but on a different level, you know, because that was the main impetus reason to have it in the first place, was to deal with these intellectual property rights in the public sector. So I completely agree with that. It would be a great initiative.
I think I would also agree with with the remark, especially in the light of this one Canadian case at the Court of Justice. But just one more follow up on the sui generis rights, because they've been there for a long time, and Bernt knows all about them. For a long time, there was a discussion: well, are they needed for the private sector? Do they actually bring any value? But I think the tables have turned now, with maybe with generative AI, or what would be your impression? Have they become more important than what it was thought for just maybe 5 years ago?
I mean, the database, right?
Yes.
The sui generis, right? Well, with AI, every right has become more important. I'm not saying it's important, but it could be another leverage, could create more leverage on the part of certain stakeholders. Does that mean that it's now a better rule than before? I don't think so. In fact, I think with text and data mining, I think it's a good illustration that we should be very careful with introducing rights that give such broad coverage of data in the IP field. So I'm not. So if I don't know where your question is really heading, but I wouldn't say that the AI has proven the usefulness of database rights. At the same time, in practice, it will be invoked probably also against AI tech companies.
Yeah, my follow-up would be if we can think about other rights which we maybe do not consider now, but they might be very important in light of the further development. Because as Lucie also has said, well, we might see the impact of these rules in few decades, right? And how we have the rules now, what we do not consider important, as text and data mining exception has been at the beginning, that it became very important at this point. I would like to open for questions from the audience. We have any? To please pass the microphone to them.
You can throw this microphone.
Yeah.
That's the idea. Yeah.
Okay, I think my question goes to Lucie first and foremost. I was actually wonder if you could elaborate a little bit more on the interface between the Trade Secrets Directive and the open data regime, as I think one of your last slides touched upon that. You talked about contractual regulations that has to be imposed in that matter. I was actually wonder specifically, what about the holder of trade secrets that is not interested to share its trade secrets? Is there any compulsory licensing systems to be imposed or introduced? Thank you.
So indeed, the bottom line is that just arguing that the data covered by the data access rights are protected as trade secret does not give you the opportunity, so to say, to block data access or data sharing. So that's the very basic concept of the data. Instead, the basic idea was to keep the nature as a trade secret by making the relevant actors agree on technical and organizational measures to keep the respective trade secret secret. But that is already a problem, right? Because as I said before, if we have 5 to 10 users talking about this data sharing provider and the user of the service, what is secret then? Even if I would conclude a non-disclosure agreement with all the users, is the data then still confidential? Difficult. But that was, so to say, at the very beginning, without having a particular exception for refusing access requests. So during the legislative process, that was a highly debated question, and also industry lobbied heavily in order to introduce particular exceptions. So at the end of the day, we see 2 specific exceptions, but they are quite narrow. So the first exception for refusing access requests or to stop ongoing sharing is if the data recipient or the user does not comply with the measures agreed upon, or if the actors are not able to agree on respective measures. And the second exception is if the data holder, who's also the trade secrets holder, in this case, can demonstrate that it is very highly likely to suffer serious economic damage. So high threshold and rather unclear what that might mean. In the recitals, there are some explanations, for instance, that data is transferred to third countries where enforcement of trade secret protection is not guaranteed. But at the end of the day, it seems at least highly likely that data holders will use it also in order to try, right, how the courts will interpret these exceptions. And it might contribute to a certain, at least, mechanism to, put obstacles in the way of the users. It's difficult. Some people qualify this basic principle of the Data Act even as a compulsory license, because basically you have to give your trade secrets to the user, or even more important, to a third party. There are also voices who argued that this particular data, because it's a very limited scope, cannot even be protected as a trade secret. That would also be an interesting line of argumentation. However, this is highly contested by industry because their main concern is also that at the very end you could somehow deduce at least trade secrets from the data you get. So a difficult one also.
Hi, so I have a very stupid question about the GDPR and the relationship with the whole regime. I am kind of struggling to really see the tension between the two. And I know that that sounds really weird because we have all the open data and a huge amount of data, but just thinking out loud, say that we enter into a data sharing agreement, or say that I request access to some data. So GDPR, being principle-based, first has an exception for use of data for research, statistical purposes, and so forth. And then even if that doesn't apply, under Article 6, obviously we can't ask for consent and we don't have a legal obligation to process this data, but we could claim either public interest, which is easy to establish because there is already legislation in place, or we could claim, I suppose, legitimate interest as well, right, as a legal basis. So I'm kind of struggling to see the tension there, disclaimer being, I'm probably wrong, but yeah, thanks.
Is that in relation to open data?
Is this about the Data Act?
Yeah.
Yep.
Oh, yeah.
Or the data governance, I'm not sure.
Yeah, it's mainly about the Data Governance Act. Indeed, what, so to say, rescues the entire mechanism, also from my point of view, is Article 6.1F, the legitimate interest. And indeed, this tension between the Data Act and the GDPR becomes apparent primarily when the user requesting data access for him or herself or sharing the data with the third party is not the data subject in the sense of the GDPR. So for an instance, an employer requesting access to data that contains data of its employees, or having this data, this car sharing construction. So there it becomes relevant. And indeed, I would also tend to solve it at least by applying the legitimate interest provision, because very often the data holder and the data subject do not have any relation. So how to obtain consent without, for instance, having the user that is helping to get the data subject's consent. But this is also contested because legitimate interest is always getting broader and broader and broader. And so to say, the strong argues in favor of the GDPR always are hesitant to apply the legitimate interest provision so far-reachingly. But at least from my point of view, I agree it's more or less the only possible way to make it work in practice.
I think we had a first.
Hi, I'm Pam Samuelson, and I'm from the United States, and you guys make me scratch my head all the time because the way that you think about data is so different from the way that we do. I have a question for each of you. I hope that's okay. So Heather, when I was listening to your talk, all I could think about was the debate back in the early 1990s about so many of the countries in the EU supported the sui generis database right because they intended to commercialize their data. And so it doesn't surprise me that there might be some tension still between some of the countries that might want to commercialize data and the European-wide effort to support public access to public data. And I'd love to see a little bit more from you about sort of how that is being managed and in enacting these public sector data rules. Was there an effort to sort of abrogate the interests of the countries that wanted to commercialize their data, or did they just give up because they're just not very good at that? And that's actually something. So maybe you should answer that question, then I'll go to the other two, if that's okay.
Yeah, I think that is a really interesting question. I think really what's happened is that culture change, like you're referring to. This was back in the 90s and the 80s. This was the norm. This was completely accepted in Europe, that the public sector could create their own products and sell those products in the market at a profit. No questions asked. There's been a huge culture change since then and a huge shift since then. We're still seeing it possibly, maybe mostly in the map sector, the mapping sector, who have had particular income provisions, and that, you know, some ways of continuing to sell their data. But it is not as much of an issue in the other sectors, and is actually, I mean, even in Norway, we have seen the number of companies who used to have an income generating situation by law, that is completely reduced now. So I think the only one really left is the mapping authorities. So we've seen a huge culture shift, and it's, you know, it's kind of unacceptable now. And I have to say that Europe has been a huge operator for that culture shift. huge reason for it.
Lucie, the question that you asked, which I don't think you really answered, that I was intrigued by, was the question about what incentives do individual users have to essentially invoke the data sharing opportunities. And it seems to me that most individuals will have almost no incentives, and that if you wanted to create incentives, then you'd give the access right to the people who'd facilitate the user. And so was it the result of lobbying that that meant that you put it only on the user and you don't allow the third parties to invoke that right? Or was it just overconfidence that the individual users would be incented to do what the drafters of the act thought they were trying to achieve?
I think one has to keep in mind that, so to say, the very basic idea focuses primarily on one particular case. For instance, I have a smart product. I want to get it repaired. I should be able to use an independent repair service. For this constellation, the access right works. Also for me as a individual B2C user, because I say, okay, my smart fridge, or it's much cheaper to have my smart fridge repaired with this repair service instead than with the manufacturers. There, I would say, okay, we have an incentive. But then this concept became much broader, right? And this rationale does not work anymore. Because what would, for instance, be an interesting use case is insurance companies. But thinking about innovative business models, would I, as an individual, be interested to request a data holder to share my data with a third party if this third party says, please share your data, because then in 3 years I can provide you with a very innovative service? And I would tend to say, no, there is really no incentive. So I think this underlying rationale was quite limited to a particular case group, and then became broader and broader to a kind of sandbox IoT access right in order to test a little bit how it will work. But indeed, I completely agree. In particular, in B2C settings, I see a very big lack of incentives. And if we have no incentive, the entire mechanism will not work at all.
Very short question to you. Who's going to make the technical standards about how to machine readable opt-out?
Yeah, that's, as always, your questions are very good. The AI Act mandates these codes of conduct because actually the AI Act will enter into force in practice only in a couple of years. Almost all of the rules will be operational for practical purposes only in 1 or 2 years. And in the meantime, the idea is that codes of conduct will solve most of the issues. They are semi-voluntary. The AI Office of the European Commission plays a role here. But in the mandate for the codes of conduct, the standardization of the opt-outs not mentioned as one of the issues. So I hope that it will be integrated into that work, and it would make a lot of sense if that happens. But it's not mandated as such under the AI Act. That doesn't mean that it couldn't be part of that. In practice, there is already some discussion underway at the stakeholder level. Actually, I attended a session where right holders and various large AI tech companies were present and talking about different standards. So my guess is it will be a voluntary standard rather than an obligatory one in the years to come. And there's a clear interest on both sides to have some standardization here. As a right holder, you need to know what kind of meta tag should I attach to my content, and the tech companies need to have standardization too. They cannot build their crawlers to recognize 25 different kind of opt-outs. That doesn't answer your question, really, but I can't go any further than that. I do want to applaud you for your question about the incentive under the data Act. I think that's an enormous gap in the whole system. Look at this country. Everyone drives a Tesla or another e-vehicle. You will now all become owners of a data generating product, and that gives you the right to access the data. Are you going to do that? Why? And what will Tesla? Where's the money in it? Where's for all that effort? So I cannot see it. It's very theoretical, this whole model. I think it's going to be a complete failure.
Yes.
I'm sorry to say that.
No, I agree.
The time I will show. We had a question from Benjamin, right?
Yeah. But perhaps have faith in businesses. I mean, they find a way to monetize those data, and then I can give back some of the money to the users. So, for example, insurances, they say I give you a cheaper insurance now if you provide me with your data, and then I can tax you in 5 years for that data and with that data. But I've basically two questions, or they're more statements, but I'll camouflage them as a question by raising my voice at the end. The first one's about this overlap with Data Act and GDPR, or that collision. I see a small glimmer of hope because the new German Federal Data Protection Commissioner, Luisa Specht-Riemenschneider, she wrote a paper before she became into that post, saying, well, the Data Act actually shows that there's a great public interest in data sharing. And when weighing those interests in Article 6.1f, well, now we've got a strong indicator that that's a strong interest, and perhaps that will help if she can promote those data usage as well as protection, because that's the ticket she ran on. Well, no raising of the voice there, but just perhaps there's some hope. But then coming to you, Bernt, I mostly agree with your analysis of text and data mining, but I see a huge backlash coming at the moment. You probably haven't seen it. There's now a 170 pages paper by the Urheberrechtsinitiative, copyright initiative in Germany, but it was presented by Axel Voss yesterday in Brussels, so it's probably getting some traction. And they're basically saying, well, we want to go back to the time where we didn't have to think about it. They just want to explain it away. So saying, well, everything is a technical reproduction, so therefore we're entering the reproduction right, and it doesn't fall under the temporary reproduction exception of the Infosoc directive because, well, it's valuable and therefore it shouldn't apply. Although I think in the DSM directive, there's in recital 9 saying, well, of course it's covered by the temporary reproduction limitation, but and then they're saying, well, in the AI Act, they didn't mean to say that the Article 4 of the DSM directive is applicable because they actually didn't think about it. I don't know. I've read it completely, but they're basically saying, well, it's a copyright reproduction and there are no exceptions, and therefore we are going back to the standard we had before we actually introduced those DSM TDM exceptions. So perhaps we have to fight a bit for the view that copyright shouldn't cover just semantic data, but the structured data. So, yeah, would you agree?
It sounds like enormous wishful thinking on the part of this. What do you say? 170
pages.
Yeah. And I think I need some AI to read through that. But I think I already get the gist. It's not going to happen, of course. I mean, it sounds like sort of an opening position for a discussion that is going to happen in the EU in the next couple of years on perhaps tweaking these rules. But I cannot imagine that the European Union is going to roll back on legislation that it introduced only a couple of years ago. And that even is confirmed in the AI Act, which was adopted only a couple of months ago. I cannot imagine that happening. But I could imagine some tweaking, yes. So, but I already said. But who knows? Axel Voss is a powerful man, of course.
Might have read it.
And we have another question from Agojata.
Yes, thank you so much for all the presentations. And the question, a follow-up on what Milos started on behalf of the big elephant in the room. So the GDPR, because legitimate interest, I'm fine with that, even strong public interest. But let us not forget about special categories of personal data. So Article 9, and there the requirement is substantial public interest. That's a different story. So I'm not saying it's not going to go, but we have very little court practice on that. So we will see how it goes. But still, in theory, we have a problem.
Yes, indeed. And also talking about legitimate interest, I would, or I personally completely agree. And I would even have wished that the Commission would just use Article 6.1c, so the legal obligation, as a tool to make the Data Act a legal basis. And the same holds true for all the different, we just talked about the European Health Data Space, etc., etc. So for all these interests, but really, yeah, the GDPR somehow seems to be the golden cow that no one wants to touch from a very political point of view, right? So also talking about the legitimate interest, let's see what happens. I also would say it's the only mechanism to make it work in practice, as I said before. But let's see what, at the end of the day, the European Court of Justice says. What can give us hope that the legitimate interest is a rather broad notion. But also the notion of personal data is super broad. And also the notion of particular sensitive data in the sense of Article 9 is very, very broad. If we take a look at the Miete judgment, for instance, and talking about smartphones, wearables, that might all be data on our health and whatsoever. So we might really, in the majority of cases, be in the scope of Article 9 of the GDPR. So let's hope that Article 6.1f can help us, but I'm not so sure.
Thank you. So we're already tapping into lunch. So unless I see any hands here, I have one question, which is a more general one, and perhaps Martin would also like to reflect on it, because we often talk about this past dependency. You know, Bernt mentioned, well, it's unlikely that now the changes will be introduced to something which was introduced just a few months ago, right? And this was access to data, both like public and private. This has been in the pipelines for some time, and we've been working towards that. And I'm thinking here about the state-private companies interaction, because there is this novel provision about in Data Act, where states can have access to the private can request access to the private held data, typically COVID-19, that would be the example, but we might think about other examples where the governments need to do that for reasons of national security, for instance, or whatever that might be. But there is also the other link. I think the Data Act also talks about access of third governments to the data, which is held by private public. So do you have any reflections on that? You know, maybe the events which have been happening during this past years, did they make the European legislature reflect on this open data policy, you know, as open as possible, as closed as necessary? Do you see anything in this direction, or we just following, you know, the path of as open as possible? That's the maximum we want to achieve. I know it's a big question, but any reflections on that? You?
Yeah, and what as open as possible and as closed as necessary even means in the future. I think that needs to be discussed. I mean, Martin was in on it there as well, and I touched on it in my presentation as well. I think another thing to add there in terms of the state getting access to data is data altruism is very important as well. So it's the Data Governance Act and the Data Act is you know, there's a complementarity there as well. And I think we will see more of that over time, of needing to pursue more of that. Would you agree?
Yeah, and indeed, and also talking about the exceptional circumstances in this B2G data access part of the Data Act. Also there, it remains to be seen, right, how it is interpreted, because it has been narrowed down quite a lot during the legislative process. So yeah, it depends a little bit on the future, and yeah, let's see. And what is indeed a little bit overlooked is this article 37 containing the obligation of service providers to introduce measures in order to avoid so governmental access to non-personal data held in the Union. And we see a parallel provision in the Data Governance Act. And this aspect is only partly discussed, actually. And there are voices saying more or less, at the end of the day, this might lead to a certain data localization requirement from a practical point of view. And it's an important aspect from an international perspective. And it also, from a perspective of the providers, is still a kind of burdening obligation, even though from a very first glance, it seems like a very marginal provision.
I think we should have lunch.
But Martin has the micro.
I just wanted to say that I think, no, they haven't learned, the policymakers here, because I think the two basic problems that I also mentioned, and you also mentioned them as well, are that they are still not solving the data protection issue. They're not synchronizing it. It's impossible. For the reasons you have mentioned, scope of sensitive data, scope of personal data is incredibly broad. If you don't try to synchronize it in some way, you cannot just build innovation policy on a concept that is a quicksand where it changes all the time, and the court is naturally inclined to expand the reach all the time. I think this just cannot work. I understand why politically they pass legislation like that because it's easier, but it's just not, as an innovation policy, it just cannot work. I mean, you cannot be given an incentive with the footnotes that essentially becomes a rule. That cannot work. And the second problem is what was also mentioned is the incentive. And then this is also not something new. Under the GDPR Article 20, we have portability right. It's on the books for a couple of years now. We spent a few years looking into, is industry going to use it? And we came up with ideas how they could use it. Lidl offering you ability to port your information from a club card from Tesco, so you can see how your purchase would compare, etc. Have we seen any of that? No. And you didn't even have the GDPR problem because this is literally within the GDPR. So there is a huge problem how to incentivize this. What is the killer app for that? And with a big footnote like GDPR, I'm really skeptical. So I think the next commission should try to not only pour money into different types of programs where they try to facilitate the use, but perhaps really think hard how to synchronize. And that's impossible without honest conversation with data protection authorities. I think. My 2 cents.
Thank you so much for such a nice closing words for this panel. Probably. So yeah, we are now into the lunchtime. We will start again at 12:45. So 45 minutes.
Welcome back, everyone. My name is Thomas Vinje. I have the honor of being part of the Faculty of Law here in Bergen. And we have a brilliant panel, just as the previous ones. And I will address or introduce them very briefly. You can always look them up. So we have Benjamin Raue, Professor, University of Trier, Chair for the Private Law, Law of Information Society and IP Law at Trier University. Torger Kielland, who is professor here at the University of Bergen in IP law, and Alexander Iken, who is with DG Competition in one of the units responsible for enforcing the Digital Markets Act. So without further ado, Torger, take it away.
Thank you, Thomas. I'm going to start by going back to ancient times, 2005. This is, as you might know, actor Tom Cruise jumping in Oprah Winfrey's sofa, apparently over his excitement with his then relationship with actress Katie Holmes. This made the news, of course, because of Cruise's seemingly crazy behavior. And the clip, of course, also made it out on the internet, and it was also posted on a then very small video sharing platform called YouTube. And these posts included remixes, including one which supposedly was the most popular, which Cruise electrifies Oprah Winfrey like the evil emperor in Star Wars. YouTube, which was founded in February 2005, and the popularity of this Cruise video, along with other viral moments around at the same time, helped draw attention to YouTube as a platform where users could easily upload and share video content. And that is like the key here. YouTube and similar platforms, they allowed users to share their contents in ways that weren't possible before. Of course, you could build your own homepage. I know I didn't have that many visitors, but by sharing your content on YouTube and similar platforms, you could get out to an audience that you couldn't before. And about the same time, you also had the advent of social media, Facebook and the like, which also allowed sharing on another level. This, of course, this heightened ability to share, of course, also increased the sharing of copyrighted content. And if you ask the copyright lawyer in 2005 if platforms were liable for their users' sharing of copyrighted material, the answer would be a unison no. The argument would have been that it's the user who makes the content available, and all the platform does is to facilitate that making available, but that is not a copyright infringement in itself. The platform only facilitates the user's sharing. Of relevance here was, of course, also the e-commerce directive and its safe harbor provisions that limited liability for online intermediaries. Of course, since the beginning of the 2000s, the Court of Justice have interpreted the right to communication to the public more broadly than than initially anticipated. In the YouTube Ciando case, the Court of Justice held that platforms that share their users' content could, under certain circumstances, perform an independent communication to the public and therefore be liable for their users' uploads. However, the platform must still knowingly have contributed to the user's sharing of copyrighted content. And in the specific case, YouTube would probably not be liable according to the criteria that the Court of Justice instilled. Then came Article 17 of the CDSM Directive. This changes thing. Article 17 establishes a new regime for platform liability for sharing of copyrighted content and establishes a rule that online content sharing service provider performs an independent act of communication to the public when it gives the public access to copyright protected works that is uploaded by its users. In short, Article 17, number 1, makes the platform liable for content their users have uploaded. Article 17 was introduced to address the so-called value gap, which refers to the disparity between the profits generated by online platforms such as YouTube that hosts a user-uploaded content and the compensation received by content creators and copyright holders. And the aim of Article 17 is to ensure that platforms like YouTube, which benefit from distributing works, take a more proactive role in, one, obtaining proper licensing agreements, and if they can't acquire licenses, then ensures that infringing content is not available. The primary obligation, the primary obligation of Article 17 is that the platforms, the online service providers, acquires a license to communicate their users' content. However, if they can't get the license or hasn't got the license, the platform can escape liability even if the content is not authorized. It follows from Article 17, number 4, which lists 3 cumulative criteria that the platforms must fulfill that enables them to escape liability for copyright infringement. Firstly, the platforms must have made a best effort to obtain authorization. And if the platform can demonstrate that they have made all reasonable efforts to secure a license for the content, it may avoid such liability. Second, the platforms must have made best efforts to ensure an availability of specific works. And this means implementing, say, effective measures like filters to prevent the availability of specific infringing works. Article 17, however, and this is important, does not impose an obligation for a general obligation to monitor all content that is uploaded by its users. And this limitation, it aims to balance copyright protection with fundamental rights, particularly freedom of expression and privacy. And third, the platforms must immediately remove infringing content they encounter. And this provision is akin to the notice and takedown mechanism found in many legal frameworks, most prominently in the DMCA in the United States. These measures taken by the platforms must be proportionate to the objective of ensuring the unavailability on infringing content. This means that platforms are not expected to employ overly burdensome or technologically unfeasible measures. The measures must be balanced against the need to protect users' fundamental rights, and the platforms cannot be held liable if the measures required would be disproportionate. And these limitations are designed to create a balanced approach where platforms are held responsible for preventing copyright infringement, but are not subjected to unrealistic and overly burdensome requirements. And the idea is to protect both the right holders and the public interest, including the rights of the user's rights to free expression and access to information. And lastly, we have there is an exemption for startup and smaller platforms that don't have to, if you fit into that category, you don't have to fulfill the same obligations as the larger and more established platforms. It's fair to say that what finally became Article 17, it was Article 13 for a long time, I remember, is the most discussed provision of the copyright in the Digital Single Market Directive. And the article was subject to extensive discussion, extensive lobbying, and extensive rewrites before its final version was adopted. And this has resulted in a provision that in itself is complicated, even by the standard of EU legislation. Article 17 is in principle a fully harmonizing provision that on its face leaves little discretion to its member states. The problem is that the wording of the article contains a high degree of general terms that member states can specify when they incorporate the article into their national laws, as long as they do not compromise the objective of the provision and comply with the requirements for fundamental rights. And this has led to a flurry of different approaches when implementing Article 17. Some member states have opted for a near translation of the directive. Sadly, I must say Norway is, or to be exact, the Norwegian proposal for the implementation of Article 17 is such it's also such an implementation by translation. I see that Germany has chosen another route, and I think, I mean, if we can discuss the end result, but I think it's commendable that you have that Germany at least have tried to implement Article 17 in a way that makes some choices and leaves less room for interpretation from national courts. Of course, this differing level of implementation poses several problems, because vague terms in the directive, they literally scream for a more specific implementation on the national level. And the Commission basically admits that such in their guidance to Article 17. They see that the directive itself is not enough. You have to make some choices at the national level. And by not doing so, you also put the aimed harmonization of Article 17 at risk, because you have different degrees of vagueness from country to country. And until, of course, we will perhaps in 5-10 years' time, get some clarification from the Court of Justice of the European Union. But until such clarification comes, there is also considerable risk that the platforms themselves are left uncertain to what their obligation under Article 17 is. A novelty in Article 17 compared to earlier platform regulations is a specific focus on the right of end users. This is implemented in Article 17, number 7, that states that non-infringing works shall stay available. Article 17, number 9, has a so-called put-back clause that requires the platforms to put back, so to say, content they have taken down for allegedly being infringement. And these obligations to protect users' rights are elaborated on in a recent case where Poland claimed that the directive was, or Article 17 of the directive, contravened with EU law and had to be nullified, where the Court of Justice says that the article stands, but they also emphasize that platforms must take appropriate and proportionate measures to avoid unauthorized contents, but at the same time to prevent overblocking of legal content. And the question is, how will platforms respond to this? Because in my opinion, the platforms will primarily aim to avoid liability, and the most straightforward way to do this would be to get an authorization from the right holders. And as I said, if the platforms haven't acquired such an authorization, it can still avoid liability by removing infringing content. The problem is that this vagueness of the directive and the vagueness of implementation in several member states will leave a room for, at least until there is court decision on this, will leave room for the platforms to interpret their obligations to protect users' right. And I think it's reasonable to assume that this would give the platforms an incentive to acquire authorization from large right holders, especially for content that is popular, but then block content from smaller right holders upon getting a takedown request. In addition, it's fair to assume that the users' incentives in many cases will also point towards compliance, because if you have a channel on YouTube with a substantial amount of subscribers, you would want to keep those subscribers, and then instead of challenging a takedown and risking the suspension of your channel, users that provide a significant amount of content will tend to just comply, take down the content, put it back up again without the infringing material, and then go on to produce and publish new content. To conclude the initial question on the title of my presentation, is Article 17 too much or not enough? I think the answer might be both. It's probably too much when it comes to enforcing right holders' rights against users' rights. As it stands, the vague terms, the differing level of implementations probably gives, or likely gives, the platforms too large incentives to neglect users' rights. But at the same time, I would argue that that Article 17 is not enough, because the lack of harmonization makes it harder to enforce than it could have been. And this lack of harmonization possibly also makes it harder for platforms to comply with different regulations in different countries. And this is especially so because the enforcement of copyright takes place at the national level, and platforms usually disseminate their content to several different countries and will then have to comply with different liability regimes depending on which country their content is made available in. Thank you.
Hello, everyone. I have the great task to explain the Digital Services Act in 20 minutes. So this, I don't know whether you've read it, but I was told by the organizers to give those who are not fluent in DSA, as Martin has put it, a short overview what the DSA is about. And I want to start to explain the DSA in 5 tweets. So just imagine you've got spare money like 50 billion US dollar, not million, billions of US dollars. You've already built a space program that's better than most of states, and now you need a new challenge. So what do? Oh, you buy your own social network, and then you can send this epic tweet, the bird is freed. So meaning no more constraints than Twitter today, X, no more rules. Just, I mean, he was saying my rules, they still apply. And again, Elon Musk was saying, it was before he actually bought Twitter, and claimed to be a free speech absolutist. No more restrictions for free speech on Twitter or X, except if it concerns Musk himself, but that's another topic. And then again, third tweet, ultimately, I, Elon Musk, think there's no choice but for Twitter to be the final arbiter of truth, but I'm open to suggestions. Then just some minutes later, perhaps some days later, I can't remember, said, well, perhaps not too much free speech, and was saying, well, the freedom of speech is not the freedom of reach, and therefore negative hate tweets will be deboosted and demonetized, so no ads or other revenue to Twitter, and so on. You won't find the tweets unless you specifically seek it out, so it's basically shadow banning. And in a letter to advertisers, Musk explained that a bit more when free speech is great, but Twitter obviously cannot become a free-for-all hellscape. Our platform must be warm and welcoming to all. Hoping to attract some advertisers today. I mean, he's back to the hellhole of Twitter, now suing advertisers to launch advertising campaigns again on Twitter, but is seeing, well, one man can actually have a great impact on social media and have a great impact on the platforms on the that we actually communicate with. And so then there's another example. It's not Twitter, it's Indiegogo. It's a financing a campaign platform, and they were making it very clear. We may remove user content or cancel campaigns and refund contributions in our discretion. And it's in our sole discretion, whether to discuss the reasons for taking action against any user content or account. So basically they were saying, we are the king in our council and we do as we please. And Twitter had the same policy, but I couldn't find the exact word. They were basically saying, even before Musk, we do as we please. Bit more complicated, but basically saying that. And now there's the answer of the European Union with the Digital Services Act. And perhaps you know this epic tweet as well. In Europe, the bird will fly by our rules, DSA. So this is basically what the DSA is about. It's about accountability of platforms. That's basically what the DSA is about. And now that you're all on board, beginning to become fluent in DSA, I want to explain the goals of the functioning of the DSA in 2 slides, and then of course there will be tons of more slides. So the first is that the DSA is a toolbox of balancing interest. I mean, Martin was already saying earlier, I mean, it wasn't true that there was no regulation at all of platforms. There were a lot of regulations, national regulations, and there were a lot of tools, but they were, you know, all over the place. Nobody really knew what was applicable and in which country it was applicable and what it actually meant. So this is what the DSA made. So the instruments on the table now. It's clear what kind of regulation is applicable to hosting providers, to platforms especially. So, and what is the deal? Well, we still have the liability exemptions. You're probably aware of the liability exemption of the e-commerce directive, saying basically as long as you don't know about illegal content of your users, you're not liable for that content. But what is new now is that in exchange for that liability exemption, there are due diligence obligations, detailed diligence obligations, which I will present to you in a moment. And the second new thing is that there's now clear public enforcement of those rules. So it's no longer up to the users, to the weak and individual users to enforce those rules, but now we have authorities, digital services coordinators of each member state in the Commission to enforce those rules. So actually those diligence obligations got some teeth. So let's go into it a little further. So the liability exemption stands. Platforms are basically not liable for third-party contents or contents of their users unless they are OCSSPs, which fall under the scope of Article 17 of the CDSM Directive, which we have just been presented. So the liability exemption is the former Article 14 of the e-commerce directive is now Article 6 of the DSA, so they are not liable until they actually have knowledge of illegal activity or illegal content, as long as the platform remains neutral. Well, we still have that there's no general monitoring obligation, and platforms are not obliged to actively seek for facts or circumstances indicating illegal activity. And the Good Samaritan rule, which was presented by the CJEU in the YouTube judgment, has now been incorporated into Article 7 of the DSA, which means implementing technological measures aimed at detecting illegal content does not mean that the operator plays an active role in sense of Article 6. So this is the liability exemption, and now comes the interesting part of the DSA. The liability exemption comes in exchange for diligence obligations, public oversight, and civil society oversight, amongst other rules, but I have only 20 minutes. I was just kidding, saying, so are we talking about the DSA for 2 days and I get half a day? And I was saying, no, 20 minutes, okay. So we have diligence obligation towards illegal content, and then there are diligence obligations towards content moderation under their own terms and conditions. And I start with illegal content. So we have like 3 main points I would like to make. So they have to make sure that they protect the rights of users and third parties by procedure. So procedure is a very important aspect of the DSA. It's mostly about procedure, and procedure are aimed to protect rights. Second, there's transparency, and third, there's the obligation to have due regard to the stakeholder interest, especially of the users. So the first procedural obligation is that they have to install a user-friendly notice procedure mechanism in Article 16.1. And in Article 16.6, there's the obligation to decide about those, to process and decide timely and diligently, and at the same time considering legitimate interest of stakeholders, especially conflicting fundamental rights. So going back, and of course, there's also for very large online platforms and search engines the obligation to assess and mitigate systemic risks. And one of those systemic risks are risk for fundamental rights and risks stemming from illegal content. And then, and that's new again, remember this Indiegogo statement where it's at their discretion whether they inform users at all about any demotion and any shadow banning. Now they are obligated to give a statement of reasons if they moderate content, and they have to inform the flaggers as well, those flaggers who have given notice about supposedly illegal content. So there's the first bit of transparency, individual transparency. But there's also the obligation to submit those notices into a public database, which we can all access now and is giving us really interesting insight. And they have to make a yearly public report on a notice and action mechanism, and very large online platforms have to give those reports twice a year. So there's a lot of transparency. And the procedure goes on. There's more procedure. The platform's obligated to install an internal complaint procedure, free of cost, online, user-friendly, and some more adjective. And there's an obligation to reverse unfounded decision. So there's a putback obligation in Article 24. So if they cannot base their decision either on state law, applicable state law, or on their own terms of conditions, they have to reverse their decision. And if they, for example, decided not to take action and the content actually is infringing, then they are obliged to take action. So it's a notice and action mechanism. They are obligated to participate in out-of-court dispute settlements, but only to participate. Those rulings are not binding. And then concerned parties can see state courts at any stage, which has been clarified in recital 59, sentence 6. So therefore, I think, Martin, recitals are actually quite helpful sometimes, at least. Okay, let's move on. So is Elon Musk right to be a free speech absolutist? Well, I don't think so, because if free speech is infringing rights, and of course we have to balance the different fundamental rights in that aspect, but if we come to the conclusion that the speech is infringing rights, then free speech has to go back behind, for example, personality rights and so on. So great that he favors free speech, but he cannot be a free speech absolutist anymore. And Twitter is not the final arbiter of truth, but state courts can decide whether content is illegal or not, and they do have the final words. Great, 5 minutes, I'll get that. So the second interesting thing is about terms and conditions, because let's have a look at these great resources of the public database. This is the TikTok statement of May and June 24, so of this year. And the interesting thing is what you cannot see, and that's content that has been removed by Twitter due to notices due to of illegal content. So it's less than 1% of the takedown actions are based on illegal content. That means more than 99% of their removal decisions are based on their terms and conditions. And therefore, we probably, although it's really, really interesting, we shouldn't worry too much about illegal content, but we should worry about terms and conditions. And there we find some provisions in the Digital Services Act as well. So the first point is self-constraint. Article 14 of the DSA says in paragraph 1, well, there is freedom to operate business, there's a freedom of contract. So platforms can, of course, put up their own terms and conditions and say what they want on their platform and what they do not want on their platform. That's their right to do, but they have to do so. They have to actually say what they want and what they do not want and how they want to restrict content and based on which rules they want and based on which requirements they want to restrict content. And then they have to stick to it. So they once have to pull up and then stick to it. And if they want to change it, they have to make public, inform their users about the changes. So I think that's a very important rule. So therefore, they cannot remove user content based on their own discretion, but now they have to make up rules and stick to their rules. And a rule that we just may take down any content based on our discretion that wouldn't be transparent and user-friendly. And furthermore, Article 14.4, the application and enforcement of terms and conditions, and in mine, I think Martin's view as well, the design of those terms and conditions, they have to be diligent, proportionate, they have to take due regard to legitimate interest of all parties involved, especially their fundamental rights. So VLOPs and VLOSes have to assess and mitigate systemic risks. That's the same. We have the same transparency requirements, and we have the same complaint procedure out of court, dispute settlement, and of course, concerned parties can always seize state courts, mainly based on contractual rights, which are now specified by Article 14 and Article 20. So those are the constraints, the accountability of platforms. What more? There's the tiered approach, which we just heard from Torger. So there are different rules for different kinds of hosting providers. There are different rules for different sizes of platform providers. So that's an overarching systematics. Or here you can see this tiered approach down to article level. Then we have this public oversight I was introducing just before. So it's in chapter 4. The European Commission has learned a great lot from the GDPR. So there's strong enforcement, strong public enforcement. So I think that was really effective. There's, of course, the island problem in the GDPR, and they've learned from that. So it's no longer island accountable for all those VLOPs and VLOSes, but it's now the Commission. And we have a subsidiary competence of the national service coordinators to impose those rules. So I think that's great learning. And again, we have a board of all the digital services coordinators where they can meet and strategize and find solutions for some of the unclearer provisions. Last point I want to make, there's civil society oversight. So we've trusted flaggers. The notices of trusted flaggers have to be processed with priority. We have transparency, which enables public society actors to make suggestions, to criticize. So we have the public database we can analyze. We have data access for vetted researchers. And there's the possibility of representing, or users can choose to be represented by bodies, organizations, or associations, and those complaints have to be processed with priority as well. So that's, I don't know how many pages, 200 pages. Nearly 300 pages of DSA in 20 minutes. Looking forward to discuss that with you, and thank you.
Okay, and leave the rest. Good afternoon, everyone. A bit of a warning, I'm not an academic, I'm an enforcer, so I'm from the European Commission, as Thomas said. So sometimes my view is a bit specific on our day-to-day work, and that's why it's very nice to be here and have a bit more of a general overview. A quick disclaimer, so I'm speaking here in a personal capacity, and everything I say does not represent the official position of my employer, the European Commission. I'll be introducing the Digital Markets Act, which is in a way the sister regulation to the DSA, which Benjamin just introduced. And maybe to start with a bit, why did the Commission come up with the DMA? In a way, the reasons you can find them in the characteristics of the digital economy. So what we have observed over years and years of competition law enforcement practice is that, and maybe start here on the left bottom, that there's a significant market power by these digital companies, that they benefit from significant economies of scale, from network effects, which means the more users that you have, the stronger you get, the more attractive you become to further users. So these kind of elements really entrenched the position of a few large digital platforms. And once they're entrenched, it's very, very difficult to curb that behavior or to enter into these markets. So this concentration is one of the issues that we observed. The other one is that the role of data plays, because all these effects that I mentioned, they're really often based on data, because the accumulation of data, the network effects, the more user you have, all this enhances or makes the position of these platforms stronger. We also observed that these gatekeepers have grown through a number of strategic acquisitions, again, which made it difficult for smaller companies to grow. And there was a bit of a feeling that, which was also based on a public report commissioned by Commissioner Vestager in 2019, which showed that the traditional competition law enforcement is not always sufficient to tackle these problems. Often these procedures are too long, they only come in ex post, they have certain conditions, which I will explain in a while. So there was the feeling that we need a bit of a targeted tool which really addresses these very specific gatekeeper practices and problems that we observe. And so that's the role of the DMA. So the DMA, the objectives of the DMA are really to increase innovation and consumer choice on the one side, and make markets more contestable, meaning that it is easier for smaller companies to compete with these digital players in the main markets, but also in adjacent markets. There's also a bit the idea that through their market power, gatekeepers were able to impose unfair practices, be it on smaller business users or on end users, consumers, and these should also be addressed in a systematic manner. And finally, the idea is to have a coherent approach within the EU and to avoid fragmentation between different member states. So these objectives then led to the okay, here the slide is a bit messy, to the implementation of the DMA. So the overall goal of the DMA is to make digital markets more fair and more contestable. So under that rule, it has 4 different ways of working. The first is that the DMA is very, very focused. It's more focused than I think all the other regulations that we talked about before. It's even more focused than the DSA. It really focuses on a handful of gatekeepers, which have a very, very significant power, and on a number of core platform services. So these core platform services are, for example, online search engines or operating systems, and they've been selected on the basis of that these services or these products where we really saw these contestability problems before most strikingly. So that's the focus, and then companies are designated based on the number of quantitative and qualitative criteria. It's essentially turnover, market capitalization, and user numbers. So you need 45 million end users in the EU and 10,000 business users in the EU. And once you meet these thresholds, you will be designated and have to follow the rules of the DMA. So that's the scope part. Then the DMA prescribes a number of obligations ex ante, which we believe are very clear. It's really very targeted, very specific rules, which should be self-enforceable. Also, yeah, I think that's the idea. What we then have is a comprehensive set of remedies, which include structural remedies. So that's a bit borrowed from competition law enforcement. It's market investigations, it's fining decisions, it's penalty payments, but also structural remedies. For example, if a gatekeeper has several non-compliance decisions, we can impose remedies, which can be, for example, a ban on M&A activity, or eventually, not very likely, a breakup. And all of this complements competition law and sectoral regulations. So it's really a new complementary tool to what we have seen before, but a bit more on that later. So this slide is a bit prettier. So what we did last year is we basically designated, we followed these criteria that I just mentioned, looked at the companies had to notify, and then we looked at it and designated by September most of these gatekeepers. So the gatekeepers are the companies. Now we have 7. Just a side note, booking was added this year because they only met the thresholds this year. But all the other companies were designated last year. For the services which you see on the right side of the slide. So here you see really the big services that you know. I mean, you have the big online social networking services. You have intermediation services, which basically intermediate between end users and business users. The app stores are a very big part of that. You have ad services, browsers, and operating systems, also very, very important, in particular the mobile operating systems, iOS and Google Android. So that, I mean, the legislator thought this would be just an easy task to kind of do a tick the box thing. In the end, it was a bit more complicated because we had to decide, how do you count business users? How do you count end users? How do you remove duplicates? How do you separate certain services from other ones? So for example, do you have one app store across different devices? So is there one Apple App Store, or is there an Apple App Store for iPhones, an Apple App Store for the iPad, for the Mac? So these kind of questions, I mean, there we concluded that it's one App Store because the App Store always has the same job of intermediating app sales. So these things were something we did, but that's hopefully, I mean, that's done for now. Of course, if certain services gain more users, then they could be designated in the future, but that's a bit the scope that we are working with now. And now I'm not going through all the obligations, but instead what we have done is we've opened a number of non-compliance cases a couple of weeks after the compliance started to kick in. So the compliance date for most of the services was the 7th of March of this year. We opened these cases on, I think, the 25th of March. Yes. And that also shows a bit the speed, because I think that's also one of the ideas that the DMA wants. It wants to be fast. Competition law, antitrust cases always took years and years, but here we really wanted to be fast. And we've been discussing with these gatekeepers, and we saw clear examples in our view where there's a risk that what the gatekeeper does, that it does not comply with the DMA. So currently we have 3 open cases against Apple. The first one is on the steering rules in Apple's App Store. Steering basically means what apps can show in their app. So if they can steer the user of an app to offers outside of the app. So if you want a cheaper Spotify subscription, which you can conclude outside of the app, back in the day, that was not allowed under the Spotify Apple app, but according to 5.4, that needs to be possible. The idea, of course, that if you offer something outside of the App Store, you can avoid the fees that Apple charges if a transaction is mediated through the App Store. There we have already adopted preliminary findings, which is a bit of a preliminary finding of non-compliance. Those we sent to Apple this summer. The second one is the choice screen that you see on your iPhone, which basically needs to enable you to choose the browser that you, or needs to present you with different choices for the browser, and not just automatically push you to Apple's own browser, Safari. That we have opened. You might have seen last week, Apple has announced certain changes there to its plans. So there's some movement. We haven't adopted preliminary findings as of yet. It also links to certain default settings and pre-installation settings. The idea here, again, is that smaller or other browser players or other apps have a fair chance at being open to customers or to users of the iPhone. The last one is on 6.4. That article is wrong on the slide. That's on alternative app distribution. It basically means that customers or that end users can download apps outside of the App Store. That can be a third-party app store, or it can be a direct download in the web. Again, this Apple has introduced certain plans to make that possible, but it's linked to very, very strict commercial and technical conditions, and these we are currently assessing whether they would be in line with effective compliance with that obligation. Alphabet or Google, two non-compliance investigation. It's here the number 4 is very, very similar to, the issues are a bit different, but the core idea is a bit the same. Again, how can app developers steer users of an app downloaded via Google's Play Store? And there we have certain concerns that that's not compliant with Article 5.4. And then another case, which is a very Alphabet one, and that's the one on Google Search, self-preferencing, so that Google preferences its own services. It can be a flight search, it can be a shopping search. How does Google preference these things? There we are also opened to see whether that's really in compliance with Article 6.5. The last one is on Meta. So for Meta, the question is really, it's a data-related obligation under 5.2, which basically dissuades gatekeepers from combining data across services. What Meta does is to combine data between its services, for example, Facebook and Instagram. It has now offered, or it offers the solution to essentially consent to that data combination or to pay a fee of 10 euros. And then they would not combine that data. So the question is, does this binary choice between paying 10 euros, which very few people do, or allowing the combination of data, is that really a proper choice that Meta offers its customers? So these are the open non-compliance cases. In addition to that, we have a lot of what we call an ongoing regulatory dialogue. So we meet these gatekeepers a lot on a very deep technical level and discuss their compliance solutions. And what we also try to do is really push for solutions which, in our view, go a bit more into the compliance direction without always having the need to open a non-compliance case, which is very resource intense because it requires a lot of procedural steps. So the idea is really, it's a bit of a mindset change for us at DG Comp, because we're used to these big cases, which are always very adversarial. Here, the idea is really in a dialogue to understand where the gatekeeper comes from and find solutions, or show them solutions which could be, in our view, a bit more compliant with the DMA. One thing which is always, and which our view is quite important, which also goes to a bit our topic today, is, so how does the DMA compare to traditional competition law? For us, it's a complementary tool. It's without prejudice to competition law. And there are significant differences which also explain how both have a role to play. So competition law is always enforced retroactively, whereas the DMA sets ex-ante obligations. Competition law applies more horizontally to all markets and all situations and companies, whereas the DMA only applies specifically to core platform services and to gatekeepers. Also, competition law allows for more broad theories of harm, whereas the DMA has very narrowly defined obligations which are inspired by our competition law enforcement, but are again very, very narrow. Competition law always, there we always need to define markets. We need to show dominance under Article 102. We also need to show negative effects on competition. This kind of analysis we don't need anymore under the DMA, because there the presumption of gatekeeper power comes once the thresholds are met. So this is a bit the differences between competition law and DMA. As I said, so the DMA is really inspired by our competition law enforcement. And we also see in practice that it works. So, for example, we have the Google AdTech case, which really addresses certain practices by Google and combining its different advertising services. And these practices are not captured by the DMA, but we are investigating whether there could be abuse of dominance under Article 102. So this is something where we believe that competition law really still has its merits in this digital markets, because it can really go after new practices, new services, which are not covered under the very narrowly defined DMA. At the same time, on the national level, so Article 1.6 of the DMA says that for national investigations, NCAs cannot go after behavior which is covered by the DMA, but they can go further again if they want to address a behavior which goes beyond the obligations or beyond a service which has not been designated. They can do that. For example, the German NCA, the Bundeskartellamt, recently adopted a decision on Google's automotive operating system and on certain combination practices. Again, that's something which is not covered by the DMA because we did not designate Google's automotive operating system. So I think we see in practice that it actually works. The last very colorful slide, and I think we can discuss it a bit more here, is really how does the DMA fit into it? We really see it as a very specific complementary tool, which, for example, Benjamin just outlined the DSA. It has a different focus. So the DMA really looks at these platform and market failures, whereas the DSA looks a bit more on fundamental rights, on the content. And the same thing with the GDPR. So the obligations of the GDPR, there are some definitions which are the same under the GDPR. For example, under 5.2, we rely on the same definitions, but overall, we don't really observe a clash. And also, it came up that because we really talk a lot also to our colleagues, to our DSA colleagues, we sit at the same floor. So we really discuss, how do we tackle certain things here? What does it mean for the investigations under the DSA? We talk to our colleagues at DG Just. So there is a lot of cooperation. And maybe I just leave it. One thing which is a bit new, and I think that's the AI Act, because there are a lot of questions how AI practices are covered under the DMA. They're not specifically covered by the DMA, but of course, if AI services are adjacent to a core platform service, for example, a search engine or a voice assistant, then they would fall under the scope. And the AI Act also has a bit, the AI Act for us is a bit more of a product of a product legislation, which also follows a bit of a different legislative framework. So it's different, and again, complements the rule of the work that we do on the DMA. So that was a bit of a nutshell. I'm happy to discuss with the other panelists. Thanks a lot.
Let someone sit in the middle.
Mike, you want to sit on the edge? See all of us.
Okay.
He's
Sure.
Oh, you put the book.
Yeah, that's Tom Cruise.
So, thank you very much. Invigorating. I understood from discussions over the lunch break that we're going to see a bunch of questions from you folks there in the audience, and we've already received a couple rather long questions I've just laid eyes on from the online audience. So at some point I may have to read them before I can address them to the group here. I have suggested a few very general questions that sort of relate to the theme of the conference, which maybe can bring together what you guys have been saying. And maybe I can just throw these series of questions at you all in one go, and then you could just have a go at addressing them. So how do these pieces of legislation that you guys have addressed, how do they fit into the broader puzzle? of the EU digital legislation, the regulation and other pieces of legislations that we've been talking about here today. And how do these three pieces, to the extent they do fit at all together, how do they fit together? Are there any ways in which they're complementary? How do their goals fit together? And are they inconsistent in any way? I'm sure you have an answer to that one, and I can guess what it is, but perhaps you other two have some perspectives on whether there are any inconsistencies. So maybe you could just have a go at those questions generally, and then we can throw it open to a broader discussion. And I'll have time to read the questions in the audience.
Should we perhaps start talking about DSM Directive and the DSA, because I think there are a lot of common goals and perhaps discrepancies, or
yeah, and it's clear that they regulate much of the same area. Of course, the CDSM Directive is more narrow; it's lex specialis for copyrighted content, but it's clear that also the online platforms that are regulated by the Article 17 of the CDSM Directive also have obligations according to the DSA Directive for other content they may communicate.
Yeah. So it's just basically the lex specialis for the illegal content moderation. So the most interesting question is there's these without prejudice clause, and I'm not sure, is it Article 2 of the DSA? Somewhere it says the DSA without prejudice to copyright, especially to the CDSM Directive. And then the question is, I mean, there are some safeguards in Article 17. I mean, there must be a complaint procedure, there must be have out of court dispute settlement. And then the question is, can the member states maintain their own concepts? So, for example, in the German implementation of Article 17, the URDAC, there's a complaint procedure, there's out of court dispute settlement procedures, which are different from the DSA. So the question now is whether Article 21 of the DSA, the out of court dispute resolution, whether that trumps the national implementation, or whether national implementations can be maintained based on this no prejudice clause. So I'm not sure, Martin, where's Martin? There's Martin. Have you written an article? Was it Raue? I think it was Raue who's written an article about it. Unfortunately, he's not here. But I would say, I mean, now we've harmonized rules, specific rules in the DSA, and somewhere in the recitals it says, well, if the DSA is the more specific regulation, then it should prevail over the generally more specific regulation. So why should each member state have an out-of-court dispute resolution procedure, a complaint procedure for the DSA and for the CDSM Directive? So we were talking in June Langtbreit that in Norway it's now being implemented. Do you know which way you're going here in Norway?
We are at the moment, we haven't implemented any of these acts or the directive, but the proposed implementation of Article 17 is like it's basically a translation of the directive. It's structured somewhat different, but it's a translation that very little effort to try to define what's the more specific essence content of the provisions of the directive. And I think that basically the Norwegian Ministry of Culture just wants to legislate a provision that is CGEU or EFTA court proof. So whatever the Court of Justice comes to in the future, it can be interpreted within the legislation. So
that's very modern.
Yeah, but in the meantime, it's very hard to interpret what the provision really means. So, but probably Norway would then probably lean more on the DSA, which has more specific rules, because we have no we have no, or it's at least not proposed to implement any specific rule on how on specific procedures for according to Article 17 of the CDSM directive, whereas the DSA will be implemented wholesale as it's a regulation. So we might lean on those rules because we have no specific rules for moderating copyrighted content.
That's probably the disadvantage if you've got this very far-reaching implementation, this over-implementation, and then you have a set of rules and you don't want to get rid of it 2 years after you've actively fought to implement it. So that's probably one of the learnings from that implementation. Yes.
And Alexandra, you mentioned that you sit near the folks responsible for the DSA. Can you reveal any of your discussions? Or at least the topics of your discussions, if you're discussing relationship between the DMA and the DSA?
I think first, what we discuss a lot is procedural things, because a lot of procedural things, such as market investigations, are very, very similar, because the tools are inspired by the antitrust rules, even under the DSA. The DSA, of course, has a bit of a different scope and purpose, as we said. I mean, one thing, for example, which I think on Benjamin's presentation, we talked a lot about Twitter or X, where you could say, there's really on the content moderation, on the liability, what is published there. I think it's a huge thing under the DSA, also evidenced by the enforcement action that the colleagues have done. Whereas under the DMA, you saw it wasn't on the slide. It's currently under investigation whether X should be designated. There the question is more, and that shows a different angle, is X really a core platform service, a gateway which business users need to use end users? Because that's really the DMA definition. So, and then the comparison, if you say, okay, you have an app store, that of course, as a developer, you need access to that app store to reach your customers to distribute the apps. But as a business, do you really rely on X maybe to broadcast your latest information for ads? But is it really enough to constitute a gateway? And I think these are questions we are currently asking ourselves, and they show a bit the different scope between both instruments, and also that they have a different and separate purpose. I think, of course, the official answer is we believe all these instruments are very much complementary. The orders are very, very clear. But I think, so far also in our work, we don't see so much tension. I mean, you see, for example, if you look at advertising services, there the idea under the DMA, I mean, they're also covered under the DSA. Under the DMA, it's a bit more transparency for business users. And under the DSA, it's a bit more control for end users. So again, it's the same service, but it's different sides of maybe the same coin. And I think for the copyright directive, for us, it's in a way even clearer, because we say the DMA does not tackle any copyright related issues. Again, I try to look a bit for a thing where it could be a bit, where there could be, let's see, a bit of a closeness of overlap. For example, under 612, you as a business users, you have the right on friend terms, fair, reasonable, and non-discriminatory terms, access to the services of a search engine, which could also include remuneration for your copyright or your copyrighted materials. But again, that does not modify Article 15, which basically also gives you that right of remuneration. I think you might need to bring those two together, but they don't really interfere and supersede each other. I think that's a bit our view that we see.
Torger, Benjamin, do you have any questions of Alex? You see any ways in which the areas for which you're responsible, if I might just put it generally that way, conflict with, are complementary to the DSA? Any questions you generally want to address to Alex?
Perhaps first another question towards Torger, because you were raising the concern, and that was one of the main concerns of Article 17, the chilling effect on lawful speech. So that was the huge debate, and interestingly enough, that there wasn't such a big debate when the DSA was implemented. And I mean, there's as well this notice and action mechanism, So where was the discussion there? And I mean, the core difference between Article 17 and the DSA is that there's this liability exemption, so where the which does not apply to the OC SSPs. But the question is, again, they have to take action. So either decide whether they leave the content online or they take it down. And there again is the question about the chilling effects. So, well, the question is what safeguards of Article 17 and especially of the Poland ruling can be transferred to the DSA. Any thoughts on that? I mean, the safeguards, so the obligation of results. So if it's lawful speech, then platforms need to keep it up. And the obligation to take down copyright infringing content is just an obligation of means. So if there's a hierarchy of those obligations, then probably the obligation of results win. The question is, does that apply to the DSA as well? So real question mark.
I'm not sure. I think might a difference between DSA and DSM be the possible sanctions for the platforms, because in my view the main concerns for platforms when it comes to copyrighted content will be to avoid liability, and if they can't do that by licensing, they will do it by blocking. But when it comes to content that is, say, whether users are protected by the DSA, you don't have that sort of Damocles hanging over you in the background, because there is no basic liability if you don't take down this content. So the chilling effect might be even higher for copyrighted content, because the platforms don't want to, they want to avoid liability, and they have incentives to set up their business models to avoid liability. I don't think that answered your question, but
that's a great answer. Perhaps the best answer we can have yet. Yeah.
Maybe I could follow up that question with a question to Pam. The putback regime, which I was lobbying for in the context of the e-commerce directive, but failed. In the US, there's obviously been, for quite some time now, since the DMCA was adopted, a putback rule. How much has it been used? Has it been effective? Does it actually ameliorate the concern about limitations on free speech? Simple question.
The ball is coming.
So I'm the only American that I know who cares about Article 17. To be frank, we don't pay any attention to it at all among the copyright professionals. The DSA we're paying more attention to, partly because the American firms are having to comply with that. So I think Article 17 doesn't apply to all that many companies, and so they are already doing a lot proactively in terms of licensing, and also proactively in terms of filtering and the like with systems like Content ID. That's the main reason to ignore Article 17 in the US. There's no effort whatsoever to consider an Article 17-like thing in the US. So there was some interest on the part of Tillis and Coons, two senators, in revisiting the DMCA safe harbors, and that happened in 2020. And nothing has happened since then, and that's most of us consider that's a good thing. Now, in terms of the DSA, I will say that Berkeley Law School had a conference co-organized with the Information Law Institute at University of Amsterdam about the DSA, and we had tutorials because Americans just don't understand it at all. They think it just imposes a lot of costs without really all that much benefit. And the reaction of the professors who were at the conference was, the DSA is unteachable. So because it's unteachable, we won't try to teach it. So that's actually, I think, the DMA. I think it's really the competition law, antitrust people who are paying more attention to that than the IP or other tech people. But of course, some of these new cases that are under investigation will get a lot of attention. But I think most of that attention will come from the antitrust lawyers and not from who are skeptical about, maybe you should define the market. Maybe there should be actually some true effort to identify antitrust harms. So we're, I think, more skeptical that, oh, gee, this lighter touch thing is going to be highly beneficial to competition. But of course, it remains to be seen. Sorry if that's
They don't realize that it's not antitrust.
Throwing a bomb in the direction.
If I perhaps could just add one remark, what I found really interesting about Article 17 was in the beginning, when it was still Article 13 in the Commission proposal, was all about enforcing copyright, to make a stronger copyright enforcement. And then in the legislative process, it was all about user rights. And so for the first time, there are actually user rights in a copyright instrument of the European Union, and now it has been even stronger implemented into the DSA. So this was interesting. It started to make copyright enforcement better, and now we've got this user perspective. So that's really interesting.
And do either of you or any of you think that the putback mechanism, I come back to my question, is going to be effective? Will it help address concerns about limitations on freedom of expression in particular? Will it work?
I think it depends on the implementation on the national level. Is there and that's basically procedural. Because that what strikes me about especially Article 17 and also the general copyright exceptions in the Husovec Directive. Materially, they are pretty good. We haven't seen. We'll get a decision from Court of Justice on the exception for prestige soon. Hopefully, that would explain in more detail what that is. And I think the material rules are pretty good for users, but what probably lacks is the procedure to enforce those rights. And even if there is a putback clause, a putback right, I'm not sure that the procedural rules as they stand now and as they are implemented in the member states are enough to enforce that right effectively for the users.
Sounds right to me. Okay, we should move on to the audience, but I wonder if Vilde could help me, because the questions from the online people have disappeared from the screen. Martin, yeah, I saw you first, and then we'll come back.
Thank you. I have a question, I think, for everyone. Alex, I wonder, so both DMA and DSA take procedural rules for the enforcement from competition law. Isn't that framing a little bit problematic? Competition law was all about ex post. This is supposed to be ex-ante regulation, supposed to be a lot about talking to companies to persuade them first and to coerce them exceptionally when you cannot persuade them. is the current setup, the way that you have taken it from competition law, good for that? Aren't you seeing the limits, that the instruments that you have are too tiered towards enforcing, sort of ex post kind of situation? Is this a good way how to do ex-ante type of enforcement, which I think applies to both to DMA as well as DSA, right? So DSA, I think, if you want compliance on DSA, you need to apply 99% persuasion and 1% enforcement, because there's no way you can enforce everything. It's just way too much, even for VLOPs. And I think DMA has perhaps even more of the problem. The question about the DSA in EA countries, what's the situation now? What exactly is happening? Who will be responsible? And finally, Germany and the DSA, so URDAC and the DSA German implementation. What's the majority view? What's Benjamin's view on which parts of the URDAC do not apply post DSA and need to be set aside, irrespective of what the legislature does, because there's a priority of the EU law? Thank you.
I can answer the short question first. Implementing DSA in EA countries, especially Norway, we're working on it. I'm not sure exactly where it stands, but I will check it up and give you an update during dinner.
It's underway.
Okay, I take them. I mean, I think very good point. I would say so I think we have two things. I mean, first we have the existing or the tools which we borrowed from competition law. I think they work in the non-compliance setting to a certain extent, but of course they're not always the fastest one. So I think I personally, and it's some things, for example, if we want to adopt interim measures, which should be fast, we still need to adopt preliminary findings, we need to give access to file, which are these things which we borrowed from competition law, and I think they make it sometimes a bit slow. So we see that they help us because they're things which we are used to. But on the speed side of things, I think it might not be the most efficient thing. But of course, I think what I said, we have a bit more these informal contexts where I think we can apply more pressure. And we have a few instruments. I mean, one thing which, is sometimes overlooked, and in Article 8, you have what we call the specification proceedings. So for certain obligations, we can, upon our initiative, or a gatekeeper can ask for it to specify an obligation and explain in more detail what we believe is the right thing for the gatekeeper to do in order to comply with that. So I think that's quite a nice tool, which we didn't have before, to actually achieve change on the ground quite quickly. So I think that's nice. We've adopted retention orders, which we didn't have before, which basically obliges gatekeepers to retain documents, which we can then request. So I think there are a few new tools, which actually are quite nice. But yeah, it's a bit of a balance of using the experience that we have, but maybe to the detriment of speed sometimes.
You had a question here, number 2.
Sorry. Thank you. Alexander Peukert, I would like to get back to Martin's very interesting observation that all of this is about shifting power also to the individual. And my question to the 3 panelists is, where is the individual? And I understand Martin distinguishing the individual from the business. Where's the individual author in Article 17? Where's the individual ex-user in the DSA? And where's the individual business in the DMA? Also in light of the fact that the enforcement, in particular of the DSA and the DMA is obvious, is not private. And the DSA private enforcement, I don't know whether you... So that's also a question I would have raised with regard to Martin's excellent presentation. I couldn't, and also perhaps... well, yes, Article 54, but that is very limited and complicated. Okay. So my question, where's the individual?
Perhaps I can start with the DSA. I mean, if the users usually have a contractual relation to the platform, and there's a putback, at least under German contract law, there's a putback obligation. So if they have not fulfilled their primary obligation to put up content, and relying either on the terms of conditions or saying it's illegal content, if it's not, then there's a contractual obligation to put back put back the content. There's the ruling of the German Bundesgerichtshof saying that, and I don't think anything has changed under the DSA. Especially there's Article 24, which explicitly says if a platform cannot rely the content moderation either on law or on terms and condition, they have to reverse their decision. So there's actually a putback claim, a statutory putback claim, and I think you wouldn't need Article 54 to enforce it, although I think Article 54 supports those claims. I mean, that's perhaps a bit of creative interpretation of Article 54, but I think there are instruments for individuals. And perhaps to answer Martin's question from before, so what about the clash between the German URDAG and the DSA? I think we can talk all day about it, but to put it in short, all the mechanisms which are based on 17.4, so the best efforts obligation to not have illegal content or copyright infringing content, that's specific Article 17 specific copyright legislation. So that's without prejudice to the DSA. I would say all the mechanism to ensure that legal content stays online. That's basically DSA. So the notice mechanism as such, the complaint procedure is much more specific, and the DSA out of court dispute settlements much more detailed. So all this should prevail over national legislation. But
just to add to for Alexander, wettbewerbs in Bergen in Germany, 2 cases, Timo and Etsy. And also considering in the Netherlands first case of a user suing from contractual claims, basically in a way that as Germany kind of derived earlier, also on the basis of the DSA. So private enforcement will be a thing. Mark my words. Yeah. And also for DMA. I also think for DMA. No, this is individual. The last one is individual.
Briefly address the question. I mean, it's direct business users, I think it would be the private plaintiffs.
It's 2 things. So, I mean, I think first, private enforcement is possible. We see first cases. We also hope and expect that it will take up. And, you know, the idea behind the DMA is really that we are not getting so involved. So the idea is really that these obligations are self-enforcing. And just to give an example, for example, you have Article 6.7, which mandates interoperability between an operating system and hardware features. So if I am a headphone manufacturer, I can go to Apple and say, look, I want the same magic pairing capabilities that you have with your AirPods. So I think that's really a bit of an enabler for a business user to enable him with the right to ask for the same interoperability functionality with the features of the iPhone. So I think it really does empower them. Is it that they always comply with it? I mean, I think that's when we get involved, and I think ideally we wouldn't, but that's unfortunately just the reality. And you also have certain end user rights. I mean, you can discuss about Article 5.2, which basically talks about the combination of data, which, well, that's an anomaly in the DMA or not, but it gives end users the choice whether they would want their data combined between, let's say, Facebook and Instagram. So I see the point, and I very much like the diagram, and I think we don't want that power. I think ideally we would push it a bit more further south towards the business users.
Might I answer the question regarding the individuals and Article 17?
Yeah.
Of course, as the end users or the users that publish content on the platforms, they are the focus on them is, as we both Benjamin and I pointed out, it's kind of a novelty in Article 17. Whether the regulation is enough, I don't think it is, but it's something to build upon. But I gather that your more specific question was the individual author and Article 17. And as I posited, the platforms will have an incentive to contract, to make licensing agreements with the large right holders, and then block the contents from smaller right holders when they get notices. And that of course means that smaller right holders will not get a payday. They will not get paid, so the value gap is still there for them. And I think there are possibly mechanisms to accommodate smaller right holders as well. We in the Nordic countries, we love this model of extended collective licenses, and now even in the another provision in the CDSM directive has like opened up for or started to regulate that for the EU as a whole. And I'm thinking that could be an interesting model for clearing content from smaller right holders for the use for platforms. I don't think we're there yet, but I think that would be an interesting model to explore, and that would help to secure the rights of individual authors to get paid under Article 17.
And perhaps that's a good link to one thing of the discussion of that Bernt raised, the remuneration rights for the text and data mining. I mean, if we're talking about remuneration, we probably need direct remuneration rights for authors. And again, the German transposition of the DSM directive, there are direct author remuneration rights, which have to be collected by the collective rights management societies. But still, there's some money coming directly to the authors and not just to the rights holders.
Yeah, maybe I could ask one question from the online audience. We don't want to ignore them. This is from Lars Edvard Storjord from the Norwegian Communications Authority. And he asked, how do you foresee the use of trusted flaggers under the DSA, for instance, regarding the misuse of copyright protected material? Will this be a successful provision to prevent distribution of illegal content?
I think so far very little trusted flagger have been appointed. I think in Germany the first one has been appointed or is about to be appointed. In Austria there's one trusted flagger. I don't know, Martin, do you have an overview of trusted flagger in other countries?
I think there are maybe 5, and I think 3 are copyright related.
Yeah, so I think it's too early to share any experiences, but hopes are high.
Okay. Will, do we have time for Bernt to ask? Oh, we have 2 questions. Okay, yeah. Bernt, maybe you were first. So I don't know which of you was first.
Quick question to Alexander. Oh, she was. She's first.
Yeah, go ahead. Bernt will be.
Yes, okay. So one question about DSA and GDPR. Would you say that DSA to some extent is trying to complement what the GDPR is missing? And actually, I think I started thinking about that, looking at, for example, children's right to data protection, because the GDPR, as we know, is extremely disappointing. I mean, pretty much there is nothing there apart from a very nice recital saying that children merit a specific right to data protection because they are special data subjects. And then, well, we have in DSA quite a lot about children and their rights in online environment. And then I came across a very interesting case from Amsterdam District Court from July, actually 2 cases. And this is a case which is like a treat for everyone who is a big fan of Elon Musk, in parentheses. So there was this Amsterdam-based privacy activist, a journalist, and he's also pursuing a PhD in law. And he's very active. I don't know, maybe you know the case. He's a very active user of X. And then he tweeted about this European proposal for regulating or trying to fight child pornography. And he was very critical about that because, in practice, chats of millions of people will be scanned only because we are trying to find those few who are actually into it. And then he tweeted that he was subject to shadow banning. And he didn't know about that because X didn't want to inform him. So he was only informed about other people. So then he complained that under DSA, so Article 17, amongst other things. And then he also filed a complaint under GDPR because of rights of access. So actually he won under the DSA And then the court confirmed that, yes, they have to provide proper information about that. He even got a kind of a compensation because he managed to argue that there was a breach of contract. He was a premium user of X. And then under the GDPR, they didn't want to give him access to what was actually happening with his personal data, because as X was claiming, well, not only he's a journalist, but he's also pursuing a PhD in individual automated decisions. And he was actually claiming that shadow banning is an individual automated decision. And then the court confirmed that it is. As with this type of decisions, they are prohibited under GDPR as a rule. And he also, and Twitter or X was subject to a fine. So would you say that they somehow complement each other? I'm not saying that that was the intention of the EU legislator, because I stopped believing in that there is any reason behind everything, because sometimes, I mean, things just happen when we have 3 EU legislators and everyone has different ideas. And as we heard from Martin, people drafting, they don't talk to each other, which is scary. But would you say that there is something like that? Or maybe do you see other areas in which we could say that DSA is maybe trying to compensate either intentionally or in practice what the GDPR is missing?
Perhaps to answer short, I mean, I think that my first slide where all these instruments were laid on the table very neatly, I think that's the answer. I think there are a lot of instruments for which we at the moment don't know for what great use they can be, but this trial actually shows how these different acts complement each other, and that there are now a lot of procedural rights and a lot of stakeholder rights. And I think that's the great achievement of the DSA, that there's a procedure and there are stakeholder rights and stakeholder interest. And I think these procedure together with the individual rights, they give the opportunity, at least for activists, to challenge decisions by platforms and challenge decisions or inactivity by regulators. I mean, in the GDPR, we've seen what Max Schrems could achieve with his strategic litigation. And of course, it's only very much individual questions that can be raised by individual enforcement, but perhaps those issues that aren't tackled by others. So I think there's a great, even a complementation between public and private enforcement. So yeah.
Yeah, I have just a quick question for Alexander. Very nice presentation, by the way. In the beginning, you mentioned the sanctions available under the DMA. I'm sure including hefty fines, but you also mentioned intriguingly breakup in an extreme situation, I assume. I also noted that the model of the DMA is designating gatekeepers by function, and you gave a nice overview of that. Is that the way you're going to break up these companies in the future? But my serious question is, how do you break up a non-European company? Is that doesn't sound easy to me. Or is it only booking.com that you're going to break up? I wouldn't mind, by the way. I pay too much.
I mean, back when we just discussed that Booking is so far the only European-based or EU-based gatekeeper that we have. I mean, we have these structural remedies. They're only available in what we call systematic non-compliance. So you need to collect 5 non-compliance cases. So I mean, that already takes a while, because we've seen, you know, Apple has 3 open ones, whether they will ultimately result in a finding of non-compliance to be seen. And then, you know, the breakup is a very, very ultimate solution that is theoretically available. Whether, you know, you break them up, I think that's really all speculation. But I think, because if they want to continue doing business in the EU, I think you have the link. I mean, there is a bit of precedence in merger control. I mean, it's a case which now got annulled between 2 US-based companies, Illumina and Grail, which concluded their merger despite an ongoing review of the European Commission. And there they received interim measures which basically told the company to spin off the target Grail in that case. No, we didn't have restrictions, so it's a very fresh and harmful loss for us. But so I think legally, yeah, it's possible, but that's really not the idea. I mean, again, we try to engage constructively. We have, the fines. We also have periodic penalty payments, which are often quite effective because they basically say, as long as you don't comply, there's a daily fine of up to 1% of your global turnover. So I mean, that can be very, very high. So yeah, that's there, but we hope that the threat will be enough. We don't need to actually use these things.
We should probably also note that in the Article 102 context, if I've understood correctly, this commission has specifically indicated in its statement of objections against Google in the AdTech case that it contemplates breaking up Google in the AdTech sphere.
Or at least ask, because they really have the problem that along the value chain, they are, there's this inherent conflict of interest because Google controls the selling of ads, the intermediating of ads, and also the buying of ads, that at least one of these parts they would need to spin off in order to comply.
And one can certainly see, based upon the theory of harm, how a structural remedy would be a natural remedy. But to your question, will the commission actually do it? We shall see. We have a couple of minutes. Yeah, sure.
Okay, so to end on a negative note. So one thing that I keep wondering about is how does all of this fit with traditional, typical law? Have we created kind of an echo chamber trying to prevent echo chambers? Because looking into DSA, DMA, and all the other provisions, the way I see it is that, well, number one, there is no great consistency with the pre-existing rules of EU law. Why do we have to define terms and conditions under the DSA? Plus define it in a way which is like, terms and conditions are any clauses, We already have a definition of contractual obligation under Brussels I. Why do we have to redefine advertising? Why do we have to redefine so many things? Does that mean that we are fragmenting EU law and kind of creating a parallel track where advertising means one thing, or like online interface means one thing under the new regulations and something entirely different in other places? So I guess, number one, are we breaking up? Are we creating separate set there? And number two, what are we doing with national laws? Because if you look into the GDPR, for example, we've decided that lots of things are going to be autonomous. So we have notion of non-material damage means fear, but not really super strong fear, but yeah, actually some kind of fear. So national courts are just confused. They don't know how to implement these autonomous standards. We see that the European Data Protection Board says we can't decide about contracts, and then they say, yeah, but people didn't expect to enter into a contract here, so there is no contract. So basically, how does this integrate with anything which is already in place, either European or national? As I said, negative.
That sounds like, to the extent there's a question there, it's for Benjamin, perhaps.
Well, it's when the EU is trying to solve that problem with the no prejudice clauses in each of the digital acts. And I think actually that's driving me and everybody crazy. I mean, try to get it together, man. So what does it mean without prejudice to Article 17? And we haven't talked about the P2B regulation. There's the online terrorist content online regulation as well. It's without prejudice as well, with the same mechanism as in the DSA there as well, but with different standards. I was joking in the lunch break whether the next commission should be a no prejudice commission and just grab all those provisions, but actually thinking, how do these acts interact? Perhaps integrate the P2B and the terrorist content regulation into the DSA. But on the other hand, I think it's best to interpret the same term in different acts differently, because the acts usually do have a different aim, and perhaps it does make sense to have a broader concept of the terms and conditions in the DSA than, for example, in the unfair terms Directive and so on. So I don't see that too negatively. I mean, it's nice to have a coherent definition, but it's better to have a specific definition than a too broad definition.
I've been wondering for the last 30 years what without prejudice means in the context of the various pieces of legislation, and received no illumination. Anyway, I think we will end 30 seconds early. It's been a great pleasure with everyone here, including the online audience. So thank you very much. We'll have a little break.
So shall we resume? Okay, this silence suggests that we resume. I will break that silence with the introduction, a quick introduction to our last panel. The latest, but most likely not the final piece of digital legislation that the EU has bestowed upon us in recent years is, of course, the AI Act, already mentioned several times on this conference, which was adopted a couple of months ago, although a almost final version was circulating for a somewhat longer period. It was adopted in June 13th. Another regulation sold as an act, but if you look at its final incarnation, it is really a regulation. And what kind of a regulation? A dense, complicated, very extensive rule book that regulates AI following a product safety approach. That was obviously the original inspiration, the way we deal in Europe and in other countries with dangerous toys, was sort of translated into an AI version of that. And then so based on risk, a sort of general risk assessment. But then much more was added to it. For example, the AI Act also creates special rules for providers of so-called general purpose AI providers, of which the generative AI providers are a subset. Those were added at the very last stage. It also establishes an AI office, which also sounds a little bit more grandiose than it is. It's not a separate institution. It is actually part of the DG Connect, but it does have now, as we speak, 140 employees. So a whole new AI bureaucracy in Brussels is being created. This panel will focus on the way we regulate AI, not only in Europe, through 3 different lenses. One, that's Alexander Peukert, the AI Act as a regulatory instrument. What kind of instrument is it? How does it work? Second, through the lens of EU competition law. How does EU competition law apply in the AI realm? Can it apply in what way? And 3, the lens of the United States, which follows a very different regulatory path. And for this, we have 3 eminent speakers. All our speakers are eminent, otherwise they're not in this conference. Alexander Peukert, already mentioned, you already heard him speak. Professor of Civil, Commercial and Information Law at the Goethe University in Frankfurt am Main. Second speaker is Tom Vigne. You've already heard as well, presiding over the panel, co-organizing this conference. He's Senior Counsel and Chairman Emeritus, means he's about as old as I am, of the Global Antitrust Group of Clifford Chance. He's been the competition man for many years in Brussels in the IT field. He's also Professor 2 at the UIB, which means a part-time professor teaching competition law. And then our third speaker, but last but certainly not least, our special guest speaker, Pam Samuelson, whom we've already heard at several interventions as well. She's the Richard M. Sherman Distinguished Professor of Law at Berkeley Law School and also director of the Berkeley Center for Law and Technology. And just a wild guess, probably the only American that has read the AI Act from cover to cover. Maybe even the only person in the world. Okay, to kick off our session, I invite Alexander Peukert.
Thank you. Good afternoon, 3 p.m. After a very rich and intense day, but I will stay awake for next 20 minutes, and I hope so will you. So before I define what I mean with meta-regulation and why I think that the AI Act is a really prime example for this type of regulation, I would like to give you a very brief update on where we are with this legislative project. It was published only in July in the official journal. And as Bernt mentioned, it is impressive quantitatively. It's 144 pages, and I counted the words. A machine counted the words. Excuse me, 90,000 words, which is a decent German dissertation in law, I would say. So if you've read it, it's a challenge. Okay, and also the schedule for its application is ambitious. It entered into force in August. The prohibitions of the AI systems with unacceptable risk will become applicable already in February. Then come the general purpose AI models, the foundation models, which were entered only at the very last stage of the legislation, but those will also become applicable earlier. And interestingly, the code of practice that Bernt also referred to ought to be ready before Chapter 5 of that act will become applicable. So the code of practice about on these general purpose models shall be ready in early May next year, and the provisions that regulate these models only become applicable 3 months later. That's an interesting way of applying law. The rest will become applicable only from 2026 onwards. That concerns in particular the high-risk provisions. One final provision only in 2027, and that's the closest link to product safety laws, in my view, in all of the AI Act, namely the rule that classifies high-risk AI systems, which are safety components of toys, for example. So the link with the conventional product safety law will become applicable at the very last minute. So I think that's perhaps already interesting. But what is going on in Brussels? Also here, the Bernt also already said that the AI office was established in January. As far as I can tell from the website, they are working currently on 2 major projects. One is the AI Pact, which is presented here. It's taken from a website of the Commission as a framework to prepare the AI Act's implementation. So to prepare within the companies about the implementation of an act which is yet to be become applicable. So the idea is to establish a network and to have as many company pledges to promise to comply even before the law becomes applicable as possible. And then a process has been launched regarding the general purpose AI models. You can still participate in the consultation, which ends only in September 18th, and then an iterative drafting process with plenaries will take place, and the result shall be that code of practice regulating various aspects of general purpose AI models. So there's happening a lot already as regards the implementation of this AI Act in Brussels. This is my one slide on the risk-based product safety approach. So the act is normally presented as Bernt said, it's an adaptation of what we already know from the product safety area. So toys shall be safe as and the same should be true for artificial intelligence. The later added AI models have now to be distinguished from the AI systems. You have a chapter on AI models, which underlie the systems. The foundation models, as they were called in the beginning, are the models upon which AI systems are then built, with which we interact. And both with regards to models and AI systems, various risk levels apply and corresponding obligations of providers of such models and systems. So there are AI models, I would claim, that are not regulated at all because they don't have the capacity to have a general purpose. Already those models have a high capability, that those models are regulated. And then you have models with a systemic risk. Systemic, by the way, is an interesting term which features in the Digital Services Act. It also was mentioned very briefly in the DMA presentation, and I would be interested to learn about your interpretation of what systemic means. It could be one of the horizontal principles running through these laws. Anyhow, and then there are various risk levels with regard to systems: minimal risk, only ex post regulation, specific transparency risks, for example, deepfake risks have to be complied with, so that you display that you are an AI generated content. Then you have the high risk AI systems and certain prohibited AI systems which display an unacceptable risk. Okay, that is the standard reading of the AI Act, but I would like to present an alternative reading of this act, which hopefully adds a little bit further to what this creature or this monster actually is. Because I'm always skeptical when digital regulation is compared to analog regulation, as if the AI Act was something similar to the toy regulation, or as if the regulation as if Article 17 is just a similar regulation like we had in the old analog copyright times. I would claim it's something different, and I would like to identify this specificity with the term meta-regulation. Okay, and let's start with the second part of this term. Regulation means it's a regulatory approach. Already that sets the AI Act apart from the body of law of which I had studied before mostly, namely copyright law, which is private law. So this act creates administrative law or public law obligations of various AI operators, but it does not, what it does not do, it does not work with traditional private law rights of individuals. And that goes back to my question, right? Although it regulates a market for AI systems and models, and is based on the internal market competence, it does not adopt rights or conventional market regulatory tools. Instead, it's an administrative law that puts obligations on certain operators on this market. So it's a regulatory approach. Good. But then what does meta mean? And here I have a quote from the OUP Handbook of Regulation. So that's a well-established term in regulatory theory. And they define meta-regulation as a mode of regulation where outside regulators, and think about here the EU, maybe the AI office, outside regulators induce targets, that would be the providers of the models or systems, to develop their own internal, that would be the company internal policy, or self-regulatory responses, that would be the code of practice, to answer to public problems, okay? It's not about individual interests or private interests, it's about a public problem, and that fits to the administrative law qualification. So that definition of meta refers primarily to what I would like a kind of multi-layer type of regulation. A meta means it lies beyond, or it's rather abstract, okay? And this we can see in the AI regulatory field. On the top of this layered regulation, you have guiding principles, very broad guiding principles on the international level. So Hiroshima International Guiding Principles on how to reply to AI risks. Those inform or are reflected in the EU response, which is the AI Act, which is, however, as I will explain in a minute, also very general and abstract. Only on the third level, tertiary law, you could also say, are those general obligations then more concretized. And those can happen either through the Commission, through delegated acts, guidelines, or it's called common rules. So the Commission has a whole set of tools with which it can concretize the general basis in the EU, in the AI Act. Alternatively, and that's obviously the preferred solution from the perspective of the Commission, the industry agrees on its own standards, well, encouraged by, invited by the Commission. And these would be codes of practice or conduct with regard to systems and models or standards, okay? So here you have some concretized question, for example, what's a machine readable opt-out, yeah? Hopefully that would be specified in such a guideline. But still we are not on the level of a rule. It's not a rule, it's still a guideline or a code. This rule will only appear within the AI provider's own systems where they have policies, that would be the terms of service, and perhaps even a code. Code is law, so they would have to transplant the general code into their systems, right? Into their bots, what they crawl, or into their systems, what they spill out. And that eventually is then the rule level where also we as users of AI systems then see what the output is or what is prohibited and which content cannot be created through generative AI. Good, but I think that the notion of meta-regulation has more to it than this multi-layer structure. Meta also implies that it lies beyond current problems, and this we have heard quite often today. It's an ex-ante regulation, right? The AI Act tries to prevent problems from appearing before they appear, and that is a specificity of many of these laws. Yeah? They don't react ex post, but regulate certain behavior ex ante. Secondly, the aims of the Act are beyond very specific aims. The ends are very general. If you read Article 1.1 of the AI Act, you have all kinds of purposes that the AI Act pursues, right? All fundamental rights. Safety, what that means is also not apparent to me. Democracy, the rule of law, the environment. I see very little what is not covered in Article 1.1. So it's a very broad purpose of this Act. The means, so the substantive obligations that the AI Act sets out and forces the AI operators to comply with are also very general. The one I like best is Article 71, which I would like to read to you. Providers of high-risk AI systems shall put a quality management system in place that ensures compliance with this regulation. Okay, it's 3 p.m. I read it again. So providers shall have a quality management system in place that ensures compliance. What that rule says, please comply with this regulation. And that's Article 71. Again, I have difficulties to imagine a rule which is more general. Yeah. So in that sense, it lies beyond specific obligations. It also lies beyond all existing laws, as we have heard today, without prejudice to. And on top of all other applicable laws, on top of IP law, on top of anti-discrimination laws, and what have you, laws protecting minors. That is another feature which we also see very similarly in the DSA. Where all of this, I think, comes to a practical relevance is when you have to establish a violation of these AI Act obligations. The AI Act speaks of an infringement of obligations of the AI Act, but I would rather speak of a violation of these very general obligations, because as a private lawyer, what I see here, this is very different, right? If you have a private right that has a scope, and if there is an infringement, might be difficult to establish, but if there is an infringement, then remedies follow automatically. The DSA and the AI Act have a different concept of violation, because if your duty is to have a policy to comply with this act, or a policy, a copyright policy, when do you violate this obligation? Well, you probably violate if you don't have any policy. Well, then that is a pretty clear case. But if you have a policy, when is it in violation of the threshold? Because if it's inadequate, and how is that established? That's a completely different approach to establishing a violation of the act than at least in private and commercial law is prevalent. Also because proportionality has to be taken into account in any establishment of a violation, right? So the proportionality features all over the AI Act when it comes to fines or also other enforcement measures. And it is very clear that the AI Act does not establish a zero tolerance standard, right? So an AI system might infringe copyrights from time to time, but that is not yet enough to say that the system or the model is in violation of the AI Act. So it's a different, a quite kind of vague standard that has to be concretized, in particular through the Commission action and other public authorities applying this act. So the violation requires a general failure to comply, right? It's a general failure or even a systemic failure. I'm not quite sure what the right terminology is. Okay, so my last slide is this one. And I think we have spoken about this from time to time in the discussion. The last question is probably also close to my claim on this last slide. So on the one hand, we have this meta-regulatory approach which is very abstract, okay? On the other hand, the AI Act and the DSA and also the DMA have a very specific scope of application, very specific scope of application. And that is a strange combination of abstract regulation of a very specific area. Yeah. So you have to define what's a system, an AI system, as compared to a model, which might also be or is different from an intermediary service. And you can even bring in the Data Act. Maybe it could also be a digital service which is related to a connected product, right? So those are the terms that define the scope of application of those various acts. And the task of the lawyers now is to classify certain cases and to put them into the right box. And what I see already is that this approach of meta-regulation on very specific technologies or phenomena creates pervasive classification problems. Are you in the right box? Are you covered by several acts? And this is also where several companies try to evade the regulation by saying, no, we are not offering an intermediary service. This is an AI system or an AI model, yeah, or nothing of that. Okay, so in summary, I would say that the EU digital agenda is a meta law or are meta laws of horses and other animals. And that obviously is reference to a discussion 20 years or 30 years ago, rather, where, as some might remember, there was a debate how to regulate cyberspace, whether it should be special laws on cyberspace, or whether one should apply the general rules that we have always known, yeah, Lessig versus Easterbrook, and the metaphor that Easterbrook brought up was, well, then we end up with law of a horse. And that's then a classification problem. Is that a horse or a donkey, or is it a mule? I don't know. And that depends then on which law applies. And I think we are repeating this here. The union creates very specific regulations where the question what falls into which box will consider lawyers for quite some time, which is nice for scholars, but is quite a problem for the industry. Thank you for your attention.
Question: will my slides appear on the screen so I know when to move them? Ah, there they go. I'm happy I don't have to look at myself. Let me begin in addressing this AI competition conundrum with the broader context that I think is influencing competition authorities' consideration of those AI-related issues. And I come at this from the perspective of someone who's been involved in most of the digital antitrust cases, tech antitrust cases for about 25 years. So one tends to be proud of one's children. I'm not saying I'm responsible for those cases, but having been deeply involved in them, I still have to say that antitrust enforcement, as Alexander rather carefully put it, but I'll be a little blunter, antitrust enforcement in the digital space has so far largely been a failure. That's led to concentrated markets, lack of contestability, and unfairness, to use the DMA's terms. So with respect to antitrust merger control, antitrust authorities, I think, now regret approving mergers like Google, DoubleClick, like Facebook, Facebook's acquisitions of WhatsApp and Instagram. Indeed, the FTC is now pursuing a case to undo those transactions in the US. And likewise, dominance enforcement in the digital sphere is also widely perceived as having been ineffective. For example, from my perspective and many people's perspectives, the remedies in Google Shopping and Google Android have been ineffective and came far too late. Now, I think competition regulators, I won't speak for Alexander, but competition regulators are sensitive to these perceived failures, which they regard as having contributed to highly concentrated and uncontestable, again, digital markets. So competition authorities around the world are, I think, fearing missing the boat again, and they're trying to get out ahead of potential issues raised by AI-related conduct and transactions. So across Europe, competition authorities have been in a race to identify perceived competition concerns surrounding AI. So reports have been issued in near record time by the CMA in the UK, the Portuguese, Hungarian, and recently the French competition authorities. And I think soon the Commission is going to come out with its own report on AI. And the attention is cross-Atlantic. The European Commission, the British CMA, the US DOJ, and FTC issued fairly recently a rather strongly worded joint statement on competition in generative AI foundation models and AI products. And that statement says, and I think this is worth reading, quote, "There are risks that firms may attempt to restrict key inputs for the development of AI technologies and that firms with existing market power in digital markets could entrench or extend that power in adjacent AI markets or across ecosystems, taking advantage of feedback and network effects to increase barriers to entry and harm competition. I think that sums up rather broadly the concerns. To be a little bit more specific, if I can figure out how to go forward, well, I've already missed one, sorry. More specifically, what are the key competition issues relating to AI that have been identified by competition authorities? And I'll try to address whether those issues are actually ripe to be addressed now, and whether they can actually be effectively addressed with the existing European toolkit. So the current focus in are on what are called upstream issues, and particularly in the context of deals between large digital players and AI model developers on access to key inputs necessary for training and deploying AI models. The agreement that's gotten, I think, the most attention has been the Microsoft OpenAI arrangement, but there are others as well, as I'll list them in a few moments. Other so-called downstream issues have been identified as potential issues that might arise. For example, AI-facilitated collusion, tying, self-preferencing, and the DMA might also become relevant here in several ways. I think Alexander intimated that, for example, a search company could be prohibited from undertaking self-preferencing in AI-related search, AI-generated, AI-driven search results. But apart from algorithmic collusion, where the US authorities recently launched a case against RealPage, there really haven't been any downstream issues addressed. So I'm going to address these upstream issues upon which the competition authorities have so far focused. And again, they relate mainly to arrangements between large digital companies and foundation model developers concerning the key inputs to foundation model development. So one key barrier to entry potentially in AI model development is what some call compute. Now, this includes AI chips. I'm sure you all know that training large AI models, especially foundation models, requires very significant compute capabilities that are underpinned by graphic processing units, GPUs. And currently, there's more demand than supply, I think it's fair to say, for GPUs. And NVIDIA has been said by some, I'm not knowledgeable enough to take a position on this, but it's said by some to have a dominant position in GPUs. And competition authorities have expressed concerns about the AI sector's dependence on NVIDIA's products and about supposed preferential access to NVIDIA's products by certain companies. Again, I don't know the facts. But competition authorities seem to fear that preferential arrangements of that nature could contribute to the establishment of an AI sector dominated by a few large digital players. I just say both Articles 101 and 102 are potentially relevant here, and investigations related to NVIDIA are underway in France, in the United States, and I understand in Brussels. A second key input into model development is, of course, cloud computing, as we've already heard. So both deploying and developing large AI models require huge computing power. And this usually comes from the cloud, not solely, but mainly from the cloud. So competition authorities have identified cloud computing services as a key potential barrier to entry in large foundation model development. Now, the other side of that coin is capital. AI is a very capital-intensive business, but mainly because of the high cost of cloud computing and chips required for the model development. So AI developers need lots of capital. And where do they find it? from a lot of different investors, most of which raised no competition concerns, venture capital folks in Silicon Valley and the like. But what has gained the significant attention of competition regulators is partnerships or investments by large digital players involving actual capital contributions or their equivalents, and that's why I say these are two sides of the same coin, their equivalents in the form of chips or credits for cloud services. And the basic concern that competition authorities have here, I believe, is whether by entering into deals with emerging AI players, including in particular generative AI foundation model developers, existing large digital players could gain control, the keyword control, over the directions of those developers take. And in particular, they could potentially prevent, among other things, these developers, these arrangements could prevent those developers, model developers, from undertaking disruption of the big digital players' existing strong positions in various markets. For example, by entering into partnerships with AI model developers, a search engine monopolist, no names here, might obtain the ability to prevent those kind of developers from supplanting existing search products and thereby displacing that search monopoly. Just one example. Now, merger law could in principle allow competition authorities to scrutinize and potentially block these sorts of AI deals. But so far, the law has not enabled any enforcement. For example, again, in Microsoft's, with respect to Microsoft's investment and arrangement with OpenAI. And from various statements that competition authorities like Commissioner Vestager and Andreas Mundt have issued, this is to the clear frustration of the competition authorities. They felt rather powerless to use merger control law to address issues that they're really itching to address. So why have the authorities been unable to use merger control here? Well, there are two main reasons, seems to me. One is control. The parties to these deals have been rather careful not to grant the requisite control to the investing party to enable the deals to be regarded as concentrations for merger control purposes. Second, the revenue thresholds have not been met because AI model developers' revenues are either small or even non-existent, especially in Europe, I think. Now, and this, as Alexander mentioned, this latter revenue threshold obstacle to pursuing merger cases grew even higher just 4 days ago when the Court of Justice gave its judgment in the Illumina Grail case, so that now the European Commission will not be able to take jurisdiction over transactions referred to it by member states that don't meet the thresholds. The transactions don't meet thresholds for notification under either the EU merger regulation or the relevant national merger control rules. Now, that said, there's another wrinkle here because in its recent Towercast judgment, the Court of Justice resurrected the possibility of post-closing challenges under Article 102 of transactions that don't meet the merger control thresholds because the merger regulation doesn't apply. It's Article 102. That leads the question, is there a possibility of using 102 in this context? And frankly, I doubt it. I think it'll be difficult to address transactions under Article 102 involving contributions to EU AI model developers of contributions of capital or cloud services, because it would be very difficult, I think, to demonstrate dominance, the relevant dominance. I mean, the cloud market does contain a very few large players, but there seems to be rather intense competition among those relatively few players. And in those circumstances, it seems to me it would be difficult to deem any of the current cloud companies to be dominant. So it's not a Google search situation. It's not a Microsoft Windows interoperability situation. I've been struggling for 30 years with that word. And the notion, I've heard notions of pursuing some sort of collective dominance theory. That seems far-fetched in light of what the law is, as I understand it, to be on collective dominance. What about the DMA? Well, this is interesting because the DMA does identify cloud services as a core platform service, but no gatekeepers have yet been designated, and I don't really hear words about that happening anytime soon. Maybe Alexander would be willing to tell us why this is the case. I think maybe I know, but I'll shut up. So the DMA is currently irrelevant on this point. And then the DMA doesn't reference AI. I mean, so the AI is simply not part of the DMA, leaving aside cloud services, the AI itself is not addressed. These I thought I'd just put on the slide here, the merger probes that either are or have been underway. So there you have them. I assume you can look at this later. I got to look at my, look at my clock. These are somehow in the wrong order, or one of them has disappeared. Ah, here it is. I don't know how. I think I was screwed up in the ordering. I'm sorry. So tech talent, another barrier to entry in AI model development identified by competition authorities, and pretty clearly does exist, is tech talent. I mean, we know highly skilled data scientists and other specialist tech employees are essential here. And there's a very limited pool. I'm sure Bob can tell us more about the facts here. There's a very limited pool of such talent, and some of it, at least, resides in AI model developers such as OpenAI. I think quite a lot of it. So another of the competition authorities' main concerns in the AI sphere concerns wholesale hires of tech talent from AI model developers, the so-called acqui-hires. And various antitrust authorities, including the European Commission, the CMA, and the Bundeskartellamt, have expressed concerns about such acqui-hires in the AI space. There are transactions between large digital players and AI model developers whereby key talent is acquired by the large digital player and the smaller, potentially disruptive AI model developer is deprived of it. So regulators are concerned that that might reinforce strong positions of existing large digital players acquiring that talent and prevent the new, smaller AI-based innovators from competing, from challenging them. But again, those transactions seem to be unlikely to be within the jurisdiction of competition authorities under merger control for the same reasons investments and partnerships involving the contributions of capital and cloud computing seem unlikely to. They don't meet the revenue thresholds and they don't establish the requisite control. So no authorities have acted against such transactions. They've been openly frustrated with their inability under existing law, merger control laws, to do so. I'm sure, absolutely sure, that competition authorities will continue to watch these deals very closely. They'll seek to influence or prevent deals that they find especially troublesome. But it's difficult to know how that will turn out given the limitations on the applicability of merger control law. The final barrier to entry that the competition authorities have identified is data. Foundation models, as we all know, are typically trained on vast amounts of data. Although there is a trend towards models that need less data. And some large vertically integrated digital players may have significant advantages by virtue of already having lots of high quality data at their disposal for model development. And some claim, and again, I don't have the facts here, that deals occur that give preferential data access to certain companies. So deals between content providers, content owners, and model developers. Now, I'm not aware of access to data issues having arisen in these deals between, for example, OpenAI and Microsoft. That doesn't mean they don't exist. I'm not aware of them, at least. And if there were to exist deals between important content owners and AI model developers, and they were to have restrictive effects, which is a big question, then Article 101 might be relevant here. Wouldn't be entirely surprised by that. But pursuing, again, an Article 102 case would seem challenging. I mean, could an authority surmount the first hurdle, namely deeming any of the existing large players here, either the AI model developers or the content owners, to be dominant in a relevant market? I mean, perhaps this is relevant or could exist in niche AI applications, targeting specific areas like segments of the healthcare markets. But for general AI, I doubt it's going to be conceivable that anyone on either side of that conundrum is going to be deemed dominant. But even if the dominance hurdle could be surmounted on one side or the other, then what would be the theory of harm? We all know how difficult it is to pursue these cases and how long they take to resolve. So there's an issue there. Discrimination is a possibility. Maybe it could work. So if we're left with Article 102 being ineffective, and there really are data issues here, then what about the DMA? Well, maybe to some extent, the DMA does seek to increase the availability of data for gatekeepers, business users, through its data access and portability provisions, but I'm not sure how relevant it is in this particular AI model development context. It's certainly no broader panacea. We've heard earlier today about the inefficacy of the Data Act, which has some things it wishes to do in this realm, but I'm not so sure it's going to. So let me then end with, I'll leave aside the downstream issues. There are big potential downstream issues. So tying, self-preferencing, quite a number of such typical issues, typical kinds of conduct that have been addressed in previous antitrust cases could potentially become relevant down the line. And Article 102 could be employed, potentially the DMA as well, but that involves pretty heavy-duty crystal ball gazing at the moment. So bottom line, I'm really not sure that any of the main competition concerns identified so far are ripe or likely to be effectively addressed under either traditional competition law or the newer digital legislation. And that leaves me with one final question, and maybe Alexander would be willing to share with us whether this is even a topic of discussion in Brussels. But could the DMA be modified more directly to address any of the AI-related competition concerns that have been raised? If a core platform service were defined that included AI services, the dominance issues would disappear because, of course, as Alexander has explained, and you all know, the Commission wouldn't have to find any single company to be dominant. So that all that stuff, surrounding stuff, market definition, dominance, all that stuff disappears. But I still have big doubts about whether this is something worth pursuing or could be effective. For one thing, I don't know how the core platform service could or would be defined that related to AI. Now, I may not be being sufficiently creative and may not be sufficiently knowledgeable, but I have tried to figure that out and I haven't been able to. But at least if there's finally in the end, they're perceived to be big issues, which is a question, and existing law doesn't enable them to be addressed, then perhaps amending the DMA is something that might be considered. But again, I'm not advocating that. I'm not sure it would work. So bottom line, plenty of fun still to come. Alexander will have a long career ahead of him, and we can all have lots of fun with AI-related competition issues. Thank you very much. Sorry.
And now for something completely different. Okay. I want to actually start by thanking the organizers for the opportunity to be here. Probably none of you know, except my husband, that I have a lot of family roots in Norway. And so I'm actually, oh, and Tom. And so I'm very glad to have an opportunity to come back to Norway. I know I've actually visited the farm that my great-grandfather emigrated from, and that was actually not on this trip, but on a previous trip. And so I have a sense of connection here. So I'm going to start with some common elements that actually is, I think, the assignment of the conference. I'll talk next about some respects in which US and EU approaches diverge, and I'll talk about a little about why I think those divergences happen. And then I'm going to cover some key elements of the US regulatory approaches, both at the federal level and at the state level, and then talk a little bit about copyright, because that's the place where things are shall I say, in a tizzy, and then I'll offer some concluding thoughts. So there are more commonalities than may appear on many people's lists. So I think that the idea that we should be thinking about AI systems in terms of risks, what kinds of risks are we talking about? Let's identify them and say, why is that a risk that doesn't appear in some other context? And I think both the US and the EU are aware that some risks are better and bigger than others. And so trying to identify levels of risk and then think about how they can be mitigated is something that they have in common. And I think a difference, but in some sense, maybe not as much as it could be, is that the EU policymakers require risk assessment, and the US policymakers say, hey, it would be a really good idea if you did risk assessment. And for American firms, the difference between require and urge is actually a pretty big difference, but I'll leave that there. I think another really important convergence has to do with standard setting as an important governance mechanism that can play an important role in how this particular, as well as past technologies, have evolved. And the sort of effort to say, I'm not just going to study this in the Oval Office. I'm actually going to go out and talk to people, find out what's going on, have some engagement with developers, have some engagement with potential competitors, have some engagement with civil society, take into account actually also what some of the leading academics are thinking about what would be sort of good in terms of AI policy and governance mechanism. And I think we all actually recognize that there is a significant potential for these systems to be deployed for the social good. And the whole point of regulations is to bring about the good stuff instead of the bad stuff. And those are like, I think, the main commonalities. And I want to spend just a minute on standards as a good governance tool. So one of the things that's important is that even though the EU policymakers want to have a Brussels effect, another way of achieving some sort of consensus is through standard setting. And a good reason that that's a useful way of thinking about it is you have these international organizations, they can host meetings, people can come with ideas about what standards might be beneficial. And so it ends up being not the policy preference of any one nation, but really a kind of consensus process that allows many industry, technologists, civil society, researchers to provide input and debate the merits of proposed standards, and hopefully that results in the adoption of standards that actually are a consensus of what would be the best way to proceed, given all of the complexities of technology development. And of course, it has a decentralized capability, and because it operates on consensus, firms that participate in it and other firms that are going to be affected by it have more incentive to voluntarily comply with those standards, particularly if developers get a safe harbor if they implement those standards. And one of the things that I have noticed in the AI Act is that safe harbor, if you comply with standards, is actually something that is part of the governance system too. And from my standpoint, another important element of standards as good governance tools is that it's possible to refine or revise them over time as you get new information about what the risks are that you didn't know about, or about what kinds of developments that weren't foreseen at the time that the standards were first developed. So again, I think this is a particularly important part of it. One reason that there is such difference between the US and the EU in respect of the AI policy and AI governance mechanisms really relates to what I call a higher level type of difference in terms of regulatory cultures. So I think it's really kind of admirable that the European Union takes this proactive approach. I can sit down and talk to people and think about this for several years, and then I'm going to put together a law, and I'm going to then take that through the legal adoption process, and that will basically solve the problems for all time. Okay, that's just not what we do in the US, okay? So the US tends to be a much more reactive and empirically driven law and policymaker approach. And so the US, for example, wouldn't have adopted the sui generis database protection law, which was really a bad mistake on the part of the European Union. We're reactive. We kind of want to know what's going on out there. Have there been harms that are occurring, and what kinds of laws and policies that are already in our toolkit can we bring out to deal with them? And then you only get to the new laws when the old tools aren't going to do enough work. I think the other thing that's related to this kind of higher level regulatory culture difference is that the European Union thinks that regulation is the way to protect consumers, and that's a value that I'm going to embody in a legal instrument, whereas the US, generally speaking, trusts the market and trusts self-regulation to protect consumers until and unless the market fails, and then you step in afterwards. That's the reactive approach. And the EU is setting up a new agency to participate in the kind of like 140 people already on board to regulate AI industries. And the United States is just not going to have a new agency, probably not even going to have a new sub-agency to do that. And I'll come back to that in a minute. I want to kind of express to you that for American lawyers, trying to read any of these digital agenda laws is just makes my head hurt and makes everybody's head hurt, okay? It's really hard to do, and partly it is that they embody a kind of how you make your laws that's so different from how we make our laws that it's just impenetrable. And it was actually a relief to hear from Martin earlier today that all of these acts that have been adopted, which don't interact with one another well, it's because nobody who was adopting this one was talking to the people who were adopting that one. And so no wonder we scratch our heads like, how do these things fit together? So it's hard enough to understand any one of them, but to understand them in relation to one another, again, we just basically say, I don't want to deal with this right now. So
That's just, again, it's part of the regulatory culture issue, I think. So from an American perspective, when is it a good idea to adopt ex-ante regulation? Number one, when the subject matter of the regulation is relatively homogeneous, when the subject matter of the newly proposed regulations is well understood, policymakers have experience with that subject matter, know what its risks are, know what the harms are, and know why they exist. And then when they're confident that they know what kind of regulations are needed, they basically then, okay, I will articulate that now. And of course, the regulation, from my perspective, from an American perspective, needs to be simply formulated, and the banned practices should almost always be harmful. And the subject matter of the regulation and the ecosystem in which it's embodied shouldn't be rapidly changing. Okay, so those are the kind of preconditions from the standpoint of an American tech lawyer about when to do that. And if you kind of apply those to AI regulation, none of them applies, right? It's not homogeneous subject matter. The technologies are very little understood by policymakers. They're changing all the time. There's little experience with them. Many of the risks that are identified are ones that are hypothetical rather than actual. It's unclear whether the laws will actually stop those speculative future harms from happening. You can't articulate simple rules. It's unclear whether the banned practices will always be harmful. And the systems are changing and the ecosystem is changing. So it's like, from my standpoint, it's not the time to do that kind of regulation. Now, I will say, in deference to the drafters of the DSA and the DMA, these conditions are more closely met as to those, right? Because there've been years of experience dealing with the platforms of various sorts, and we know what kinds of harms that European policymakers think that they've done, and then they came up with particular things that were tailored to those. But that can't possibly be true with the AI Act. So what are the main concerns of the U.S. commentators about the AI Act? Well, I think everybody would say it's well-intentioned, right? Nobody would say, oh, they're just being mean. But although they are being mean. So it's well-intentioned, but it's too complicated and it's too inflexible. It imposes very high compliance costs on developers and deployers of AI systems and puts them at risk of very heavy fines for non-compliance. And this is of special concern because, shall I say, there are some ambiguous terms in the AI Act. So when you're trying to say, can I make this investment and can I do the following things? You're taking a big risk because you have no idea what it actually really means. And from the standpoint of again, American theory about regulation is that lighter regulation in early phases of industries is more likely to attract new entrants and also enable research organizations to participate. Sectoral approaches to regulation then can be fine-tuned to the risks that apply in this sector as opposed to that sector. And so a sectoral approach appeals to a kind of American regulatory approach. And in the recitals, the aim is to impose EU regulations on all developers, even if the models are being developed in jurisdictions where training is lawful. If the EU decides that it doesn't comply with copyright in the EU, basically you can't do business in the EU. And again, that's in a recital. It's not in the text of the law, but it is of concern. Now, the question is, will AI developers in the US comply? Large companies such as Microsoft, Google, Meta, etc., they can afford to comply. But Bloomberg earlier this week or last week reported that Meta is not allowing its most powerful model to come into the European market. And Apple is keeping its most powerful AI-enhanced features for the iPhone also out of the EU, so that even the big players are not just saying, oh yeah, let's comply. But the smaller US companies and research organizations just can't afford to comply, so the EU will not have the benefit of their innovations. You know, Meta actually is being disadvantaged by not being able to make its model available here. But that also has disadvantages for European developers which would want to build on the ecosystem as part of an ecosystem for their systems to build on Meta's model. Now, the approach that that so far has been dominant in the United States is the Biden executive order on AI. It may not be apparent to all of you that executive orders in the United States actually have the force of law. So they're not just policy documents. They are basically force of law things, but most of the Biden executive order articulates the main policy goals. It directs specific agencies to undertake certain actions. So the NTIA is supposed to do something, the NIST is supposed to do something, Energy Secretary. So there's a series of directives. And also there's a big emphasis on procurement policy, which I think is an important element of this. And the NTIA report addresses the issue about open versus closed models and weights, and that's actually something which I know people are interested in Europe as well. After receiving a large number of submissions, NTIA basically said there isn't enough evidence right now to say that the open systems are too dangerous, and therefore let's kind of keep monitoring the situation. But for now, let's not forbid them. State AI regulations are really quite substantial. The last number I saw of state legislative bills was 700. And right now there's no preemption. The Colorado basically enacted the first of the AI-based regulations that was designed, again, focus on risk and focused on safety. That's actually something that caught people's attention. But the big thing is the question about what California will do. And the state legislature in California just passed Senate Bill 1047, which proposes to regulate very large AI models to impose various, you have to measure this safety thing before you can release something. It requires kill switches to be installed, and it would impose heavy penalties. And then because all the details can't be in 1047, you create a new agency in California to fill in the details. But you can see that from the standpoint of a lot of people in that industry, not exactly a reassurance that it's going to get this right. So it was enacted already, but we're waiting to hear from Governor Newsom about whether to sign it. There's been strong opposition among AI industries, including AI researchers and members of Congress. There are listed a few of the reasons why this particular legislation is of concern. These are mostly come from one of the letters that came from a member of Congress to the governor. But I think part of, if you're going to say, what's the matter, what has generated the AI Act and what has generated these Colorado and California laws, it's because we're having a moral panic about AI systems, right? So so many of us watch the movies that basically involve doom from an extinction concerns and loss of human control. And so there's a kind of moral panic that's going on, and it's moral panic that's happening also in the copyright space. I've seen one commentator call generative AI a Marxist nightmare, because the works of millions of writers are accruing to a few capitalist owners who pay nothing whatsoever for that labor. And Goldman Sachs predicting that generative AI will displace 300 million jobs is actually mentioned in some of the complaints in the copyright cases. And I know I just got flashed 5 minutes, but I was told I had 35 minutes. Okay, so I'm taking 35 minutes. Okay, so copyright can be an AI governance tool too. You underestimated how many lawsuits there are. As of today, there are 30. So most of them are class action lawsuits. There are lawsuits, as Bernt mentioned, the New York Times, Getty Images, and the recording industry. And many of the complaints, particularly the class action complaints, express concerns about displacement of creative labor. Why pay a visual artist to design a logo if DALL-E will basically generate it without any hard work and for free? The Copyright Office is planning to study the training data issues. And as I've said a number of times when I've given talks on this topic, copyright law, at least in the United States, is at the moment the only law already on the books that could bring generative AI to its knees, right? Because remedies for infringement include impoundment and destruction of infringing materials, and several of the complaints asked the court for an order to destroy the models that were trained on the plaintiff's data. Many of them also claim statutory damages for removal of copyright management information, and the statutory damages for that start at $2,500 per violation. And the Doe versus GitHub case basically estimates that it's entitled to $9 billion just for that one claim. And here's a nice image, just kind of like, what do the visual artists really think about generative AI? This shows their view. Okay, so the argument against fair use is that, hey, this is a commercial activity. The outputs have the same purpose as the plaintiff's work. Generative AI is only able to generate high quality outputs because the models were trained on our high quality inputs. The training process makes exact copies. And there are two types of arguments in terms of market effects. So plaintiffs such as Getty Images and New York Times basically say, hey, I now have a licensing regime for training uses of our works as training data. And so if you don't pay, then you're an infringer. The class action plaintiffs basically say that generative AI outputs reduce demand for human authored works and threaten authorial livelihoods. Now, the generative AI companies come back and say, hey, actually, it's transformative because I'm using the data as data, or the works as data. I'm not using them for their expressive purposes, and I have a different purpose than the original. So under Supreme Court case law, that means it's transformative. If it's transformative, that means that it's more likely to be fair use. And hey, 71% of the data on that one slide that somebody showed for training data comes from the open internet, okay? And people put that stuff up there, voluntarily posted on the open internet. Yeah, I copied whole works, but it's only intermediate copying. And here's something that's, I think, pretty important, which is data sets are different from models, right? You train the stuff on the data, and then you set it aside. the model is not a derivative work in the copyright sense, but it is something that was derived from the training data, but it's not the same thing. So that actually may matter. And the market effects, you know, it's not possible to get a license from everybody whose works are ingested, so there's a market failure, besides which we don't need a license if the use is fair. The outputs of generative AI are overwhelmingly not substantially similar to, let alone identical to, the input data, and hey, millions, hundreds of millions, right? 180 million people are registered users of ChatGPT. And if ChatGPT, right, if OpenAI is an infringer, then every one of the users, every one of those 180 million people, they're infringers too. Now, I think it's going to be a little hard for courts just to put their mouth around that, but you can't just say, oh, the technology person is the infringer and nobody is who is a user. I think that's not going to happen. So there are precedents that basically the generative AI companies rely on. I'm not going to go through them right now, but another sort of thing that's talked about in the US less seriously in the US than in the EU is a collective license. Maybe you should tax these systems for, have a levy on the training data uses or tax the commercial services. And a paper that should be coming out in the UCLA Law Review pretty soon, I go into some detail about why a collective license for this kind of stuff, given the global nature of the internet, is just completely unworkable, but not today. So what's going to happen? All but one of the cases actually is in very early stages. The Thomson Reuters case was scheduled to go to trial on August 26th. And right before it was going to go to trial, the judge asked the parties to actually file summary judgment motions. So it now looks like the judge is actually going to decide the fair use issue himself. I think many of the people either pro or anti generative AI training data want one decision to basically make the rule for everybody. I think that's pretty unlikely. Those cases are basically being filed in different jurisdictions. They'll go to different appellate courts. And so there are a lot of things happening. Now, Eric Goldman is one of my favorite US commentators, and he just wrote an essay called Generative AI is Doomed. So he compared in this essay the recent proliferation of generative AI with the proliferation of internet services in the 1990s. Both technologies are likely to have revolutionary but uncertain impacts on society at the time that they become kind of like a thing. But the internet arrived at a period of kind of widespread techno-optimism, and so a light regulatory approach seemed to be the right thing to do. Generative AI, by contrast, arrives during the kind of techno-pessimism, following decades of conditioning about AI is going to harm us all. And so he basically thinks that this difference is consequential. The prevailing regulatory responses so far to limit generative AI, to regulate it heavily, may limit or negate that, and to achieve the potential we need to change our approach quickly. Now, this is my part, my comment on his thing, is to say, I think a premise of the current digital agenda in the EU is we made a mistake last time in lightly regulating internet platforms, and we don't intend to make the same mistake again. But will the EU just be making a different kind of mistake this time with the AI Act? I fear so. So, in an era of rapid technological change, the United States is going to be working toward regulations that are flexible and adaptable, as well as sector-specific, because different technologies have different risks in different sectors. I think the Biden administration's executive order isn't perfect, but it's closer to being that kind of flexible model. The Harris administration is likely to follow the executive order. God knows what Trump would do, but he'd be so busy implementing Project 2025 that I don't think he has AI in his sights. And the European Union may be hoping to achieve another Brussels effect to persuade other countries to abide by their rules. But I have some reasons to think that isn't going to work. So thanks very much.
I invite the other speakers of this panel as well. Yes. Hey, wonderful. Thank you, the three of you, for very stimulating presentations, and I'm sure our audience has lots of questions, but I use or abuse the privilege of the chair to start off with a few questions to each of you, and then a general question, and then it's all yours. The floor we'll have, I think, a lot of time for asking questions. We have until 5 o'clock. Alexander, you start your talk is about meta-regulation as the model of the AI Act, which, as I understand it, is basically explaining the AI Act as a co-regulatory instrument where the EU sets norms, some general norms and procedures, and puts a lot on the plate of the platforms, or in this case, the tech companies that provide AI and develop AI. A regulatory approach which overlaps in many respects, as you all pointed out, with private rights that I'm trained like you as a civil lawyer, that we used to frame inside the world of private enforcement. Here we have an AI Act basically telling AI providers comply with European copyright law, or at least develop a policy to comply with European policy law, or else we'll fine you. What is your opinion on that shift? Is that the way we will see private rights being protected more in the future, where you have basically agencies in the end enforcing private interests? Is that a healthy development?
So I would firstly say that your description is correct. So this is the point I'm trying to make. There's a strong shift towards the executive branch, which is the Commission largely, in enforcing various also private interests. I am personally a bit skeptical about this, because the selection of cases that the executive branch will pursue is not in the control of the private individual. It follows other prerogatives, be it how many people are employed or who is pushing the Commission from which angle. And it's also not always that transparent. So honestly speaking, also, if I listen to the DMA application, you have these dialogues going on, but not everyone knows what's going on in those dialogues. And perhaps the plenary of the GPA model regulation will be more transparent. And I understand the Commission is trying to engage many people and also publish reports to show that they are responsive. But the nice thing about private property, honestly speaking, is that it is up to each one to go after an infringer in whatever the situation might be. And perhaps it's even possible to go back to the toy example. I mean, when toys or machinery came up, it was the tort law which regulated that. And then the courts developed rules slowly, in what cases damages came up and so on. Then the legislator came up with strict liability. But no one would ever have said that early, okay, let's establish an agency which will then perhaps in a semi-transparent way establish the rules in what context the respective technology might be used. So it is a very radical departure from prior technology regulation, and I'm personally a bit skeptical about that, but that is a personal preoccupation.
We're brought up in a certain tradition, right?
Yes.
But I can see problems as well. Just to follow up on your answer, the reverse, of course, is or may also be true that there are actually norms in the AI Act, which is crafted as a regulatory instrument that could trigger private rights claims. Have you thought about that? I've looked into the AI Act, but could hardly find any mention of private rights except a right to complain somewhere hidden deep in the AI Act. But what could a right holder or another AI developer derive rights from the AI regulation?
Possibly. However, that would take many years to be cleared. I mean, just take the example of the GDPR. There has been many years of discussion whether GDPR violations can be considered as unfair competition and then brought before the civil courts. And my understanding, it's still not fully settled who is entitled to bring those claims, right? And that's now, 8 years after the enactment of that regulation. And equally long would it take to find out whether and under which conditions there's private enforcement of the AI Act. So you would have already massive delay, which would give the executive branch, the administrative authority, time to establish the rules it sees. And in addition, I did not find much in the Act either. I tried to read it completely. I only found that right to bring a complaint, and then there is the recital which says there is already many possibilities to pursue your individual interests on the basis of the standard law. So you can bring a copyright case perhaps as right holder against any of these providers. So it's not necessary to make the AI Act a basis for additional private enforcement. So it comes, as I said, on top of existing law, on top of private enforcement, on top of individual interest enforcement. And I think it will take time to find out what this executive branch public authority involvement in technology development will mean at the very end. To me, it seems a lot about planning and control also.
Well, we'll certainly come back to the AI Act. I have a question to Thomas. In your presentation, you explained with various illustrations rather forcefully that the rise of AI technology has a potential of creating new problems of abuse of dominance, of potential conflict with competition law. You illustrate that I thought brilliantly in your talk. What I didn't hear from you, or maybe I missed that, is the theory, the opposing view, which you also hear in the literature or read in the literature or on the blogs, is that AI is so disruptive to the tech world that it might also be a liberating force by bringing down existing conglomerates and monopolies, and in that way foster innovation. For example, many have, and you actually mentioned that too in your presentation, AI could challenge the dominance of certain search providers.
Yes, let me try to make clear what I was trying to say. I was trying to identify the competition concerns that the competition authorities have in their various reports and investigations identified, and mainly raise concerns about whether they have any effective tools to pursue those concerns. I didn't pursue the other side of the coin, which you're absolutely right, exists, and certainly there are those who make powerful arguments that indeed AI has the potential to disrupt many markets and displace existing monopolists. But again, to circle back, what the competition authorities have identified is that in their view, again, I don't know all the facts, I'm not coming down on any position on it, but in the competition authorities' view, the existing large digital players are seeking in various ways to prevent that disruption by occurring by gaining control over the potential disruptors, in particular by entering into arrangements with them, by wielding their cloud computing clout, their financial clout, and otherwise to put those people in the boxes where they want them to stay, and to avoid entering territories that can undertake the disruption. So it could very well be, I'm absolutely not suggesting that there's a greater potential for disruption by AI, smaller AI model participants in particular, but the question remains whether the competition authorities are right that they will be kept in their place and won't be able to reach fruition with respect to that regard. So that's the overall picture as I see it. And again, I don't have any answers. I'm not sure anybody really has any answers to those questions. They shall be played out in the next few years.
Yeah, you also said that competition law hasn't been particularly successful with past technologies in the past. So you are a bit of a pessimist here.
I have to, yeah. I mean, I have to say, again, I've been involved in most, I think, of the big, Microsoft and Google, Android, Google's Shopping, Spotify, Apple, and others over the years. And I just have to admit, I think they've had a useful effect, frankly, in terms of disciplining those players, having a broader disciplinary effect. I think Microsoft had a change in culture, and now I'm very friendly with Microsoft people, and at least those who've left Microsoft, and well, those who are still there too. And Microsoft had a sort of a coming to Jesus moment, where, and I think it was not the fines that caused them to change.
After they met you?
No, long after they met me. Long after they met me. I've never brought anybody to Jesus, I'm afraid. But I mean, I think it was the reputational harm, and eventually some internally, I think, coming to the conclusion, well, maybe the antitrust authorities did have a few points here, and so they changed their culture, their conduct rather significantly. And I think that the existing antitrust cases, especially European ones more than the American one, had that effect, which was really important in the market. But the interoperability remedy was, in my view, the only one in all the big tech cases that's actually been reasonably effective. The media player remedy was, to put it nicely, a joke. Commission officials don't like to have the word media player mentioned, especially those who are involved in the case. And none of the other ones have worked. So yeah, I'm pessimistic, even if one can find dominance, whether, given how long these cases take to pursue, so that by the time you've gone through, I mean, Google Shopping was filed, I'll shut up soon, was filed in 2009 by my client, Foundem, small Google Shopping, comparison shopping service, and the Court of Justice is going to issue its decision in that case this September 11th. And that might not even be the final word. They could send it back. So, but I'm hoping for good news on September 11th. That is the final news. But the game was up long ago. So I'm sorry, I had to explicate my pessimism.
Oh, that's well done. Thank you. Pam, you said a lot of things that trigger follow-up questions. One very general one was the observation that a regulator should not step in too soon before a topic, an issue has become sufficiently homogeneous, that there's some experience, that there's some empirical basis for an intervention. I think we can all agree with that, and probably even the European lawmaker would in private agree with that. But there is a problem here, of course, with digital technology, with digital markets that they're constantly in flux. Yes, you mentioned that the DSA regulates stuff that is perhaps a bit more stable, but when is the time right to step in? And a concerned regulator would also add that if we wait and see, it could all be too late, and the world is already doomed. I'm exaggerating, obviously, but when should have we stepped in your opinion, or should we step in at all? Or are you really saying that AI is something that defies regulation in the first place?
I don't think it defies regulation. I think that, first of all, there are already a lot of laws on the books in the US and elsewhere that can address certain things. So as I understand it, the Copyright Office just published its first report about AI and IP related things, which says, oh, you know, digital replicas should be outlawed and blah, blah, blah. Okay. I've heard from sources that I trust that the Copyright Office initially said, we don't need new laws, right? The right of publicity and laws about regulating basically deceptive practices. There are already laws on the books that basically can be used to address some of the deep fake issues. And that would be something that you didn't need this extra thing for. I'm not going to say this is particularly effective today, but certainly the Federal Trade Commission has had, during the last 25 years or so, has had an important role in having listening sessions where they identify a set of questions that regulators are trying to figure out what to do anything about. And then they invite people, including the people who are unhappy with what the players in the market are doing now, and then people who are in that market, and have them come in and talk about what their concerns are. And then the FTC can basically take action if there is some deceptive or unfair trade practice that has been identified. So the FTC, for example, has identified a number of things that they call dark patterns, right? Ways in which some of these digital services manipulate people into signing up and then it's really hard to cancel, or that they engage in some manipulation. They have unfair terms. They change their terms too quickly. So when I signed up for it, this was the rule, and then the rule became X. Kind of watching what's going on the ground, and then deciding to regulate in response to that is, I think, an effective thing to do. So I actually am very pleased, again, with the Biden executive order, because it basically says develop standards, develop test protocols, develop reports about whether open versus closed is something that we should have a national policy on. We want this sector in health to focus on these risks. We want this sector in sort of the, let's say, the aerospace industry to be mindful of these risks. And then you kind of see, you know, do I already have a tool in my toolkit to deal with that, or do I need a new tool? And so I'm agnostic about the idea that maybe some regulation, special regulation is needed. But I think this kind of like you have to install a kill switch if it's a model of a certain size. That's just, I think, feeding into a kind of hysteria about, hell will take over and we won't have, we'll all get extinct because the AI system will decide to wipe us all out. I just think that is completely. Now the fact that some of the people who are computer science developing these things, some of them take that seriously. Okay, I would listen to that, but I would basically be focused more on what's going on in the near term and what kinds of things might we put in place that would avert some things that are actually foreseeable right now under the circumstances. So, can disinformation about elections, can that be regulated? Well, I think there are some laws already about manipulating election information.
Sure.
And I want to see the proof that that additional regulation is needed.
Yeah, there's a kind of comment. I mean, we are very critical perhaps right now at this moment about this AI Act, but I want to remind everyone of Martin's, if I may, observation that the EU is different from the US, perhaps in the sense that if the EU doesn't act, the member states might step in, and then you get this 27 member states, and I could say probably from experience, Germany would not wait too long to have a rather strange law quickly. And so I think the purpose, so the EU is a pretty different type of regulator, probably with a special purpose to harmonize, and perhaps also this coming quickly and early has something to do with integrating into markets at a very early stage to not then clear this mess up 20 years later. Like with the internet. So Article 17, it's still not achieved the harmonization.
Bad EU regulation is better than no regulation.
So
this is exactly the follow-up question.
I'm sorry.
But no, it's very good that you remind us of what Martin said in his keynote. That was a very good point. In a sense, what Martin said is the EU is doing the American big tech a favor by stepping in early, unifying these rules, and thereby preventing that Slovenia, Slovakia, and all the other countries and Germany have to set their own, or Italy set their own rules on AI.
But of course, in the US,
Somebody in the US thinks that they were done a favor. Okay.
No, but that's why we're saying this.
But in the US, there's state laws coming.
But you have to. But yeah, that's
not necessarily so different.
So indeed, you mentioned 700 state laws.
No, they're not 700 laws. There's 700 bills.
Well,
okay,
that's more than we have.
Isn't Colorado?
Legislators, AI. Need regulation. I'm going to pass a bill. I'm going to propose a bill. So they're mostly performative, okay? And the governor of Colorado issued a signing statement expressing a lot of reservations about the bill that was passed by that legislature. There is an enormous amount of pressure right now on Governor Newsom to veto 1047 because of the extremely strong opposition. And Fei Li is somebody that you might have heard of. She's a Stanford computer scientist, a really, really amazing person, a great person who believes in AI for the social good. I was watching her work really hard to persuade the governor to not support 1047. And the reason is because 1047, at least as she and others interpret it, would mean that open models wouldn't be possible. And for academic researchers and for research organizations such as the AI Institute, the Allen AI Institute in Seattle, they are developing open models, and they think that actually they're doing the world a favor by making some of these open models available so that academic researchers and others can build on it. Right now, for reasons which you were pointing out, is that the cost of development of these AI models and the amount of compute that you need to train them, that actually is a big barrier to entry. If you can get an open source model, then you can basically fine tune it for specific interests that you have, and to then make it more accessible and usable and so forth. So the academic research community is almost all really very skeptical and very concerned that there would be these consequences that that the people in the state legislature, they don't really understand this stuff so well. And there's actually a quote by one of the state legislators saying, you know, I don't know that much about AI. And I'm going like, well, maybe you shouldn't be passing laws if you don't understand what you're doing.
Or wouldn't it be better to have a federal law that preempts all that?
Yes, and that is another possibility. And I can imagine that that there are in certain sectors talk about doing some federal legislation that would have preemptive effects. Again, right now, the federal situation is pretty uncertain, so this isn't the time to do it either. Okay.
No, never a good time. But it's time for the floor, and I already see several hands there. Martin is first.
Thank you so much. This was fantastic. I have two comments, questions for Alex and Pam. So first, Pam, I mean, your observation, I think, and this is already what Bernt identified, I think your observation about sort of a slow legislature applies vis-a-vis the federal legislature, right? It does not define how the US states regulate. Just it's enough to look at the sort of a situation with respect to platforms to see the number of potentially unconstitutional laws, but a flurry of such laws that need to be sort of brought into the fold through the First Amendment types of challenges. So I think indeed there is a benefit to the federal legislation that makes a decision, even if the decision doesn't turn out to be the right one. I think one other thing that Bernt, I think, was hinting at, and it was actually articulated by a theorist of innovation called David Collingridge, if you're familiar with his Collingridge dilemma. It's a dilemma that essentially says you always have, as a legislature, whoever wants to control technology, a problem. If you act too early, you have very little information, but a lot of control. If you act late, you have a lot of information, but little control. And I think it makes a lot of sense that, for instance, with respect to, and this is where I would probably look at the challenge of AI versus the platform regulation in the late 90s differently, is it makes a lot of sense that there we made a choice of we're not going to regulate this. This is very close to civil liberties. We're actually going to regulate it to make it flourish through the liability exemptions, because civil liberties will be too impacted if we go strictly here with a strict liability. Well, here we're not talking about something that is as threatening to civil liberties. Yeah, we can make mistakes that can cost us productivity. But the worst thing that can happen is that the Europeans get it wrong. You guys get it right. And then if we are sensible enough, we'll just revise our approach. And we realize, okay, we actually made a mistake. These, AI-powered self-driving cars cannot be introduced to the European market. That seems like a pretty stupid thing to do. How about we change this, right? So I think it makes a lot of sense that for these two different technologies, we kind of on the spectrum of these Collingridge dilemma, we make a different trade-off. So I'm not defending necessarily the AI Act, but I'm saying I think I'm a little bit less disturbed. And I think the story of platform regulation actually isn't necessarily that we have thought that we made a mistake. In fact, the Commission in all its documents would say we did it right, but has come to time we have learned enough to control it more. So I don't think it's necessarily admitting mistake, which is why we have, we have preserved the liability exemptions. Which brings me to so what do you think about that? I'll be interested to hear your comment on this sort of a Collingridge dilemma. Which brings me to Alex. And again, I mean, we can also look at the AI Act, and I agree with you on the AI Act. I disagree, though, that DSA has the same attributes. I think most of the DSA is privately enforceable, with the exception where I think I agree with you is the risk management system, which I think it's more akin to the AI Act. But what if AI Act actually becomes a safe harbor for the industry? Because again, what is the starting position? If the starting position ends up being that the national courts impose strict liability on AI vendors or producers of AI technology, then this can actually turn out to be a safe harbor. And in a similar way as we have a safe harbor for the safety toys in a way, right? Because regulation becomes a way how to sort of do all these very complex assessments as to whether something is compliant or not. So I have no idea whether that can happen, but I'm just wondering, could that actually happen? That in a way, the compliance with something becomes a beneficial thing, right? In the long run. Just a thought.
So, you know, I haven't seen or heard a European official say, hey, the database directive was a mistake, that it was premised on an supportable economic interpretation. Again, I know that it was taken, that was initiated partly because of disharmony, but okay, it got adopted. People realize that it was ineffective and it's still on the books. Okay, now it gets cut back a little bit in terms of interpretation. And as was noted earlier today, if the data is AI generated, then it doesn't qualify for the database right. But that to me is the example of something where the Europeans didn't admit that they made a mistake and repeal it, or do a significant revision of it, at least as I understand it. So I don't think that it's very likely. Now, I think one of the things that can happen is that there are ambiguities in the AI Act. And so you can imagine that initially they're gonna turn that lever of the ambiguity up this way very strictly, and then if it turns out nobody's willing to play in your game, then you kind of like adjust that back. But that means that you're taking advantage of ambiguity as opposed to really thinking about what it is that you're trying to accomplish and making sure that you have the right mechanism in place. So, you know, it's unfortunate that this is a kind of another one of these transatlantic dialogues where we end up kind of starting off in this kind of pretty far away place, when it would be good if we could like get a little bit closer together. So maybe that will happen over time. I don't know, but that's my kind of response to it. I do think that it is very well intentioned, but you know, if I was advising an American company, I'd say, wait till you get to be as big as Microsoft before you try to enter the European market.
So can the AI Act be a safe harbor as regards strict liability, perhaps brought about by courts? If I understood you correctly, under German law, this wouldn't be possible. So strict liability is enumerative, needs a statute. Otherwise, you only have fault liability. And I don't know, I might assume that this is true in many other cases or countries. But what the AI Act preempts is strict legislative duties of AI providers going beyond what is in this act. So it will not be even more than that. But how can you be more comprehensive? As I tried to say, it's already covering everything, and also probably with the aim to prevent any kind of loophole where the Germans might jump in and then create a new Network Enforcement Act or something like that. And I would, if I may, also add that whether AI is not so much civil liberty related, I'm not that sure. Imagine that there is a powerful open AI system that really helps you to get informed very quickly and perhaps accurately, with the necessary skepticism that should be around. And if that is available in some countries, but not in the EU, because for whatever reason that provider doesn't want to be active here. If then information becomes digestible and available at other places, that might also become relevant not only for commercial purposes but also for possibly political information and other issues. So I think AI is too powerful a tool to dismiss this possibility.
I saw some more hands, Benjamin and then Bob.
I just want to support Martin and challenge the panel a bit, trying to take a regulatory stance. 3 points. First, I mean, it's a product liability question. So, for example, if an AI is employed, is used, and someone loses his or her job, or someone has to leave university without a degree because some AI detection software says someone was cheating, or someone isn't admitted to a master program, which just has occurred in Germany because some program says you were writing your letter with AI, and then the question is, did the company, did the developer establish due diligence? I mean, did they apply their due diligence care? And then a court would have to decide whether or which diligence standards would apply. And now we have the AI Act, and there's some very common sense stuff in there. I mean, they're saying if you're challenging the admissibility to a school or to a degree, then you must understand what actually happens there. So human oversight. I mean, you have to take care of your data. So if there are discriminatory issues, well, you have to solve them before you put it on the market. So what's bad about that? And then the second point I'm trying to make is a very civil law point, but I want to defend it as well. I mean, it's in our view, it should not be the courts deciding the most basic rules, but should be the legislature. So if there are like really important question, it should not be left to the courts, but to parliaments to decide on the liability standards or on the diligence standards. And yeah, let's leave it at that.
It's an interesting phenomenon, by the way, with the presence of an American commentator makes us love our EU law a lot more. Just an observation. This would be a different discussion without Professor Samuelson. Who would you like to respond? Alexander?
Both.
Both?
Go ahead.
Well, I disagree. Courts would also be able to establish such rules. So which diligence would be required? I mean, imagine we've done that throughout all the time, all through the Industrial Revolution and through the internet. I think there was no doomsday scenario as far as I can say. And then the parliament, well, that's precisely also my point. The commission is also not that very strong when it comes to, or is of limited, has not the same democratic legitimation like regular parliament, to phrase this moderately. And the same goes for these multi-stakeholder events, which are even less, I would say, democratically legitimate. So courts apply, and if the legislature finds this is outrageous, then repairs this mistake. And I don't see immediately why this case doesn't fall into the category that could be covered. But I think the EU is special in that it tries to cover as much ground as possible in an integrative fashion, and the agenda is that the digital realm is covered by EU law from day one.
So I want to just say something about adaptable regulation. And a good example of that in the United States is that after there had been some pretty bad cybersecurity breaches, the Federal Trade Commission did that kind of listening session and sessions and basically compiled information about what's going on and about what standards there were, what levels of kind of industry norms about what kind of cybersecurity should you put, in place if you are in this particular type of industry. And then if you didn't do that, if you didn't kind of comply with that industry norm, then the FTC would come after you for essentially an unfair or deceptive trade practice. And what that did is basically made everybody pay attention. And then as cybersecurity technologies improved, the standard that you had to meet basically went up. And so systems are more cyber secure today, partly because this kind of like, let's try to sort of understand what's going on inside the industry. Let's like figure out how responsible are they trying to be about safety and about trust. And then if the technology evolves in this particular way, maybe we kind of like see how it's doing and then take some measures if they're not complying with kind of industry norms. So I think that flexible type of regulation is something that might be a model for kind of how to adapt kind of the safety standards in the context of AI systems. And so I think it was a good idea for the AI Act to say, this is riskier than this. And, the ones that are riskier ought to have more responsibility than the ones that are like less risky. I mean, one of the first AI systems that was deployed in the United States was one that I think has no risk at all. And that is the technology to read mail addresses so that the Postal Service basically could more efficiently process things and get things to this zip code, that zip code, this. So that was an artificial intelligence system. It worked, okay? And it improved productivity in the postal system, just like that. So that's obviously different than the kind of AI system that we have that would essentially control all of the medical records that are kind of in hospitals, right? That's a very different kind of situation.
Bob Blasco.
This is my spouse, by the way.
Yes, Bob Glushko, Cognitive Science, Berkeley, and Pam Samuelson, driver in ballet. I have two provocations rather than questions. The first provocation is that I've heard this afternoon the word model, developer, provider, and platform treated as sort of synonyms in the sort of very broad way in opposition to this notion of some kind of user. And yet I can argue that anytime a user is able to tweak a model to make it more domain specific or task specific, they become a platform or a provider. So the categories are totally broken. Okay, that's the first observation. Second observation is that I have not heard the word self-regulation at all today. And that's interesting because, in fact, that's a standard way of making things work, especially if you have a naive view of what a standard is. Because I spent most of my time in Silicon Valley playing standards games, pretending to make a standard, when in fact I was doing self-serving work by taking my preferred solutions, volunteering to host the standards meeting, getting everyone else to sign onto my team, which is why we have the Android standard and the Apple standard and the Windows standard. Are these standards, or are they basically self-dealing cartels? All right, so I think I wouldn't say my wife is naive about standard, but she has a simplistic view, optimistic view of standards. And in general, I'm just amused that we haven't talked about this sort of, let the company, if I were advising OpenAI, I'd say, create a standards organization and push your good stuff, right, so you can control the world the way you want the world to go. So that's what I do.
Well, I will respond to that. There is actually another slide. I was trying to keep that talk really slim, but Bob and I both have had conversations at some length about ways in which dominant players can use the standard setting process, particularly so the international ones, which require you to go to Dubai for this meeting, and then next to Brussels, and then to Sydney for the next meeting. And civil society people can't really do that. On the other hand, I do think that that the Internet Society and Internet standards and the process of technologist involvement in standard setting has actually been a pretty successful model, at least for Internet-based standards. And the question is, you know, would the standards for AI systems be more like the Internet Society, or will they be more like the sort of capture that Bob is talking about? And I think it's too early to know. I do think it's there is a criticism I've heard, I've read about in terms of the AI Act, which is a criticism of the Commission and the Parliament basically handing off the regulatory role of saying, you know, what should the standard be to the standard setting organizations, and then saying, as long as it got adopted by a standard setting body, then as long as you comply with it, you're golden, right? You got a safe harbor. And that doesn't, that from the standpoint of some people who think that the Commission and the Parliament and so forth are supposed to be basically making the rules that actually govern, then handing that off to standard setting is actually basically delegating to private entities the legislative power that they should be exercising. So I'm not going to go there, but I have understood that some Europeans feel that that actually is a mistake.
Alexander, this touches upon your talk, and I'm sure you have.
I have a final competition thing.
I'm sure.
Yeah, so self-regulation, I actually did not speak. I did not use that word because it's rather now called or hybrid regulation, because the Commission is very much involved in it. So there is my understanding, there's always someone from the Commission in the room that follows the debates and encourages, well, not always perhaps in every debate, but encourages and initiates this. So we've moved from self-regulation, which is then adopted, to co-regulation. And I have to admit, I would have to look, I mean, the standards in this Article 56 have a strong role, but I would have to check again whether there is not a backdoor for the Commission to say, no, the standard is problematic and has to be adopted or something like that. But I have to say that I would have to check that again. Martin perhaps knows even.
I think this all comes from the new approach for the product safety.
Would you please put it?
So I don't exactly know all the details, but the genesis is that comes from the new approach adopted for the product safety, where we actually have some regulation on the participation of third parties in the standard setting, but it's still the same problem. We did a big empirical study on standard setting, and it's exactly as described, all the problems with the capture and problem for the civil society. But indeed, that the criticism is there, that rather than the problem that it's undemocratic because it delegates it to the Commission, it's rather problematic because it delegates maybe stuff that it's very much different from, regulating how safe a toy looks like, much more, consequential stuff to a standard setting body that has an even lower legitimacy than the Commission itself. And therefore, at least for the typical standards that we call the attached standards, in the product safety regulation, it's actually as consequential that we have accepted that a Court of Justice has a jurisdiction to interpret the standards, including their compliance with the fundamental rights. So we have cases where the Court of Justice is literally interpreting these standards because they are attached to the legislation. They're given legal effect through EU legislation. So strictly speaking, Court of Justice will have jurisdiction over all these standards and can read fundamental rights into them. But I think that concern about the legitimacy and the scope of what the standard setting is doing is a pretty big one. So I certainly count myself on that list, Pam.
Did you have anything to add?
Yeah,
Yes.
very quickly wanted to take another crack at your question, because I think there's one important point I left out. Clearly, the competition authorities around the world have raised concerns about conduct and transactions that they think exist or might exist that could potentially disrupt, that could prevent the disruption. And clearly, in my view, AI technologies and those who develop and deploy them could potentially significantly undertake disruption and transform the competitive landscape of many digital markets. But that's never been, but the conduct and transactions that competition authorities have expressed concerns about have never been vetted, because in particular the merger control legislation doesn't allow them to. So it's never been shown that those concerns are valid. And so it's quite possible that they're not valid, and that if if they were to, that there really is no basis for those concerns. I just wanted to ensure that I wrapped that circle up. I don't have the facts in order to assess that.
Speaking of wrapping up, time's almost up. It would be a sin to go over time with this kind of weather, despite the fact that we have a stellar panel and a brilliant conference running. There's about 1 minute left, and I was told that Torger was going to say something at the very end. Is that correct?
I was.
Then I propose that we give our panel a big hand.